Court officer. Court officer. We'll see. Give it. Yes. Wednesday. Not granted. Give it. Yes. Kodi memo kodi. Further hearing. 12th. Give it. Wait. Kodi. CRP. Friday. Parvala. Friday kodi. CRP ಯಾವತ್ತು so what sir? ಒಂದು ವಾರದಲ್ಲಿ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಏಜ್ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ವೇಟ್ ಸರ್. ನೋ ಪ್ರಾಬ್ಲಮ್. ಎಸ್. ಸೇಲ್ ಅಂಡ್ ಆಕ್ಷನ್ ಇಲ್ಲಿ CMCPC-ನಾ vacate ಕೊಡಿ. ವಿಲ್ ಸಿ. ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಏನು CRP ಡೇ ಬರುತ್ತೆ ಬಿಡಿ. CRP ದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. CRP ಡೇ ಬರುತ್ತೆ. ಗಿವ್ ಆಲ್ CRPs. At what stage did you file it? At what stage did you file it? Simple question, simple answer. Give it. Yes. We'll see. Next Wednesday. An urgency illa there. Only to drag the proceedings, nothing else. We'll see. We'll see. Yes. Wednesday. Parvala. Next Monday. Parvala, sir. Yes. No problem. Give it, sir. No. Yes. We'll come on Wednesday or Friday. Give it. SLP. $230. Yes. GMR. Yes. Yeah. Which? That was not brought to my notice. You appear for the respondent. Okay. Heard. Then can it come on Thursday? Thursday it will come. Yes. Then wife and husband are separate properties, huh? Kodi. Wednesday. GMCPC memo ella kodi sir. Give it, sir. Should be listed. Yeah, what is that? It won't be listed like that. An urgency. When? 2:30 totally. Thursday. Yes. Next. Yes. Then Google the password ಮಾಡಿ. Yes. What's the problem? ಅದೇ ಎಲ್ಲಾರ್ದು additions.
There are 3 errors in that I pointed out to my learned friend.
And rectify those errors. File another memo.
But she has
and also indicated the URLs.
She has now given it to me. The Lordship will
Wednesday.
Please.
Give it. Wednesday. Yes. Next.
Great.
Preliminary hearing, still number 2.
Adi Narayan will issue notice in the connected matter. 16 ವರ್ಷ entertain ಮಾಡಕ್ಕೆ.
I appear for the respondent.
We'll see. We'll direct notice on this connected matter. Connected matter ಕೊಡಿ. ನೆಕ್ಸ್ಟ್ ನೀವು ನೋಟಿಸ್ ತಗೊಂಡ್ಬಿಡಿ. ಇದರಲ್ಲಿ ತಹಶೀಲ್ದಾರ್ಗೆ ಸುಮ್ಮನೆ ಇರಕ್ ಆಗಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಸುಮ್ಮನೆ ಇರಕ್ಕೆ. ಸುಮ್ನೆ ಏನು ಇಲ್ಲದೆ ರೈಟ್ ಕ್ರಿಯೇಟ್ ಮಾಡೋದು. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ಯಾಕೆ?
ಬೇರೆಯವ್ರಿಗಾಗಿಲ್ಲ.
ರಾಂಗ್ ಆಗಿ ಯಾಕೆ ಕೊಡ್ಬೇಕಾಗಿತ್ತು? We will observe against the Tahsil. That is exactly why I have tagged this petition here. Learned AGA is directed to AGA, na? AGA is directed, HCGP is directed to accept notice for the respondents. Copy idea? Copy idea? Copy kodi. Counsel for the petitioner to serve set of papers upon the aforesaid counsel forthwith. List the matter on 20th. ಏನ್ ಕೇಸ್ ಇಲ್ಲ, ಕೇಳಕ್ಕಷ್ಟೇ.
3.
Video conf will dispose it, madam. Permitting you to, under the rules. Why, sir? Why, sir? Petitioner is not asking to be allowed. No, petition is filed only for video conferencing evidence. What is abnormal about this?
Both are residents of UK. Subsequently, the address is also meant to be. I am not directly any agreement with the plaintiff. Your can be seen. Non-prosecution case to be filed. Now, again filing in a demo, not an application before the court, seeking to reduce evidence to
VC.
He is claiming that he is a resident of UK. Now he filed an application which says that he is a resident of Dubai. Again, his application file itself shows that he's come down to Delhi for seducing and filing an application.
What? For what?
Delhi to file an application. Where is it executed? Page number 2012. This is executed. The verifying affidavit is executed daily. Document itself verification. And moreover, the payment itself is wrong. 50 number of documents shows that it's a bogus transaction.
That you contest, sir.
I should be given opportunity.
For what? Opportunity for what? You want to file objections to this?
Yes, sir.
All.
Application they don't file because I filed an application before the court.
All right. You want to file your objections? File your objections. I'll give you a week's time. Let him file his object. Whatever you want to print, you print. All right. You didn't ask that at the outset. I would have granted. Correct, but he wants to set up something. Yes, ma'am. No problem. Yes. That is fine. Shall we record it?
Maybe the week's time, not in a day's time, at least we should know what happened.
No. He's not asking on a day-to-day basis. It should be over. Then fine. We'll dispose it on that ground instead of this. Can that be? Then that will be better. I'll take this on Wednesday. Both of you want to file a memo or undertake whatever it is. I'll record that and close this. That will be better. All right. That for nothing. For this is only to dispose it with dates. That's all. Wednesday in the same stage. Yes. I will not record anything. Wednesday you get it. Yes.
4.
That is, we'll issue notice. Yes. It's an order 1.5 years old. Yes. Emergent notice to the respondents. Respondents, petitioner is at liberty to serve on the counsel who represented the respondent in the trial proceedings, put up immediately after service of notice. Next.
5,
Yes, Trivikram.
Please, my lords, I am the plaintiff before the court below, my lords.
Both
My-
courts against you.
Both the courts, please, my lords.
Yes, sir.
My lords, I am only seeking for a limited indulgence, my lord. Here, in spite of the documents being produced, my lord, to show that I am in possession since last 21 years. Lords, my interim relief has not been considered, my lords, by the courts below. By limited indulgence, my lord, let them not
1,
dismiss us,
2,
my
3.
lords.
Emergent notice to the respondents, petitioner, apart from taking out steps, shall also serve on the counsel who represented the respondent in the trial proceedings. List the matter on last week, Monday.
Lords, till such time,
That
my lords,
is 1
let
minute,
them
sir.
not- Please.
30th, list the matter on 30th in preliminary hearing till such time status quo, the property / possession be maintained by the parties. Next.
So grateful, my lord, so great.
6,
Pass over.
7,
Divergent. Yes. ಇನ್ನ 3 ಇದೆಯಾ? ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರ? Will say status quo. Who is in possession, sir? What is the suit for? Partition. Partition andre? All right. What is the prayer in the partition suit? ಅಷ್ಟೇ ಅಲ್ಲ, ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಏನು ಕೇಳಿಲ್ವಾ? Then there is definitely a dispute with regard to possession. If sale deed has taken place 1 month before the partition, ಈಗ ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಲ್ವಾ, ಸ್ಟೇಟಸ್ ಕೋ ಮೇಂಟೈನ್ ಮಾಡಿ. ಯಾಕೆ ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಲ್ಲ, ವೈ ವರಿ? ನೋ, ಆಸ್ ಆನ್ ಟುಡೇ ಇಫ್ ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್, ಬಿ ಇನ್ ಪೊಸಿಷನ್. ಅಲ್ಲ, ಯು ಆರ್ ಇನ್ ಪೊಸಿಷನ್ ತಾನೆ. ನಿಮ್ಮ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ, ಕರೆಕ್ಟಾ? No problem. Your contention is that you are in possession and entitled to an injunction. No problem. You continue to be in possession. Hello, you continue to be in possession. No problem. You continue to be in possession. ಯಾರು ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಸರ್? ಅಲ್ಲ, ಅದು ಬೇರೆ. ಈಗ ನೀವು ಪೊಸಿಷನ್ ಇದ್ದೀರಲ್ವಾ? ನಿಮ್ ಪೊಸಿಷನ್ ಇಂಟರ್ಫಿಯರ್ ಆಗಲ್ಲ ಅವರು. ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ಮೇಲೆ ದೇ ವಿಲ್ ನಾಟ್ ಇಂಟರ್ಫಿಯರ್ ವಿತ್ ಪೊಸಿಷನ್. ವೈ ಆರ್ ಯು ಅಫ್ರೇಡ್ ಆಫ್ ಅ ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್? ಅಂದ್ರೆ ಸ್ಟೇಟಸ್ ಕೋ ಅಂದ್ರೆ ಕೀಪ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ಅಂತನಾ? ಅದಂಗ. Purchaser of the property when? 2008. All right. From whose hands? 23/8/2008. This sale deed is questioned? Not questioned. Yes, sir. Have you, who has challenged the sale deed? Anybody has challenged the sale deed? That is between members of the family, sir. He is a purchaser from one of the members of the family. No, that would be a subject matter of the final decree, whether it is binding or not. To protect the status quo, if he has purchased the property in 2008 from one of the members of the family and he is in possession, he will be protected. What is wrong with, where is the order of the first appellate court?
They say in the second step, some of the portion of the property is settled. Excluding us.
In which you are in possession.
It's a different property.
ಅದಕ್ಕೂ ನಿಮಗೂ ಸಂಬಂಧ ಇಲ್ಲ ಅಲ್ಲ, ಅದಕ್ಕೂ ನಿಮಗೂ ಸಂಬಂಧ ಇಲ್ವಾ?
This shows they want money out of the sale on the property. They issued a close of the case.
ಎಲ್ಲಿದ್ ಪ್ರಾಪರ್ಟಿ ಇದು? ಎಸ್ ಸರ್.
So the 2 crores they have issued and settled the matter before the court.
Where is the order of the first appellate court? Where is the order in OS observation that you are in possession of the property? In the OS. ಅದೇ ಎಲ್ಲಿದೆ? ಆಮೇಲೆ ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಯು ಹ್ಯಾವ್ ನಾಟ್ ಶೋನ್. ಎಲ್ಲಿ ಹೇಳಿದ್ರೆ? Correct, rejects the application. Yes, sir. Yes. OS 1740 of 2008 ಯಾವ the partition.
But further reading HTMP jail will stand. Further reading contact.
Yes. Yes. Correct. That is set at not appropriately at paragraph 10 and 11 of the first appellate court's order. Yes, portion of the property. All right. Yes. We'll see. Hmm.
Not relying, it's not because one account is open, it has not grown family, not the influence is not the influence, not
You will permit for that?
sorry, there was no
Huh? There was no? ಏನು ಇಲ್ವಾ ಅಲ್ಲಿ? Not with you. All right, the first appellate court is, order is correct. Anything else, sir? That is not the subject matter of any suit. It is pending. No. Nothing will happen. Nothing will happen. Yes.
You will not do anything, not which is prejudicial to the interest of the other side. Let them do also the not similarly, let them also perform those acts. Because 2008 till 2023, there was absolutely no dispute. 2023 cannot come the first time, not thereby a suit. Therefore, not easy model is granted by this law. It will certainly affect
No, it's already granted by the first appellate court. I will not interfere.
as otherwise not virtually I'll not be allowed to go into my own.
He is in possession of the property, sir. No doubt. Now you are only telling that you want to get into the property for the purpose of performance of rights of the person who was buried in the tomb. So you are not in possession of the property. Yes.
Before the trial court was not disputed by the other side.
I am sorry.
Photographs not clearly disclosed, not the extensive operation that was being carried out, and your functions not that have been which are the performed.
No.
Those rooms. Not in fact not with these very very at least came to my knowledge. Not I challenge the state before the Assistant Commission. Not at the we have not the time not immediately the state. Subsequently, the Assistant Commissioner was being rejected by appeal. Thereafter, not it went up with revision. The revision not Deputy Commissioner paid to grant an interim order. I approached this on the report and granted an interim.
Where is that? Which page? Page. That is against you. Where is the order of this court? No, sir. Not a case for interference. No. Then you will. He is in possession. You can't disturb his possession. What is the suit filed by you for?
Who sued for permanent injunction?
Yes, sir.
No, trial court records the finding. I am in possession. Paragraph number 15.
No. Even his statement is that he wants to perform the rights at the tombs that are present in the property. All that is a matter of the suit, sir. Yes.
All the five suits not are together.
ಈಗ ಸೇಮ್ ಆರ್ಡರ್ ಇಸ್ ಪಾಸ್ಟ್ ಎಲ್ಲ
Please.
ಯಾವ್ದು ಕೊಡಿ ಅಂತ ಕೇಳ್ತಾ ಇದೀನಲ್ಲ, ನಂಬರ್ ಕೊಡಿ ಎಲ್ಲದರದ್ದು.
ನಂಬರ್ ನಾನು ಕೇವೇಟ್ ಹಾಕಿದ್ದೀನಿ, ನನಗೆ ಕಾಪಿ ಸರ್ವಿಸ್ ಮಾಡಿಲ್ಲ ಅವ್ರು
ಇದನ್ನ
ಇದರಲ್ಲಿ ಇನ್ನೊಂದರಲ್ಲಿ
ಅಂದ್ರೆ ಕೊಡಿ, ನಂಬರ್ಸ್ ಕೊಡಿ ಎಲ್ಲ. ವಿಲ್ ಟೇಕ್ ದಮ್ ಆಲ್ ಟುಗೆದರ್ ಮಂಡೇ ನೆಕ್ಸ್ಟ್, ಬಟ್ ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಇಂಟರ್ಫಿರೆನ್ಸ್. Yes. Tag this petition along with so and so. List them all on Monday. Next. Yes. Next.
8.
Let's seek for short accommodation.
Police protection. Why police injunction is in your favor?
Yes, my lord.
Then why?
That's a senior work. As we have preferred an MA, my lord.
Who has preferred?
We have preferred.
So what?
That's it.
Another order stay idea.
No, my lord.
Matte?
No interview.
Police protection they have to grant. If there's an injunction order, why did the court refuse it? You are not in possession. They have opposed, yes. Anyway, order of injunction is in your favor. What is the stage where ML ಏನಾಗಿದೆ?
It's posted for arguments. It's on coming up on 11th.
When?
Pass on the.
11th. List this matter on Friday. List the matter on Friday. In the event the arguments would not conclude, an order or an order would be passed in MA so and so, the court would hear the subject petition on its merit. Yes, next. Friday.
9.
Yes. Three months. Saka, the petitioner is before this court seeking the following prayer. The suit is of the year. The learned counsel for the petitioner submits that the matter has been after arguments posted for what? The matter is now at the stage of final arguments. Therefore, if 2 weeks' time is granted, the suit could be concluded. The suit itself could be concluded. The prayer of the petitioner being innocuous, and also the fact that the petitioner has sought in his prayer that the suit be disposed with the direction be issued to the concerned court to dispose the suit within 3 months. In the light of the matter being at the stage of arguments, I deem it appropriate to direct the concerned court to dispose the suit within an outer limit of 8 weeks, if not earlier. You carry 3 months, if not ordered accordingly. Yes, next. For a while, if not earlier, next.
10.
This is a suit filed by the defendant hearing for fraudulent injunction.
TI is set aside by First Appellate Court. Yes.
The petitioner here, earlier there was a suit filed in year 89 by the mother of the plaintiff, wherein our father was declared as the owner of the property as against.
Emergent notice to the respondent. The subject petition is preferred by the defendant, who had you are the defendant, is it?
Defendant.
The plaintiff, an application filed under Order 39, Rule 1 by the plaintiff was turned down by the trial court, which was challenged by the plaintiff before the First Appellate Court. The First Appellate Court, in terms of its order dated 15th April 2024, has granted temporary injunction in favor of the plaintiff. The defendant calls in question the same. The observation in the order is that both the parties are disputing about the title and possession. If the injunction order is granted in favor of the respondents, then the respondents may interfere with the suit scheduled property. In the light of the said finding, I deem it appropriate to direct the parties to maintain status quo till the next date of hearing, which would mean that they would not interfere with the possession of each of the parties, whoever is in possession of. Next. Hey, why?
There are seven door numbers where the respondent is asking for. Out of which 3 door numbers, only 3 door numbers are in my possession. And tenants are already occupied in that door numbers from nearly 10 to 15 years.
You want time?
If you notice a date, I may be permitted to.
You don't want this order.
This order, with respect to 3 door numbers, for the reason of because it's rainy season, more door number entirely water is entering into the.
All right, emergent notice returnable, the order everybody. Emergent notice returnable by 23rd, list on 23rd. Petitioner is at liberty to serve on the counsel who represented the plaintiffs before the concerned court. Next.
11.
The petitioner is before this court seeking the following prayer. The prayer of the defendant petitioner is expeditious disposal of the suit, which is of the year 2014. In the light of the fact that the prayer being innocuous and the suit were languishing in the concerned court for over 11 years today, I deem it appropriate to direct the concerned court to conclude the proceedings / suit within an outer limit of 4 months from the date of receipt of the copy of the order in accordance with law, if not earlier ordered according. Next.
12,
Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the plaintiffs before the concerned court, list the matter on 25th till such time further proceedings in OS 577 of 2014 shall remain stayed. Next.
13,
We have the advocate for the respondent.
12A not compliant.
No, the issue of law is left open, Cyber
Kodi.
to be decided by the Supreme Court. In the meantime,
Patel
mediation to be
Engineering, Patel
permitted.
Engineering, it is left open.
Patel automation has been carried to be reconsidered.
Where is it?
My lord, I take my lord directly. Page 19, page 20 is the
By the Supreme Court?
by the Supreme Court. The question, because on the basis of Patel automation, the underlying judgment was in favor of
Page 19.
page 20. The question that requires consideration by this court is whether due to non-compliance with section 12A of the Commercial Courts Act 2015, a suit should be dismissed under order 7 rule 11 of the CPC, or whether it should be kept in abeyance, directing the parties to first explore the possibility of settlement by instituting mediation. In the meanwhile, the petitioner, Novenko so and so, will move a letter before the mediation center, which is exactly what the trial court has done in our case also. Underlying judgment which came up for consideration before the Honorable Supreme Court relied on Patel automation. That is, my lord will see.
But is the Himachal Pradesh.
Himachal Pradesh. Himachal Pradesh relied on Patel automation at ink page 9, para 11. And the Supreme Court said, no, we will reconsider, because in a prior decision, my lord, not in my hands right now, Yamini Manohar, there too the Supreme Court deferred from Patel automation. Yeah.
Which is that?
Court
Supreme
puts
Court differs from Patel.
From Patel automation.
Patil, yes. Good.
Patel automation. Yamini Manohar. Where they said that Patel automation does not consider very clearly in cases where paragraph, my lord, I'll give that. One second. This I have on. Yamini Manohar, paragraph 10. We are of the opinion that when a plaint is filed under the Commercial Courts Act with a prayer for an urgent interim relief, the Commercial Court should examine the nature and subject matter of the suit, the cause of action, and the prayer for interim relief. The prayer for urgent interim relief should not be a disguise or mask to wriggle out and get over the section 12A. The facts and circumstances of the case have to be considered holistically from the standpoint of the plaintiff. Non-grant of interim relief at the ad interim stage when the plaint is taken up for registration, admission, and examination will not justify dismissal of the commercial suit under Order 7 Rule 11. At times, interim relief is granted after issuance of notice, nor can the suit be dismissed under Order 7 Rule 11 because interim relief post the argument is denied on merits and on examination of the three principles, namely so and so.
That's all right. Come to para 11.
Para 11. Para 12, my lord, para 11 I'll read, but para 12 is the finding.
Words complete and urgent so and so with reference to the suit, the suggested suit.
The proposition that the commercial court, para 11, my lord, the proposition that the commercial courts do have a role, albeit a limited one, should be accepted. Otherwise, it would be up to the plaintiff alone to decide whether to resort to the procedure under 12A of the CC Act. And an absolute and unfettered right approach is not justified if the pre-institution mediation under 12A is mandatory, as held by this court in Patel automation.
Yes.
The words contemplate any urgent relief in section 12A1 of the Commercial Courts Act with reference to the suit should be read as conferring power on the court to be satisfied.
Yes, sir.
But what they did is trying to reconcile Patel automation and Yamini Manohar.
This is also reconsidered. Kodi.
After that, only, this is,
After that, either.
no. The decision of the Honorable Supreme Court, which I
No,
showed,
Yamini Manohar, give that, sir.
is after Dhanbad. Dhanbad was earlier. Dhanbad, my lord, considered case of bifurcation that came up in Patel automation. prior to partial automation, post
Paragraph.
partial automation.
Paragraph 52. Now, see.
D and E may also be noticed. Basically, partial automation said that suits that have been filed after 20th August 2022 will suffer the rigor of 711. Supreme Court says we'll reconsider.
It is after the cutoff as by the, in partial automation.
And in the facts of our case, parties have already spent more than 3 months attempting settlement during the pendency of the suit.
But this is the latest.
Well, no. May 15, 2025 is Dhanbad, but what the Supreme Court has, May 15.
Yamini is 23, sir.
No, I'm not referring to Yamini, my lord. I'm
Then
referring
what?
to the one in the memo that I gave.
February.
That is February 2025, but they said we'll keep the issue open. In Dhanbad, this was
Issue,
not
nothing
pointed
is
out.
kept open by the subsequent judgment.
In Dhanbad, the fact that the Supreme Court said that we will keep the issue open for
So
reconsideration.
it is already here, sir. Subsequent, May 15, 2025.
May I explain? May I explain?
Yes, sir.
Partial automation held the field. Himachal Pradesh said that we will follow partial automation.
Correct.
Honorable Supreme Court said no, we want to reconsider partial automation.
That is in February 2025.
That is where the issue rested. That reconsideration has not yet happened.
No problem. There is already a consideration by another bench of the apex court. You will follow the later judgment law. You know very well subsequent judgment would prevail over the earlier of the same strength.
That's right.
Yes, sir.
What Dhanbad also says is only that post partial automation, the suit needs to be rejected.
All right.
But in cases where the suits do not contemplate urgent interim relief.
Very clear.
But in the
7
facts
to
of our
20,
case-
7 to 2025 is an order which says it should be kept open or whatever reconsidered. That's all. It's a daily order. This is a judgment rendered on complete narration of facts and spectrum of the law.
This also, Dhanbad does not address a situation where suits, where that exception that had to be taken care of in partial automation is
The
not taken care
conclusion
of.
is very clear, sir. Para 62.
No, no, Para 62.
Yes,
My
sir.
lord may see subpara D and E.
Yes, no problem.
A suit which contemplates an urgent interim relief may be filed under the 2015 Act without first resorting to
Come to
mediation.
G and H, sir.
Courts must also be wary of the fact that there is no finding on whether my urgent relief, interim relief that I'm seeking in the suit is a mask, is a disguise, or is a reality, is a requirement. The facts of this case, my lord, I am the landlord, is a defaulting tenant. My interim relief that I'm seeking is for deposit of the interim rent because there is no dispute.
Right, fit case for mediation under 12A.
We have already attempted. My lord will see the order sheet.
Where is the attempt?
My lord, I'll demonstrate. From the order sheet itself, my lord. I'll demonstrate.
Page.
One second. My lord, see.
Where are the 12A proceedings?
My lord, not the attempt at page 40.
12A, na?
40.
12A proceedings are
Not
just
12.
like that mediation.
Just like that.
Just like that.
Well, the fact of the matter is that in principle, parties have attempted mediation. Now, all that the defaulting tenant is trying to do is take advantage of a technicality.
Not technicalities, sir, jurisdictional issue. Without 12A, you can't
But it is
institute a
not.
suit unless
With-
you show urgency. He's
Sir,
a tenant, you're a landlord. What
I will not
urgency
labor
now?
a point unless necessary. Just this consideration, and then my lord, I'm in my lord's hands. The trial court, while deciding this, has not contemplated the requirement that the suit
ಈಗ-
contemplates an interim relief.
All right, 12A proceedings ನೀವು ಸೆಟಲ್ ಮಾಡ್ತೀರಾ?
ಇವಾಗಲೂ
ಬಿಡಲ್ವಾ?
ಆಯ್ತು ಮತ್ತೆ then
ನಿಮಗೇನು ಹಣ ಕೊಡ್ಬೇಕು ಟೆನೆಂಟಿಗೆ? 4 crores. Why did you invest in a tenanted premises? Well, lease agreement ಎಲ್ಲಿವರೆಗಿತ್ತು? ಎಲ್ಲಿದೆ? ಎಲ್ಲಿವರೆಗಿದೆ?
lease agreement was right.
ಅದು ಕಂಟಿನ್ಯೂ ಅಂದ್ರೆ
2029, my lord.
2029.
2029, but there is default from the beginning. The lease agreement period was from
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ ಈಗ?
arrears, my lord. At page 22, arrears are 1 crore and 28. Page
Crore and
20.
28 lakhs.
Crore and 28 lakhs.
My lord, I have invested, my lord, original landlord passed away. We have given, my lord, by way of loan, my lord, to him.
ಇವ್ರು ಯಾರು?
Why?
Yes, sir.
But is there other way? Even now, if you are sent to mediation, I am told to comply with 12A. The compliance with 12A is subject to the exception that there is an application for interim relief. Partial automation is not is not a complete bar to the
Now,
institution of a suit.
you are the plaintiff.
I am the plaintiff. I filed a suit in the regular court. In regular court, we have spent more than 90 days attempting mediation. That cost.
What is it?
Well, that's what I'm pointing out.
Oh, no,
At
that
page
ನೀವು
40.
ಮಾತಾಡ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ.
At page, no, it's not.
Proceedings under section 12
No,
is.
no. In the regular trial court, we spent 90 days in mediation. That did not work out.
Where did you spend in mediation?
In the regular trial court, not in the commercial court. That's what I'm pointing on, my lord, page 40.
Page 40.
40. During the pendency of the suit OS 245, prior to it being transferred to commercial court, from 9th January 2024 to 22nd April
Time for
2020.
settlement.
Yes, my lord, 90 days, which is what is contemplated under 12A.
ಈಗ ಅರಿಯರ್ಸ್ ಯಾವಾಗ ಕ್ಲಿಯರ್ ಮಾಡ್ತೀರಾ? ಯಾರಿಗೆ ಬರ್ಬೇಕು? ಯಾಕೆ ನೀವು ಬಿಟ್ಟೋಗ್ತಾ ಇದ್ದೀರಾ? ಮತ್ತೆ 29 ವರೆಗೂ ಲೀಸ್ ಇದೆ
And
ಅಲ್ವಾ?
they're still in possession.
2029 ವರೆಗೂ ಲೀಸ್ ಇದೆ. So you are staying in the property. So rent ಕೊಡ್ಬೇಕಾಗಿಲ್ವಾ? ನಿಮಗೆ ಯಾವ ದುಡ್ಡು ಬರ್ಬೇಕು?
That was the understanding.
ಹಾ.
Our landlord, we have given investment more than 4 crores by given.
You are staying in that property and you invested for yourself. Then
Renovation.
renovation of what?
That bar and restaurant.
Counterclaim illa.
Bar and restaurant.
And counterclaim illa. This is just a defense that is being raised.
ಇದು ಮೊನ್ನೆ ಬಂದಿತ್ತು.
ಸಾಲ ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್? ಎಲ್ಲಿದೆ? Where is it, sir? Government ಎಲ್ಲಿದೆ ಸಾಲ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ? ಎಲ್ಲಿ ಸರ್? ಸಾಲ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದೆ? ನೀವು ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ನಿಮ್ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ನಡ್ಸಕ್ ಅದೇನ್ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ನಡೆಸಿದ್ರೆ ರೆಂಟ್ ಮರ್ತೋಗುತ್ತಾ? ಮತ್ತೆ
Extension of parole.
why did you stop paying?
ನನ್ನ ಪ್ರಕಾರ ಬಂದಿತ್ತು ಅನ್ಸುತ್ತೆ.
Page 28.
List of the 4 weeks order.
ಯಾಕೆ ಓನರ್ ವೈಫ್ ಬಂದ್ರೆ ಪೇ ಮಾಡಬಾರ್ದು ಅಂತಿದೆ? ಮತ್ತೆ
5-6 ಅಲ್ಲ?
Our ತಗೊಂಡಿಲ್ಲ, because my lord, we have paid him, my lord, and we will produce material.
ಈಗ ನೀವು ಹಸ್ಬೆಂಡ್ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಗೊತ್ತಿಲ್ಲ, ರೆಂಟ್ ಅಂತೂ ಕೊಡ್ಬೇಕಾ? ಎಷ್ಟು ರೆಂಟ್ ಮಂತ್ಲಿ? 1,38,00,000
2 lakhs.
ರೆಂಟೇ ಕೊಟ್ಟಿಲ್ಲ ನೀವು.
2 lakhs.
ಬೇರೆ ಲೀಸ್ ಅಗ್ರಿಮೆಂಟ್ ಇದೆಯಾ ಅದೆಲ್ಲ? ರೆಂಟ್ ಕೊಡಬಾರ್ದು ಅಂತಿದ್ಯಾ? ಮತ್ತೆ ನಿಮ್ಮ ಬರೋ ಹಣ 29ರಲ್ಲಿ, ಈಗ ಸೆಟ್ ಆಫ್ ಎಲ್ಲಿಂದ ಬರುತ್ತೆ?
When we enter the property, we have invested the amount and renovated
ಆಯ್ತು.
by investing.
That is for your business you have done, sir.
Personal ಏನು ಕೊಡ್ತೇವೆ, invest ಮಾಡಿ.
Yes. Anyways, we will send it for 12A. They have instituted a commercial OS.
Very well. So long as the suit is kept in abeyance and we have to undergo
That suit
12A.
will be kept in abeyance, commercial court
That
will.
is what the trial court has said. My lord, look at the impugned order at page.
So it has sent it to the commercial court.
Yes, my lord. The suit got transferred to commercial court.
Ah.
In the commercial court, an IA came to be filed for rejection of the plaint. My lord, you see page 48 is the IA. And the impugned order, which begins at page 55,
Yes, sir.
page 63, he says that the suit must be.
Court ಅಲ್ಲಿ reach ಆಗ್ತಾ ಇದೆಯಾ? ಆಯ್ತು ಸರಿ.
Trial court has done exactly what has fallen from this honorable court. Let the suit remain pending. If one more exercise of mediation has to be done, we don't mind. We want the money and we want the property back.
Order 7 rule 11 ಬರಲ್ಲ, 12A I will send.
Perfect, sir. Perfect.
Rejection of plaint ಮತ್ತೆ ಹಾಕೋದು after 12A. 12A ಅಲ್ಲಿ settle ಆದ್ರೆ what's it?
No difficulty, my lord. Where am I shying away from mediation? I am agreeable to go for mediation even now.
We will arrest the suit and
No difficulty.
direct 12A mediation.
No difficulty.
Now, my lord, you know what trial has to take place. But now, learned.
12A ಗೆ de novo trial ಏನಿಲ್ಲ. After failure of 12A, we will reignite the suit.
No difficulty.
After mediation, my lord, you know what trial.
ಈಗೇನ್ ಟ್ರಯಲ್ ಆಗ್ಬಿಟ್ಟಿದೆ? 7/11 ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಷ್ಟೇ. ಆಯ್ತು, that we will see. From the stage of plaint, we will restore it.
No difficulty. What the trial court says at page 63.
It's correct. ಏನಾಗಿದೆ ಅದೇ ಮಾಡಿರೋದು. 7/11 ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಹೌದು.
Chinese see, my lord, how we have dealt with it.
However he has dealt with, don't worry.
ಇಲ್ಲ, ಅವರು false records ಮಾಡಿದ್ದಾರೆ.
ಅದೆಲ್ಲ we will arrest everything and permit you to mediate on 12A.
And mediation case, my lord, let did not rise.
That suit, all suits will be arrested.
There's only one suit. What happened was I filed.
Oh, that is transferred now.
That is transferred, and now we are left with one suit, COM-OS 302.
No, we will arrest that suit and permit 12A.
ಅಷ್ಟೇ ಆಗಿದೆ.
Order passed on the earlier.
That suit is no longer in existence.
Directed to return the plaint along.
Correct. ಈಗ commercial OS 302 of 2024 ಅಷ್ಟೇ ಇರೋದು.
And page
That you have sought 711. 711, 12A, of course it is, but we'll have to answer these things.
That's what I'm saying.
Matter is referred to the larger bench, even according to my experience.
It is not referred to larger bench. Where is referred to larger bench, no?
No, not referred. For reconsideration. kept
Left open to be reconsidered. No reference. Reference to larger bench is no ground not to follow it. Anyways, we'll see. If we have to answer all this or this via media is permissible, we'll see. Day after tomorrow.
Just this submission, my lord, partial automation is not an absolute bar for non-compliance with 12A, where
No,
suits contemplate.
those
urgent relief.
conclusions in Dhanbad we will see.
Yes.
Next.
Grateful.
Day after tomorrow, same station. Next.
14. Notice. When is the next date? When is the next date? When is the next court vacant alva? Yes, we'll see. ಆಯ್ತು ಕೊಡ್ತೀನಿ. Learned the emergent notice to the respondent defendants. The petitioner is at liberty to serve on the counsel who represents the defendants. List them, defendants/respondents list on Monday next. Yes, next. 15.
Additional issue 14(5). Order 14 Rule 5. So what?
Now this time, order is cast on the. It says that it is concocted.
16.
Yes, to do it.
Where is the additional issue frame now?
Additional issue is named after trial comments. Almost
That's all right. Before the passage of the decree at any time. Yes. Order 14 Rule 5 language adene. Yes.
13.
Additional issue ಏನಿದೆ?
additional issues. In favor of.
That's your contention in the written statement. Yes. So according to your contention, additional issue is framed. ಇಲ್ಲ ಇನ್ನೊಂದು ಸೂಟ್ ಬರ್ಬೇಕಾಗತ್ತ. ಅಲ್ಲ ಅದಕ್ಕೆ ಬೇಕಾಗಿಲ್ಲ ಅಂತಾನೆ ಅಡಿಷನಲ್ ಇಶ್ಯೂ ಫ್ರೇಮ್ ಮಾಡ್ರಿ. ಬೇಡ ಅಂತ. Where is the issue already there?
Issue is that page number 16.
60. You mean to say there is duplication of issue?
Yes.
Where?
Issue number 3 at page number 16. The plaintiff proves that the register being executed by the source on 13/12/2006 in respect of item number 566 issued report and in respect of issued property number 11.
ಅದು ನೆಗೆಟಿವ್ ಆದ್ರೆ ಇದು ಬೇಕೇ ಆಗಿಲ್ಲ. Yes. Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel representing the respondents in the next 3 days and file an acknowledgement. List the matter on 23rd. Till such time, the order that permits or directs additional issue to be framed. ಯಾವ date ಇದು? Dated 25/1/2025 shall remain stayed. ಬೇರೆಯವ್ರು ಬೇಡವಾ? ಕೌನ್ಸಿಲ್ಗೆ ಸರ್ವ್ ಮಾಡಿ ಅಷ್ಟೇ. Counsel represents any of the defendants. Next.
16.
own amendment application that was filed to add the property belonging to the plaintiff own.
What's wrong, sir?
Plus, yes,
Suit for what, sir?
suit for partition.
Yes, sir, all property should be there.
As far as this property is concerned, she has acquired through her mother. And which property has been acquired by the mother in the settlement, whether it is between herself and her father.
It has to be proved amendment ಆದ ತಕ್ಷಣ ಪ್ರಾಪರ್ಟಿ ಬಂದ್ಬಿಡಲ್ಲ. Nothing.
And he has filed the written statement in the year 2018.
Maybe, sir.
Mother has acquired the property in the year 1983. He did not raise any objection with regard to
No
that.
problem.
And there is no disturbance because this property.
In a suit for partition, all property should be there.
As far as the title of the property is concerned,
That doesn't mean that your property will go away from your hands. It is only a claim, it is only a claim which has to be adjudicated. No necessary. It's all right. That is why amendment. No, sir. You are also a claimant in partition. Yes, you are the plaintiff.
This is the property acquired by her through the mother.
That she will not get, sir. That should be adjudicated. Amendment ಏನಆಗಲ್ಲ. No, no. Nothing. Yes. That's- Parallel. Yes.
Documentary evidence in the matter of prima facie this property does not belong to the family.
That the court will decide. Amendment ಏನಆಗಲ್ಲ. Anything else, sir?
I produce the document, 1993 document I have produced.
No problem.
And subsequent, and she has acquired the property year 2022, the guidance of the suit. Suit was filed in the year 2017. He filed the written statement in the year 2000.
Now, who has filed this amendment application?
Defendant number one.
Who is defendant number one?
Defendant number one is the brother of the.
Anything else, sir?
That's the only.
Yes,
condition.
yes.
2022 document.
It's all
She has
right.
acquired the property from the Mandamus,
Suit is of the year.
2017. And he filed the written
Emergent notice to the respondents. Next.
70.
Respondent.
We will fix a date.
Lily,
Let the
matter is
cross-examination get over on that day.
Matter is posted for judgment.
When?
19. It is a
19.
matter where the defendants filed a RFA. They have taken order that within 6 months they are cooperated with this before the
Page.
civil court.
Page.
They have not produced the RFA copy.
Kodi. Wait, sir. Order 18, Rule 17.
ಹೌದು ಅದಾದ್ಮೇಲೆ
ಕೊಡಿ ಆರ್ಡರ್
ಎರಡೇ ಪೇಜ್
ಮತ್ತೆ
ಲಾಸ್ಟ್ ಅದಾದ they have filed one more application IA-15 after the disposal of the IA-14. I have one side ಮಾತ್ರ ತಗೊಂಡಿದ್ದೀನಿ ನಾನು ವೇಸ್ಟ್ ಶೀಟ್
ಬರೀ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇಲ್ವಲ್ಲ.
ಲಾಸ್ಟ್ ಶೀಟ್ ತಗೊಂಡಿದ್ದೀನಿ.
On the said date, file is written statement and entitled further cross-examination. 6 months. ಈಗ the court has rejected the application filed only because of this.
After that,
Only because of this.
ಇಲ್ಲ IA-14 ಆದ್ಮೇಲೆ
Permitted him to cross-examine. He did not do it.
2009 suit legal. Yes. Now insofar as 1817 is concerned, we'll fix a date. ಬೇಕಾದ್ರೆ
ಇಲ್ಲ
ಅದಕ್ಕೂ
IA-14
objection ಇದೆ.
ಆದ್ಮೇಲೆ ಏನಾಯ್ತು ಗೊತ್ತಾ, IA-15 ಹಾಕ್ತಾರೆ. Recall the order dated 10/3/2025 where matter was posted for argument. ಇಲ್ಲಿದೆ ಆರ್ಡರ್ ಶೀಟ್ ಇಲ್ಲಿ
ಕೊಡಿ.
ಮೇಡಮ್ ಅದು ನಾನು IA-15 ನಾನು ಅಲೋ ಮಾಡಿಸ್ತೀನಿ.
Suit for?
Suit for declaration and for the plaintiff before the trial.
No, that other things we will consider, but 1817 for cross examination, one day we will fix.
Sufficient opportunity has been
ಎಷ್ಟು
given. I
ಕೊಟ್ಟಿದ್ದಾರೆ?
said no objection to allow 3 applications were filed from January.
Prior to that?
Yes,
Where are the applications filed?
the applications are not in my hands.
When is the next date?
19th is fixed for the judgment.
List the matter on Friday. File your objections by then. If you are documents with a memo with documents.
Please.
Yes. ಲಿಸ್ಟ್ ಒನ್ 19th ಇರೋದಲ್ಲ ನೆಕ್ಸ್ಟ್. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಅವತ್ತು ಕೊಡುವ ಜಡ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗೋದು ಇದು. ಅದೇ ಪ್ರಿಪೋನ್ ಮಾಡ್ತಾರ. 19th ಹಾಕಿದಾರೆ ತಾನೆ?
19th.
Yes. List on Friday. 13th. Yes, next.
18.
Harsh.
I can't permit you to go on with the constructions. Emergent notice to the respondent. Petitioners are at liberty to serve, petitioner shall serve on the counsel who represents the respondents in the trial proceedings and file an acknowledgement in the next 3 days, less the matter on 23rd, till such time parties to maintain status quo, including the construction of the alleged construction in the property. Next.
19.
Appear for respondent number 1.
Appear for the petitioner. The divergent views that the suit for injunction. Sale deed has been registered in favor of my father. Unless that sale deed is there, they cannot. Now they wanted to sell the injunction granted only not to alienate the property. So now,
What do you want now?
appellate court has reversed it. Trial court granted injunction.
Yes, sir.
98, the person died. Meher Mehta. 2007 is a sale deed in their favor. On the basis of a power of attorney.
All are created documents.
Power of attorney yavaginda?
Power of attorney is an older power of attorney.
98.
Which also there is material.
It dies with the person, then perpetual Allah.
It is a fraud. Fraud played by the second respondent.
What
creating
fraud?
the document, first respondent. He has come from Andhra Pradesh, Telangana, and created the documents as it.
What document is created according?
A legal heir certificate to death certificate to, and also he lost the legal heir certificate. This is a very funny page.
No, 1 minute.
He
On
claims to
what,
be the
1 minute, sir. On what document are you basing your plaint?
sale deed.
Dated?
2007 sale deed.
On what basis?
Based on the
Where is the
JPA.
sale deed? Page?
May I pass it on? I have the documents.
You lost page, annexure F, page 85.
Let me see it. Page 4 is the general power of attorney.
Page 4, huh?
Page 4 is general power of attorney. This also is forged and there is prima facie material for that in a
No,
criminal.
anyway, this
Yes.
is 1998.
98, my lord.
All right.
No one has the original. And then the sale deed
Ah.
is, my lord, at annexure R5, page 11.
Page?
11. It says 7/3/2007
Ah. Between whom?
between father and son. Son executes the sale deed in favor of the father on the basis of the general power of attorney of 98. Oh, I'm sorry, of
No. This,
Power of
father
attorney.
dies, is it?
Father dies, 18, yes.
Father dies, R3, page 10.
Yes.
R3, page 10 is not father, it's the lady,
Oh, mother.
mother.
All right.
Father also dies.
Father also dies.
Yes. Before that.
No. Who
The
is
property is
Sir,
owned, my
who is
lord,
the-
but-
1 minute. Who is the executant of the power of attorney?
Mehra, one Mehra.
When did he die?
She, it's a she, it's
She
actually she.
died. ಅದನ್ನ ಹೇಳಿ.
Adhe, Meher,
ಅದನ್ನ ಕೇಳ್ತಿರೋದು. Death certificate ಯಾರ್ದಿದು ಅಂತ.
ಅವಳದೆ.
That's
But
what he
ladies.
said, no? Yes.
Oh, I'm so sorry. Because your lord he said he, no, I said no to he.
He and
It's
she
a- It's a
problem.
she.
Anyway, it's a lady.
Lady passed away in
Executant is a lady, same lady dies on
1998.
16/5/1998.
Yes,
Power of attorney is 10th February 1998.
yes.
Sale deed bani. Come to the sale deed.
Sale deed
2007.
is,
Hello. Sale
Page
deed
11.
Between whom, sir?
sale deed is by my learned friend
Ah.
To
in
his
favor
father.
of his father. On the basis of the general power of attorney hold, general power of attorney.
In
And-
favor of the father, that is husband of whose father?
No, my father.
His father.
Your father.
The general power of attorney, my lord, is granted to him. He executes sale deed in favor of his father. Subsequently, father dies, he comes back and says it's mine property.
Yes, sir.
And he doesn't even say she's dead in this.
I
It goes
will,
as
I
if he's
will
alive.
submit.
First appellate court had granted injunction.
ಇಲ್ಲ, ಇಲ್ಲ. Civil court has
Trial
granted
court
injunction, first
injunction.
appellate
Oh,
court
sorry.
reversed it.
Reversed it.
Reversed it saying,
It's only not to alienate. You lost my kindly see page 85, annexure F.
Where, on what basis are you claiming the property, sir?
But
To
sale
claim
deed,
injunction, on what basis are you claiming the property?
not to alienate. Because unless the sale deed is there, not trial, first
Not to
appellate-
alienate, but to whom? To against them?
Yes, that will, but
Yeah,
second,
yes.
when the is created the agreement of sale in respect to second defendant.
Hmm.
Even
When is,
before,
when is the agreement of sale?
11 to 2008,
there's no agreement to sell.
Which agreement of sale?
agreement
Nothing in
of
his
sale.
favor, nothing in his favor. There is,
No, no, you have created agreement of sale
we have
in third
executed
party.
agreement in favor of
Yes,
third
third
party.
party, yes.
2008.
That has been cancelled. That's what-
Lalala,
cancelled.
22,
22 is it?
22.
Ah.
And that is cancelled.
thereafter it was cancelled because.
Now, who are you?
I am a relative
Yes,
of this
that is the main
lady
important.
and the only sole surviving heir
Sole surviving heir of that
of
lady.
that Mera. And there's also a will in my favor.
Where
Will
is
is
the-
my lord of the year
where is the will?
1980. The
Where is
will
the
not is the first document. Annexure R1, page 1.
R1,
R1, page 1.
will is dated
Will is dated 1980.
1980.
Yes.
But as on that date, there was no property available. That is what I am wanted to bring it to notice.
What is the description of the property here?
Yes.
Same thing. Please see page 3.
Agricultural land in so and so.
Kogilu village, Jalanka Tal.
When did the lady purchase that property?
It was a grant. It was
Grant in whose favor?
No, annexure F, I put this. Page 85. That was land under section 66 of Land Revenue, Land Reforms Act.
Correct.
It was forfeited by the government
Forfeiture.
along with
Forfeiture
other
was
lands.
certified.
By virtue of the GP executed in my
That
favor.
forfeiture has become final?
No. All the other lands, 54 acres was there, except this land, other lands were forfeited. This land was released in the year 2003. Where is the question of the execution
No.
of the?
This
will.
land was released in the year 2003
Three.
in favor of the lady.
Yes. There was no how come the will can be executed in the 98? Even funny thing, when page 108, you lost legal heir certificate. Page 108.
It was granted in her favor, is it?
That was
And for what
forfeited,
purpose?
excess lands.
Beg your pardon?
Parsi anta.
Parsi.
No. Now he is a Muslim, I think.
Parsi, sir. Not a
you
Muslim.
rest-
Now he is a Muslim.
First respondent.
Yes.
Annexure Milad, page 108, page you lost. my
Firoz
page.
Irani is.
Legal heir certificate, how
Firoz
it is
Irani
unknown
is
to
a
Milad
Parsi.
into succession act, page 108, you lost me, go to 108.
Allah, but what
Adalli
are
ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ?
my learned friend slightly, what is to be answered?
Meher Mehta sisters,
No, no, you are trying to deviate the main issue. ಅದೇನು ಹೇಳ್ತೀರಾ?
ಅಲ್ಲಲ್ಲ, what I am submitting, he has no legal right at all. All created
Or do you
documents.
have?
Sale deed, unless that sale deed is set as.
Sale deed on what
First appellate
ground?
court says, first appellate court says, what the first appellate court says is, unless the declaration is made, injunction cannot be granted. That is not so, because on the other hand, they have to file suit for
You want
declaration.
me to observe that how the sale deed came? I will observe.
Not necessary.
Not necessary.
Page 23, Milad, you lost me, kindly see.
In the criminal petition is already an observation that the
Criminal petition ಆಗಿದೆ.
our criminal case ಹಾಕಿದೀವಿ.
ಅದು pending ಇದೆ.
Charge
You lost
sheet
me.
ಆಗಿದೆ.
I produced
But,
that also.
no. In that what happens is, there is a forensic examination of the signature on the GPA and it is found to be completely forged. And that also is a photocopy.
Legal, you lost me, kindly, page
It
108.
came on this, sir.
ಅಲ್ಲ ಪೇಜ್ 108 ಅಲ್ಲ ಪೇಜ್ 108 ತಾವು ನೋಡಿ ಮಿಕ್ಕಿದ ತಾವು ಇಲ್ಲಿ
Not it.
ದಟ್ ಈಸ್ ದಿ ಲೀಗಲ್ ಹೇರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕ್ರಿಯೇಟೆಡ್ ಬೈ ಹಿಮ್
Created.
ಎಸ್ ಅದ್ರ ತಾವು ನೋಡಿ ಸರ್ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಹೋಗಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್
93 ಅಂತಿದೆ ಸರ್.
Son-in-law.
ಸನ್ ಇನ್ ಲಾ ಹೌ ಬಿಲ್ ಹಿಂದೂ ಸೆಕ್ಷನ್ ಆಕ್ಟ್ ವಿಲ್ ಕಮ್ ಸೆಕ್ಷನ್ 8 ಆಫ್ ದಿ ಹಿಂದೂ ಸೆಕ್ಷನ್ ಆಕ್ಟ್ ಹೌ ಹಿ ವಿಲ್ ಎಂಟೈಲ್ ಫಾರ್ ವಿಲ್ ಮೇಲೆ ಕೂಡ ಬರೋದಿಲ್ಲ. ಸೊ ದಟ್ಸ್ ವೈ ದಿಸ್ ಕೋರ್ಟ್ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಮಾಡಿದಾಗ ಅನೆಕ್ಷರ್
ಅವ್ರದವ್ರು ಡಿಫೆಂಡ್ ಮಾಡ್ಕೊಂತಾರೆ ನಿಮ್ದು ಹೇಳಿ.
ಅಲ್ಲ ಕರೆಕ್ಟ್
ಇಂಜಂಕ್ಷನ್ ನಿಮ್ದು ರಿವರ್ಸ್ ಆಗಿದೆ, ಕರೆಕ್ಟ್ ಆಗಿದೆ.
ಅಲ್ಲ ಫಸ್ಟ್ ರಿವರ್ಸ್ ಆಗಿ ತಪ್ಪ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
ಅದೇ correct ಆಗಿದೆ ಅಂತ
ಅದರ್ವೈಸ್
ನಾನು ಹೇಳ್ತಾ
ದಿಸ್ ಬಿಕಮ್ ಮಿಲಾಡ್ ಯು ವಿಲ್ ಸೆಲ್ ಅಂಡ್ ಗೋ ಮಿಲಾಡ್
ಅದೆಲ್ಲ
ಅದರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಈಸ್ ನಾಟ್ ಟೇಕಿಂಗ್ ನೋಟಿಸ್.
ಅದೆಲ್ಲ ಅಲ್ಲಿ ಯಾವ ನಾಟ್ ಟೇಕಿಂಗ್ ನೋಟಿಸ್ ಯಾವ್ದ್ರಲ್ಲಿ?
ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಒಂದು ಲಾಸ್ಟ್ ಕೈಂಡ್ಲಿ ಫಸ್ಟ್ ನಾವು
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ನಿಮ್ಮ ಮೇಲೆ?
ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಟೇ ಆಗಿದೆ.
ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ.
ಅಲ್ಲ,
But
correct.
there is forensic examination that it is correct forged ಅಂತ.
ಅಲ್ಲಲ್ಲ, ಅದಕ್ಕಲ್ಲ. ಸಿವಿಲ್ ಸೂಟ್ಸ್ ಇದೆ.
ಅದ್ ಶೀಟ್ ಆಗಿದೆ ತಾನೆ.
ಆಗಿದೆ.
ಸ್ಟೇ ಆಗಿರೋದು ಬೇರೆ ಮಾತು.
ಹೌದು.
ಸ್ಟೇ ಆಗಿದೆ ಅಲ್ಲ.
ಬ್ಲಡ್
ಪ್ಯೂರ್ಲಿ ಸಿವಿಲ್ ಅಂತ ಸ್ಟೇ ಆಗಿರುತ್ತೆ.
ಅಲ್ಲ, ಅದಾಯ್ತು. ಬಟ್
ಆರ್ಡರ್.
ಅಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕ್ರಿಯೇಟೆಡ್ ಅಂತ ಹೇಳಿ
ಎಸ್.
ಅದರ್ ಪಿಟಿಷನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್ ಟುಮಾರೋ. ಯು ಲಾಸ್ಟ್ ಮೈ
ವೈ ಸರ್?
ಇದರಲ್ಲಿ ಬೇರೆ ಪಿಟಿಷನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ.
ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
ಅಲ್ಲ, ಯು ವಿಲ್ ನಾಟ್ ಮಿಲಟ್ ದ ಗೆಟ್
Your foundation itself is shaky. You are wanting a superstructure there.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಳ್ಳಿ ಸರ್ ಮೇಲ್.
ನೆಕ್ಸ್ಟ್ ನಾಳೆಯಿಂದ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾಕೋಯ್ತು ಸರ್?
ಆಯ್ತು, ನಾಳೆನೇ ಹಾಕೊಳ್ಳಿ.
ಆಯ್ತು, ಏನಿಲ್ಲ.
ಆಯ್ತು, ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದಟ್.
You want me to pass an order on merits observing that the fact that your sale deed has come up after the death of the executant of the GPA.
That itself is created. That's what I am submitting.
Sale deed is created.
Sale deed ಅಲ್ಲ, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅವೆಲ್ಲ ಕ್ರಿಯೇಟೆಡ್.
Death certificate create ಆಯ್ತು. ಇನ್ನು she is alive still.
Documents
on the website.
She is still alive, is it?
15 ಪೇಜ್.
She is still alive.
ಇಲ್ಲ, ನಾನು ಸೇಲ್ ಡೀಡ್ ಆದ್ಮೇಲೆ ತೀರೋಗಿರೋದಕ್ಕೆ ಆ ತರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಆರ್ ಪ್ರೊಡ್ಯೂಸ್. ಪೇಜ್ 15 ಆಫ್ ಮೈ ರಿಟ್ ಪಿಟಿಷನ್. ಪ್ಯಾರಾ 12.
This is the first time it's coming up.
ಎಲ್ಲಿದೆ ಲ್ಯಾಂಡ್ ಇದು?
Kogiju village, Yalanka Hubli.
ಯಲಂಕ, ಅದಕ್ಕೆ ಇದೆಲ್ಲ.
ಅಲ್ಲ, ಕರೆಕ್ಟ್.
ಕರೆಕ್ಟ್ ಕರೆಕ್ಟ್.
ಆಸ್ ಆನ್ ದಿ ಡೇಟ್ ಆಫ್ ಪೇಜ್ 23 ಲಾಸ್ಟ್ ಪ್ಯಾರಾ 23.
ನಥಿಂಗ್.
ಪ್ಯಾರಾ 23
ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್ ಇಸ್ ಕರೆಕ್ಟ್. I'll close this if you want. ಇಲ್ಲ ಅಂದ್ರೆ
I will produce this.
what you will produce?
Documents created ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ನಾನು. I produce those.
ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ?
ಹೌದೌದು. ಲ್ಯಾಂಡ್ ರೆವಿನ್ಯೂ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಬ್ಲಡ್ ಐ ವಾಂಟೆಡ್ ಟು ಸೆಟ್ ಅಸೈಡ್ ದಿ ಎಂಟೈರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಬ್ಲಡ್ ದೇ ಟುಕ್ ಟೈಮ್. ಬ್ಲಡ್ ನೌ ಆಫ್ ಕೋರ್ಸ್ I will produce.
Anyway, this is only an injunction granted. It's not a decision in this suit.
Injunction not to alienate. Blood injunction not to dispose, okay. But injunction not to alienate. Once alienate is there, alienation is there. Well, where is the property available in the suit to be decided?
Correct. ಇಲ್ಲಾಂದ್ರೆ ಸೂಟ್ ಡಿಸೈಡ್ ಆಗೋದ್ರೊಳಗೆ ಖಾಲಿ ಮಾಡ್ಬಿಡ್ತೀರಾ ಪ್ರಾಪರ್ಟಿನ.
ಆಯ್ತು, ಎಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗಿದೆ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
That is why not to alienate is correct.
Correct. ಅದಕ್ಕೆ ಹೇಳಿದೆ. That's what.
ಅಲ್ಲ, not to alienate, ಯಾರು you against you it was.
ಅದಕ್ಕೆ
Against me.
That is
On
the
the
reason.
basis of
Now first
your
appellate court.
title is on the basis of the sale deed. Entire basis is that.
No, that the first appellate court considers
all of that and says it's all forged and sale deed could never have been
Forged
executed
and
because
dead.
one second, sir.
Yes.
Sale deed could never have been executed in his favor because she was dead. And it is not on the basis of any document. It's the website details which are there of her date of death. And when that is there, where is the question of him making a claim?
Anything
He should have
else?
some title.
Next week I will produce.
Jack next week. We'll close it today.
No. Say, blood sale deed, ಇದು death certificate and
There is
also.
nothing wrong with the first appellate court's order.
But then he will sell and go away. This is from Telangana.
Correct.
He is not at all concerned to this property. Last my kindly see ಅದಕ್ಕೆ ನಾನು ಹೇಳಿದ್ದು legal hair certificate ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು. Even you last my kindly see.
No, first of all, we will sell the property and go away. And the property is not yours at all. Does not belong to you at all.
ಅವ್ರಿಗೂ ಬರೋದಿಲ್ಲ ಹಂಗೆ sale
The basis of what you are claiming is a sale deed which could not have been executed. By then the lady had died. Not by then. 10 years ago the lady had
ಅದೇ
died.
ತಪ್ಪು. That's what I did.
ಆಯ್ತು, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಬೇರೆ ಕೊಡಿ ನೋಡೋಣ.
ಅದು ಕೊಡ್ತೀನಿ. ಅದಕ್ಕೆ
ಅಲ್ಲ, ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಆಫ್ ದಿ ಗವರ್ನಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್, ನಾಟ್ ಅವ್ರೇನ್ ಕ್ರಿಯೇಟ್ ಮಾಡಿಲ್ಲ.
ಅದನ್ನು ಗವರ್ನಮೆಂಟ್ ಕಾರ್ಡ್ ಇನ್ನೊಂದು ಹೇಳಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಏನೋ ಹೇಳಿದ್ದಾರೆ,
ಎಲ್ಲಿಯಾದ್ರೂ ಒಂದು
legal hair certificate.
ಎಲ್ಲಿಯಾದ್ರೂ ಒಂದು ಫೈಂಡಿಂಗ್ ತೋರಿಸಿ ದಟ್ ದಿ ಲೇಡಿ ಹ್ಯಾಸ್ ಡೈಡ್ ಆಫ್ಟರ್ 2000.
ಅಲ್ಲ, ಫೈಂಡಿಂಗ್ ಇಲ್ಲ. That's why I wanted to produce.
ಫೈಂಡಿಂಗ್ ಅಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್.
Document.
ಯಾವ document?
ಅಲ್ಲ, later I secured from the.
ಎಲ್ಲಿದೆ?
ಇದೆ, I produced the documents. In the other case.
Day after
Not in
tomorrow.
the court. Nothing has been filed.
Day after tomorrow.
ಅಲ್ಲ, ಶುಕ್ರವಾರ ಹಾಕೊಂಡ್ರೆ ಒಳ್ಳೆದು.
ಬೇಡ, ಸುಮ್ನೆ ಕ್ರಿಯೇಷನ್ ವರ್ಸಸ್ ಕ್ರಿಯೇಷನ್ ಯಾಕೆ?
Day after tomorrow.
ಎಸ್, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಟೈಮ್ ಸಾಕು. ಇದ್ರೆ ನಾಳೆಗೆ ಹಾಕ್ಬೋದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ. ಇಲ್ದೇ ಆದ್ರೆ ಟೈಮ್ ಬೇಕಾಗುತ್ತೆ.
Okay.
ಎಸ್,
ಆಗ್ಬೋದು. Not only that, ಅವರು ಲೀಗಲ್ ಎಂಟಿಟಿನೇ ಇಲ್ಲ ಅವನಿಗೆ. Where is the question?
ನಿಮಗೆ ಏನಿದೆ ಅದು ಹೇಳಿ.
ನಾವು ಸೇಲ್ ಡೀಡ್ ಇದೆಯಲ್ಲ, unless that is sale deed set aside.
ಪರ್ಸನ್ ಸೇಲ್ ಡೀಡ್
Section
ಎಲ್ಲಿಂದ ಎಂಟಿಟಿ ಸರ್ ಅದು? ಎಸ್,
Even that has to be decided. That is the Millard.
ಕರೆಕ್ಟ್. ಟಿಲ್ ದಿ ಡಿಸಿಷನ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ.
Correct. Not to alienate Millard is the Millard.
ಎಸ್, ನೆಕ್ಸ್ಟ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
Same stage.
ಇರದೇ ಒಂದು ಸ್ಟೇಜ್, ಸೇಮ್ ಸ್ಟೇಜ್. ಎಸ್,
ಅಲ್ಲ, ಬೀಗಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟಾರೆ.
ಹೋಗ್ಲಿ ಬಿಡಿ.
My lord, this is the defendant writ petition, my lord. Rejection of application is the court commissioner appointment is rejected by the trial
ಕರೆಕ್ಟ್
court.
ಆಗಿದೆ, ಏನ್ ತೊಂದ್ರೆ?
My lord, may kindly peruse the finding at page number
Come
21, my
to the
lord.
findings. Yes.
21, my lord.
Yes, sir.
Para number 8.
Ah.
The scope of order 26 rule 9 of CPC is very limited in suit in which a local investigation is required or proper for purpose of eliciting any matter of dispute may appoint a commissioner. It is settled law that the parties are required to prove their own case by way of evidence. Therefore, it is the duty of plaintiff or defendant to first give evidence in support of their case. After the evidence of the parties, if the court deems it proper that any issue requires clarification, then the court may appoint a commissioner. In this regard, my lord.
Come to para 12, sir.
Yes,
Suit for bare injunction.
my lord, my
It is the burden on the plaintiff.
Lord, further, para number 12.
Ah.
Further, in a suit for bare injunction, burden always lies on the plaintiff to prove his possession over the suitable property.
Court
as on the-
commissioner ಯಾಕ್ ಬೇಕು?
My lord, in this present case, my lord, the dispute involved is that he is claiming site number 6, measuring 1,200 square feet. We are saying that we are running this pool at 38 guntas of the land, converted land. And the dispute really is concerned, my lord, the identification of properties dispute.
Nothing.
In this regard, we have produced the photograph in the earlier round of litigation, my lord.
Sir, it is for the court to consider whether it is necessary for appropriate adjudication or not for you or them to fish evidence.
Yes,
by
my lord.
appointment
Para
of a
number
court
11, my
commissioner.
lord. 1 minute, para number 11.
Oh, yes,
Finding 11, my lord.
Yes, sir.
The defendant counsel vehemently argued in a suit for injunction. Also, the court commissioner can be appointed and there is a no bar to appointment of court commissioner. In support of his contention, he has also relied on the citations referred above. This court has gone through the facts and circumstances of the citations relayed by the defendant. Though it is permissible to appoint court commissioner in an injunction suit, discretion is left to the court to decide whether there is a need for appointment.
ಹೇಳಿದ್ನ.
Yes, sir. Next line ಓದ್ತೀನಿ sir. Decide the matter in dispute. In such circumstances, question of appointment of court commissioner does not arise.
Does
Here,
not arise.
the court did not decide what is the real controversy
No,
in between the
not
plaintiff
at
and
all.
defendants. Moreover, my lord, merely because the plaintiff burden is
Stage
there,
of the proceeding?
stage of the proceeding, further evidence of the defendant.
Anything else? sir?
17:6.
Anything
The
else?
citation I want to
Oh, ಕೊಡಿ sir.
Para 10, 16, 20.
ಕೊಡಿ sir. Yes. ಹತ್ತೋಳಿ ಮೇಡಮ್.
My lord, may page number 94 may also be produced, my lord, for a moment.
ಇದರಲ್ಲೇ ಇದೆ ಸರ್. ಷಡಾಕ್ಷರಪ್ಪ ಅಲ್ವಾ?
ಹೌದು sir.
ಎಸ್.
Page number
ಪೇಜ್
94. The writ petition proceedings. From the top 9th line, my lord.
ಈ ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ ಇಲ್ಲಿ.
94 writ petition. Writ petition ಅಲ್ಲಿ 94.
Petition ಬಿಡಿ, come to this to save precious time of the court, streamline the procedure as far as following principles. Clause C.
The issues framed in the suit are where the issue is not yet framed. The pleadings which give rise to issues and the documents placed on record would be a guide ascertain the matter in dispute report in the order 26 rule 9 of the court. Here are the issues framed, my lord. In the present
Anything
case,
else?
my lord, in
Anything
the
else, sir?
page number 94 of the writ petition, may kindly.
Yes, sir.
From the top 9th line, my lord.
The
The photographs clearly show the demolition of the compound wall and within the compound wall RCC columns are existing. The question is
ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್?
ಈ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಯಾಕಂದ್ರೆ ಲಾಸ್ಟ್ ಪ್ರಿವಿಯಸ್ ಲಿಟಿಗೇಷನ್ ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಎಕ್ಸ್ಪರ್ಟಿ ಆರ್ಡರ್ ತಗೊಂಡು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿ ಅದರಲ್ಲಿ ಫೋರ್ಸಿಬಲ್ ಪೊಸಿಷನ್ ತಗೊಳ್ಳೋದಕ್ಕೆ ಪ್ರಯತ್ನ ಪಟ್ಟಿದ್ರು. ದಟ್ ಈಸ್ ದ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ಫಾರ್ ಅಪ್ರೋಚಿಂಗ್ ದಿಸ್ ಆನರಬಲ್ ಕೋರ್ಟ್ ಬೈ ವರ್ಚು ಆಫ್ ದಿ ಪೊಲೀಸ್ ಆರ್ಡರ್ ಹೆಲ್ಪ್ ಆರ್ಡರ್ ದೇ ವಾಂಟೆಡ್ ಟು ಗೆಟ್ ದಿ ಫೋರ್ಸಿಬಲ್ ಪೊಸಿಷನ್. The question as to when the RCC columns are put up is required to be ascertained. If the columns are put up even before a judgment and decree was passed by the trial court, then the decree holder cannot be permitted to execute the judgment and decree, which restrains the defendant from interfering in the suitable property to enable the demolition of structures. In this background, this court is of the considered opinion of the some breathing time to be given. And that circumstances, I approach this honorable court, my lord. My lord, the photographs of the school building is also placed before this honorable court.
Yes, sir.
At page number 107, my lord. It may kindly peruse, my lord. It is the inside of this school building, a photograph is showing, my lord, that an attempt was made by the plaintiff to take the forcible possession that is evident before this honorable court, and all these circumstances clearly show that, my lord, the court commissioner report is assisting the court for arriving the proper conclusion for determination of the case.
Yes, madam.
Lordship, in this case, it is only for bare injunction, Your Lordship. So that's the reason the court has come to a conclusion correctly that court commissioner is not.
There is no
report is
bar
not-
in even injunction suits, but
Yes, Your Lordship,
Yes.
there is no bar, but court has said that it is not necessary for this case because plaintiff has proved that he is in the position. And we ourselves have concealed, Your Lordship. Let them adduce the evidence and conclude the case within 6
anything
months.
else?
Oh, the matter is second round of litigation, my lord, if it will decide at the matter, my lord. Because he's claiming the
Order 26
imaginary
rule,
side.
there is no warrant for 26(9).
My lord, imaginary property is claiming, my lord. This is the property.
He will prove
Yes,
it, leave it, sir. Imaginary property, then he will fail in the suit.
That
Why are you
observation
worried?
may be.
Yes, dismissed. Next.
A pleasure, Lordship.
21.
My lords, the suit is one for recovery of money, my lord. My lord, kindly appreciate-
Commercial OS.
Oh, it's commercial OS, my lord. My lord, kindly appreciate the plaint, my lord. In page number 21, annexure B. My lords, it is filed by.
Order 1, Rule 1110.
Yes, my lord, I have filed.
Sorry, Order 11, Rule. Yes, next. Order 11, Rule 1, Clause 10.
Please, my lord. With the leave of the court, I can. My lord, here what happened, my lord? This father of the plaintiff, my lord, the Rishabh Impacts, is the filed the suit represented by Gautam Kanoga, age 21 years. My lord, his is represented by GPA holder, my lord, his own father. My lord, who has transacted, my lord, with the.
When did you file the suit, sir?
They have filed, my lord.
Sir, suit is of the year 2020.
24. 24, my lord. My lords, while transacting, my lord, he has issued a WhatsApp communication to put the money to the particular account, my lord. Accordingly, I have paid the entire money, my lord, which I wanted to produce now, my lord.
One moment. Serve on the response. The petitioners are defendants 1 and 2 in a suit instituted by the plaintiff in commercial OS 835 of 2024 for the purposes of recovery of money. The present defendants file IA1 under Order 11, Rule 110 of the CPC, seeking to produce certain additional documents which would go to the root of the matter. The concerned court has rejected it on the score that those documents pertain to the year 21 to 2023 and the suit is of the year 2024. A perusal at the documents and the claim that is made is indicative of the fact that it would touch upon the claim that is made by the plaintiffs. In that light, the respondent shall serve on the counsel who represents the respondent plaintiff before the concerned court and file an acknowledgement in the next 3 days. List the matter on 25th. Till such time, further proceedings before the concerned court shall remain stayed.
Grateful, man.
22.
You serve on the wife.
My lords, on the previous occasion, your lordship wished to see the compromise petition because the compromise decree is to be read.
Clause.
My lords, all the clauses, in fact, your lordship, because the wife respondent in the present petition, she agrees to come back to live with the husband.
Where is that? Voluntarily to admit to the wards in school.
At 3, your lordship, the petitioner and respondent have jointly agreed to stay together at Bangalore and continue to live the life as husband and wife along
Is
with.
not here now.
No, your lordship. In fact, your lordship.
Emergent notice to the respondent. Petitioner is at liberty to serve on the respondent. Counsel appearing for the respondent in the unclaimed idea.
One submission, if I may. On the previous occasion, emergent notice was issued, and in fact, it's returned as per.
The respondent wife has the postal cover or the postal shara indicates that the respondent the postal shara indicates that the notice issued to the respondent is left unclaimed. In that light, the registry to print the name of the respondent and show her as served
The learned counsel for the petitioner submits, what is called in question is the proceedings in execution 22 of 2023. The learned counsel for the petitioner relies upon clause 3 of the compromise petition pursuant to which the proceedings were concluded. The clause reads as follows. The wife had agreed that she and their children would live with the husband, and there are certain conditions after that. The learned counsel submits that the wife has breached the said condition and has now travelled back to Kurga.
Please, Your Lordship.
Travelled back to Kurga along with the children.
Please, Your Lordship.
Along with the children. In that light, in the light of the said submission, there shall be an interim order of stay as prayed for. However, it would not mean that the petitioner would not pay the fees for education or take care of the children in the meantime. Yes.
Grateful, Your Lordship.
23.
Oman.
Lord said, ask me to verify if my client is coming to India. She has no plans of coming to India, Lord. One more submission, Lord. Lord, this order, Lord, which is impugned. This is passed, Lord, in June 2024. But this writ petition is filed in April 2025. Meanwhile, Lord, I have already cross-examined defendant number 5, who has examined himself as DW1. And Lord, another factor is not to see the order sheet. Lord, at the instance of Lord these defendants, but earlier Lord is already an order of recalling. And Lord, that is how Lord I have went.
No, that stray sentence is what troubled me. Anyway, I will answer that stray sentence.
Yes.
It should be ignored. Otherwise, you have no rights, sir. Finished. You have finished all your rights. I will answer the stray sentence. That will not, it does not mean that it is merely because you have not filed the written statement. It is not that the cross-examination is not permitted.
Please,
Please.
not, these are all family dispute, my lords.
Correct.
Certain amounts were paid to the defendant number 2 for buying land for.
No, that is true. That's on the merit of the matter. We are on cross-examination, permission cross-examination. I don't find anything wrong with the order, except that stray sentence. I will say that is not the purport of the order itself.
Please.
Tumba sari agogide.
Great.
Yes. Ashte. If it's a good case, Joseph sir definitely will do something. Not. He would also not object it. Dismissed.
But speedy disposal.
That ಯಾವ ವರ್ಷ
2020.
2020. In recovery of money.
Oh, the recovery of money.
I will 4 months.
I cannot compromise because actually it is not a commercial dispute. It's all.
That has already
there is
been
no
rejected
agreement.
by the Honorable Court. There's an order, Lord. They have challenged that order.
There is
We will
subsequent
not get
judgment.
into all that, sir. We are only on permission for cross-examination.
Yes, please.
Not for non-filing of the written statement. That is not the purport of the order. There is only a stray sentence. ಅದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಬರೆಯಕ್ಕೆ ಹೋಗಿ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು. Yes.
Great.
Yes. 4 months. Yes.
Please.
Next.
24.
My application for amendment.
Order
of-
6 Rule 17.
Yes, my lords.
Emergent notice to the respondent. Issues are framed.
Yes, my lords. Issues are framed matter at the stage of defendant evidence.
What did you want to do in this?
My lord, I want to bring in certain facts, and I have filed a injunction suit against the plaintiff, and that suit has been dismissed. I want to bring in record the dismissal of that said suit. Also, my lord, I need to give some certain.
When did you file the application?
Application was filed on
At what stage?
at the stage of plaintiff defendant evidence, my lord. After plaintiff evidence, what has happened is due to the change of counsel, my lord, the
Change of counsel is no grounds. Yes.
there's some typographical errors, my lords.
If you are correcting only typographical error, it's fine. Otherwise, if you are changing the nature of the suit, difficult.
It's not changing the nature of
Where
the
is
suit. and-
typographical error? Come to para 10 at page 25.
On perusal of the written statement filed by the defendant.
ಇದರಲ್ಲಿ ಓದಿ ಸಾಕು. Admission given by the defendant in his written statement are very crucial,
It's
important.
the defendant's written statement, inconsistent pleas can be taken, and the
Correct.
plaintiff has the right to cross-examine the defendant at the time of evidence.
Hmm.
So no prejudice will be caused to the plaintiff if the application is
What
allowed.
is the application you filed?
Application is at page number 63, my lord, annexure F.
Where is the latest judgment of Supreme Court? Could you?
That's extracted,
Where?
page number 27. 26.
Revajitu.
Revajit.
Haleyadu. Where is Ganesh Prasad?
I'll produce, my lord. I'll file. Today is the matter for defendant evidence. my
Amate,
lord.
you should come with all ammunition, sir. Ganesh Prasad is 2023. Everything is still clear there. When it should be permitted, when not.
Kindly pass over. I'll get the judgment.
Pass over. Yes. Get it.
Grateful.
Ganesh Prasad versus Rajeshwari Prasad. Yes. Next.
25. To appear for the petitioner, my lord. Lands were acquired, my lord, or compensation was granted, reference was made, my lord. Now the LAO, my lord, files an application for order 1, my lord, seeking another trust to be a party to this petition, my lord. Evidence has also had been led, my lord.
Order 1 rule 10 Ivaga.
ಇವಾಗ ಆಗ್ತಾ ಇದ್ದಾರೆ ಅವರು.
Who is the applicant?
No, my lord, one another trust, my lord, trust by name Jinadevaru trust.
Emergent notice to the respondents. Petitioner is at liberty to serve on the counsels who represent the respondent in the trial proceedings. List the matter on 30th. Till such time, the order impugned shall remain stayed.
Obliged.
Yes, next.
26. Appearing for the petitioner.
The auction is deferred.
Auction is deferred, my lord.
So what?
The property in question is to be divided into 4 parts, mother and 3 children. I'm representing the son who is the
There is
respondent.
an interim order already granted here, no?
Already granted.
Howda?
Already granted, extended by the court on 2 occasions.
The auction is deferred.
Auction is deferred. Public auction is deferred. The public auction is Dehorse Partition Act. When there are 4 parties and I am ready to purchase the property.
Who are you?
I am the respondent. I am the son. My mother and 2 sisters have filed the case against me. And they have repeatedly sought for the sale of the property. So as per section 2 and 3 of Partition Act, when they are seeking for sale, the court does not have an option but to sell it to me. And I am ready to purchase. And the trial court has also conducted a valuation of the property. The valuation report is also on record. When I am ready to purchase the property, they have gone ahead and declared a public auction.
Your lordship.
Gone ahead and declared yaru.
The court has appointed a commissioner and the commissioner has issued a newspaper publication and put up the property for public auction, and the court has said all of you participate. But as per section 2 and 3 of Partition Act, if one of the parties or multiple parties asks for a sale, then the court has to offer it to the other party who is not asking for the sale.
Page 75 ತಾವು ನೋಡಿದ್ರೆ 74 bottom 75 26/11/2024.
This is an FDP.
Yes.
In the FTP.
The suit was decreed in
Morning session,
2006.
advocate for respondent finds a memo that he is ready to purchase at 6 crores 80 lakhs. Afternoon memo
75, sir.
Oh, sorry, 74.
During the morning session.
Only.
Yes.
During the morning session, ಅವ್ರು ಹಾಕ್ತಾರೆ. Afternoon, my lord, he says I'll fight. Both of them, my lord, parties have not signed. Therefore, my lord, the judge says it has to be, my lord, and valuation report, my lord, is only 5 crores and all. So apparently, my lord, value, my lord, property is valued.
Quoting higher price quoted by the petitioners.
Correct.
My lord, but that auction itself is erroneous and against section 2 and 3. If your lordships turn to page 73, in page 73 in a detailed order, the trial court has said acting under section 2 of Partition Act. On the next date, the court is holding us at gunpoint and saying, give your bids.
Yes, sir.
Person staying in Bahrain.
He stays in Bahrain.
Yes. My lord, he has never come here. The mother, my lord, and sisters, my lord, they filed a suit for partition. 1/3, my lord, was ordered, 1/4 was ordered to everyone. No difficulty about it. Thereafter, my lord, what happened was the FTP proceedings were initiated. In the FTP proceedings, his contention, my lord, if your lordships look at, my lord, the order sheet, he says, I want mean profits, let there be an inquiry. For 2 years, my lord, inquiry went on without, my lord, any progress. Whole idea is, my lord, to protract, not, my lord, so that, my lord, mother dies, sisters, my lord, will, and then, he'll, Bahrain chap, my lord, will take it. Now, if your lordship,
wait, senior counsel is submitting.
if your lordships, my lord, just look at
the order where, my lord, for 2 years, my lord, his contention was that he wanted, my lord, mean profits.
Inquiry on mean profits?
It's done. I have already filed my memo of calculation.
All right.
Please,
One minute, yes.
please come to page 35. Already, that order sheet itself, says. And if you lordship look at, my lord, page 35, there was a writ file, page 35.
Yes.
Quash and set aside the order.
What happened to that?
Earlier, the trial court had
No, what happened to that writ petition?
it's disposed.
Where is it?
There is a copy of.
Not
the
a part
order.
of the paper book?
It is part of the paper.
Page?
It is a part of the document supplied on 29th. There's a compilation which was given on 29th April. Document number 6 in that compilation. List of documents. RFA 1988 of 2013. It is disposed in 2021. At that time, the court had directed demolition of the property. Both parties challenged it.
What's the order here? Directed re-adjudication.
Inquiry on mean profits.
Correct. Now that is over.
That's over.
Now you have come up with a new application.
I have already filed documents before the trial court regarding my mean profits. I filed a memo of calculation. I've argued the matter in detail. The trial court has failed to adjudicate my share. So I am not in possession of this property from 25 years. I have been kicked out of the house and the property has been enjoyed by mother and 2
Where is the
sisters.
question? Kicked out.
You
He
have
doesn't come
gone,
here. Mother
I
is
was-
left to her lurch.
kicked out to Berlin, Bahrain.
I was told not to enter. No, I was working in
Very
Bahrain.
good.
My mother was supposed to come and join me.
I must
Suddenly
appreciate
they
my
filed the
mother.
case and they say that I'm not giving them the share.
We'll see.
Lot of water has
we'll-
gone under them.
That is what we need to digest those waters. Yes, list on Wednesday.
In this case, order passed and.
What is the reason for delay?
Delay, my lord, the petitioner is suffering from menstrual problem from the menstrual problem and also financial crisis.
ಅದಕ್ಕೆ delay ಬರುತ್ತೆ. ಅದಕ್ಕೇನು delay? That is not sufficient cause at all.
Even the court has held that, my lord, I am not produced the medical records with respect to the.
Where are the
year
medical
2000
records now?
Sorry, my lord.
Medical records ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಇಲ್ಲಿ ಇಲ್ಲ ನನ್ನ ಹತ್ರ ಇದೆ.
Huh?
I am not produced, but.
Where is it? ಅಲ್ಲೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ, ಇಲ್ಲೂ ಮಾಡಿಲ್ಲ.
ಮಾಡಿದ್ದೀವಿ. That has been.
Where is it here?
It is marked as
Both the courts have held it against you.
only one court.
ಯಾವುದು? RA 20 of 2020 ಯಾವುದು?
RA 2020 ಲಿ ನಾನು application ಹಾಕಿದ್ದೀನಿ, that has been rejected.
That's the only thing.
Even in this cross appeal, I preferred this appeal only against the B scheduled property, not
Right.
against the A scheduled property. The
Who is-
aggrieved persons are not contested this matter.
Who is the contesting respondent?
Respondents are defendant number 3 and 6, my lord.
Others have not contested?
Others are not contested. Even the appeal is filed by the purchaser of the item number 1 of the schedule A property.
Which defendant is that?
Defendant number 13. His contention is that he has purchased the item number 1 of the A scheduled property. In this-
Defendant number 13.
Yes, my lord.
Will respondent number?
In my petition is the
ಇಲ್ಲಿ respondent number ಏನು?
Respondent number 1.
1. All right.
In my
yes.
petition, he is respondent
All right,
number
you
1.
serve on them, yes. Petitioner to serve on the counsel who represented defendant 3, 13 and 6, 3, 6 and 13 as the contention of the plaintiff petitioner is that they are the only contesting respondents, subject to further orders, list the matter on, subject to further orders on the service of notice, list the matter on Monday next.
My lord, 18th is the.
Parvaila. Yes, next.
28.
Monday next end date, madam.
Sorry, my lord.
Next Monday end date.
16th.
Yes, next.
Okay for the petitioner, my lords. Plaintiff's application for temporary injunction.
Section 10.
The next matter.
Next matter.
Next matter, section 10, not? Is it 28?
Oh, 39. Yes. Ex parte kotilva.
Ex parte kottidro, first appellate court kottittu. Both on considered, they have rejected it. On the ground that there's a dispute
Yaar
as to.
kottidro?
Trial court has also granted, first appellate court also granted.
What's the problem now?
No, then, but after main matter, both the courts have rejected temporary injunction. Ex parte granted.
Ex parte granted after
Petition,
hearing rejected.
application rejected. Appeal ex parte granted. Appeal rejected. Because the case is, my lords, I'm saying Schedule A and Schedule B are the properties. Schedule B is created subsequent to the filing of my earlier suit against the
You
defendant.
serve on the respondent. Yes.
They are on caveat, my lords.
Where is it? Idara. Where is the caveat?
Ms. K. Harish, advocate for caveator number 2.
On password ಮಾಡುವ.
Please.
Yes. ಬರಲಿಲ್ಲ ಅಂದ್ರೆ I will grant. Yes, next. Oh, this is section 10.
This is section
Yes.
10. Lords.
Both are different.
No, my lords, kindly see, my lords.
Anyway, I'll take this on Wednesday. Tomorrow we'll pronounce on section 10.
Great.
Next.
30.
Petitioner, suit, plaintiff's petition, suit for injunction. The suit injunction was granted.
1 minute. Emergent notice to the respondents. Petitioner is at liberty to serve on the counsel or represent the respondent. A injunction granted by the trial court shall continue during the pendency of the subject petition. List the matter on 25th. Next.
Lords,
31, my lords.
Same on the order ಮಾಡಿದ್ದೀನಿ.
Please, my lords. 15406 of 2025.
ಅದು 15406 of
2025. That was passed on 4th of this month, my lords.
ಅದು ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ?
ಇನ್ನ ಅಪ್ಲೋಡ್ ಆಗಿದೆ, ಬಟ್ ಇದು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ. Lords, other matters are listed today, my lords.
Correct. ಎಲ್ಲ serial numbers ಹೇಳಿ first.
Serial number 31 is this, 35,
35,
36, 41, 42, 44, 45 and 46, 7.
ಬರ್ಕೊಂಡ್ರೆ ಎಲ್ಲ ಬರ್ಕೊಂಡು. Same order. 15 number 15406 of 2025. Same order. Yes. Next.
32.
Petitioner.
May appear for the
Lord, I
respondent.
verified it, Lord, being in the
600
office.
975.
My lord, in fact, my lord, I was verified in the office. There doubt, my lord, expressing doubt in issuing that kata. Any of the circular not issued in 2014. In fact, not in the suit, my lord, they relied upon site number 5. In fact, the kata issued, my lord, in respect of 6/1. In fact, the bifurcation of kata is, my lord, prohibited by virtue of circular, not issued by the BBMP in 2014.
Whatever, all that is there.
Please me. In fact, not there is no basis and there is no document produced before the trial court, not substantiate in respect of not claim number 6.
Yes. Anything else, sir?
Please.
My lords may kindly come to annexure B for a moment, my lords. Page number 30. My lords may kindly come to para number 3.
So what is the problem if he comes on record?
No, none of the parties in the suit have sold any property to him, my lords. I have filed a suit against my father and my siblings. I have
You are
sought
the
for 1/9
adjacent
share.
property owner.
Please, madam, I am the adjacent one.
ಅದರ ಪ್ರಕಾರ ನಿಮಗೆ 975 ಇಲ್ವೇ ಇಲ್ಲ ಅಲ್ಲಿ.
My lords may kindly
Item
come-
number 6 at page 38.
Please, my lords. For a moment, that item number 6 arises out of a partition deed, which was allotted to my father by way of a partition.
Correct.
In 2004.
ಅಲ್ಲಿ measuring 957 square feet.
Please, my lords. So in the partition deed also, if my
Now this person claims that he has. What is your claim?
Well, I am the neighboring, my lord. I am produced, my lord, 2 sale deeds. Where, my lord, towards
What is
southern
this
side-
page 104?
Please.
104 in.
Not 10.
Item number 7.
Not 104. Not original is 103. A typed copy of not 104.
All right, 103, 104.
103. Milad, I'm situated milad towards southern side. That's southern Muniappa.
Tammaya Bhairappa yaridu? Tammaya.
Tammaya milad is the defendant number 1.
Huh.
Milad, I have purchased from Muniappa towards southern side. Muniappa.
Annexure G is his sale deed, my lord. Page number 79.
From whom, my lord, I have purchased?
Now, order 1 rule 10 is rejected.
Please, my lord.
Correct.
Annexure A, my lord. Para number 20 for a moment.
My lord, rejected. My lord, the reference my lord given at page number 26. My lord, whatever the objection my lord filed by the defendant by plaintiff, my lord, reiterated my lord, page number 20, para number 20, my lord, it is came to be rejected. On the ground that my lord, I have to file a separate suit.
My lords, my kindly.
Yes, sir.
In fact,
it's a suit for partition.
Please, my lords.
ನೀವೇನ್ ಮಾಡ್ತಿದ್ದೀರಾ ಅಲ್ಲಿ?
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ನನ್ ಪ್ರಾಪರ್ಟಿ ಸೇರಿಸ್ಕೊಂಡು ಕ್ಲೈಮ್ ಮಾಡ್ತಾರೆ ದೇರ್ ಎಕ್ಸ್ಟೆಂಡ್
Not
ಓನ್ಲಿ
at all. Yes. You're a rank stranger. You file a separate suit.
My lords,
I have to include my lord all
You're
the
a rank
parties.
stranger, sir. Partition suit ಅವ್ರದ್ದು ನೀವೇನ್ ಬಂದಿರ ಇಲ್ಲಿ?
ಅಲ್ಲ I have to file my lord separate suit. My lord, I have to make all them as a party.
Federal relations ಇದ್ರೆ ಮಾತ್ರ and impleading
ಅದು
application.
ಗೊತ್ತಾಯ್ತು. Judgment ಏನ್ ಬೇಡ. Yes.
My lord, if they restrict my lord to an extent of 600 square feet, I have no issues. My lord, they have included my 357 square feet.
Separate suit ಹಾಕಿ ಸ್ಟೇ ಮಾಡಿಸಿ.
My lord, I have to challenge my lord entire suit, partition suit. I have to challenge. I have to make all the parties. And
Partition suit. Okay.
Well, may make one submission. Well, just I will take my lord only 2 documents. My lord, for my lord, along with the plaint, they my lord, their claim was based on not page number 103.
ಅಲ್ಲ entire 957.
just
Entire 957 square feet.
Please.
Is item number 6, which is in the partition.
Please, not on the
All
basis.
right. And you are claiming some 357 square feet on the basis of this panchayat something, which you have purchased 600 square feet new purchase ಮಾಡಿದ್ದೀರಾ?
Adjoining land.
Adjoining.
Adjoining.
land.
Further side of the
ಬರಲ್ಲ
property.
ಬಿಡಿ.
On the last occasion, my lords had asked me to provide a document to demonstrate that the BBMP has issued 957 square feet, which is standing in my name. I have produced that.
ಅದನ್ನ ಇವರು ಕೊಟ್ಟರು.
ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೇನೆ.
I have derived through a partition deed. Partition deed allu it is mentioning the same square feet.
But the number
957 ಅಂತಾನೆ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ.
ಅಲ್ಲ ಇದೆ, but ಆ ನಂಬರ್ ನೋಡಿ, ನಂಬರ್ ಬೇರೆ ಇದೆ, 5 ಇದೆ ಅದರಲ್ಲಿ, 6 ಇಲ್ಲ. ಪಾರ್ಟಿಷನ್ ಡೀಟೇಲ್ 6 ಇದೆ, 5 ಇದೆ.
Partition suit ಅಲ್ಲಿ you don't interfere.
He is a purchaser in the year 2023. His vendors have not questioned me. Today all of a sudden he comes and knocks the door.
Yes, sir. Anything else?
No, liberty to file separate suit, I will
In law you have to do it. Yes.
Please. If that is the case,
Learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and avail of such remedy as is available in law. Reserving such liberty if available in law, petition stands disposed.
Please.
Yes, next.
33.
That's appearing for the respondent merits.
Against the judgment and decree for declaration and possession, my lord, I have preferred an appeal, regular appeal before the first appellate court, wherein, my lord, I had filed an application for stay of the further proceedings pursuant to the decree. That application, my lord, came to be rejected. Against which, my lord, I am before your lordship. Order, my lord, at page number 17 may kindly be seen. The appeal has been filed in the year 2023, in the month of December 2023. And after some time, my lord, it was not mentioned or it is not moved. That application was not pressed for consideration because there was no execution petition pending. And after the execution petition came to be filed, my lord, I have pressed the application for consideration. That application, since it is not moved for 1 year, it has been rejected on that ground.
Yes, not only on that ground.
Only on that ground. Page number 17.
ಇಷ್ಟೇನಾ?
ಅಷ್ಟೇ ಸರ್. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
Yes, sir. We'll send it back.
My lords, kindly bear is the order sheet, my lords. The appeal was admitted in the year 2024 and the TCR was called. And from 1 year, my lords, they are not addressing the final argument at all, my lords. After filing the execution case, they pressed on ILA and thereafter the IA order was passed.
Let the court pass orders on merits, not this perfunctory order. We'll send it back. The petitioner
is before the petitioner is the description ಮಾಡಲ್ವಲ್ಲ
Defendant number 1 and 2.
ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ಸರ್ ಕಾಸ್ಟೇಟ್ಲಿ ಅದು ಹೇಳ್ಕೊಡ್ಬೇಕಾ The petitioners are defendants 1, 2 and 3 are now calling in question an order dated 3/11/20 order dated ಏನಿದು 17/4/2025 by which the application filed by the petitioner son I-1 of 2023 seeking stay of the order in decree, judgment and decree passed by the concerned court in OS 48 of 2016. The said application is rejected by the first appellate court in RA 24 of 2023 by the following order. Page 16 to 18. A perusal at the order so passed is indicative of the fact that what has weighed in the mind of the first appellate court is that the application was filed by the petitioner on 3/11/2023 and has not been moved, and it is moved. It has not been moved for a long time, and on 16, and only moved in the year 2024. Therefore, it would not merit consideration. The reason so rendered by the concerned court to reject the application seeking stay of the judgment and decree does not inspire a semblance of confidence, as there is no reason rendered on the merit of the matter except the statement that the trial court records were called. The petitioner is not willing to argue the matter on its merit, and now after a lapse of 1 year, more than 1 year, the appellant has come up with the application seeking stay of further proceedings of judgment and decree in OS 48 of 2016. In the light of the order impugned being perfunctory and laconic, I deem it appropriate to set aside the same and remit the matter back to the hands of the concerned court to pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order. It's made clear the court has not considered or pronounced upon the merit of the claim of the petitioner or the respondent.
Let it be considered, but let them address the arguments, because it's been
consideration of the application shall happen within 15 days from the date of receipt of the copy of the order, and it is made clear that the consideration of the application should not become a ruse to drag the proceedings. Yes.
Let there be a time period.
15 days ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
Yes. Execution petition
For
is for day of tomorrow, my lord.
It's still in
there
notice
may
stage,
going to
my
be
lord. Notice
an
has
order
been issued.
not to precipitate the.
Don't worry. Yes, 15 days almost.
ಅಲ್ಲ possession ಇದೆ ಸ್ವಾಮಿ.
ಅಲ್ಲೇ ಕೇಳಿ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಮುಗಿದೋಗ್ತಾ ಇದೆಯಾ?
ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಮಗೆ
ನೋಟಿಸ್ ಆಗಿದೆ,
ಮುಗಿದೋಗ್ತಾ ಇದೆ.
ನೋಟಿಸ್ ಬಂದಿದೆ.
ಮತ್ತೆ ಬರ್ಲಿ
ತಿರ್ಗಿ ಅಲ್ಲ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಕೊಟ್ರೆ
ಅದು ಆಮೇಲೆ ತುಂಬಾ ದಿನ. ಡೋಂಟ್. ಎಸ್.
34
ಒಬ್ಲೈ.
Why order 5 rule 20 is rejected?
What, no, Lord, order 5 rule 20, Lord, what happened was, the suit is filed in 2020. Lord, application for impleading, Lord, of the petitioners, Lord, is filed. Lord, what happened, the financial institutions, Lord, also sought to be impleaded. Lord, suit is only for a declaration that she continues to be a partner of the firm. Lord, everybody sought to be impleaded, including bank officials. They took out multiple paper publication. We filed a suit for injunction, and injunction has been granted. Normally, what they do is, Lord, in this application for impleading, Lord, the bankers, Lord, in fact, the trial court had passed an order at page 139, if not, so kindly see. They did not take proper steps, and they want to take out paper publication because there's an order of injunction in the other cases.
Now your defendant number?
But I am not proposed defendant in the matter. Number at page 139, if my lords may please turn to.
All are proposed defendants.
Yes, but all proposed defendant. Andre namma bankers, not they want to implead in the suit. Suit, not kindly see the preamble, not it is only for a declaration that they are partners of not the respondent partnership firm.
They are the plaintiff is the home buyer.
No, my lord. Plaintiff not claims to be a partner. Please turn to page 106. She claims to be a partner of a partnership firm. That is defendant number 3 therein. Page 106 is the prayer.
What is the privity of contract between you and
It is
the
not there,
plaintiff?
Lord. There is no privity of contract.
No, with whom is the contract?
Contract, Lord, in fact, she was not no more a partner of the firm.
No, no, with whom is the contract?
Contract, Lord, she claims, Lord, as against, Lord, the defendants 1 and 2.
1 and 2, yeah.
1 and 2, Lord, are one Mr. Gopal Reddy and second is, Lord, B.S. Shiram. She says, Lord, she is a partner of the third defendant. Page 24, Lord, is the original
And
plaintiff.
these are companies owned by you.
But these are different companies which are LLPs, companies which are incorporated.
They are all
Yes.
owned by you.
Now,
All
Lord, she wants to say everybody falls under this
Concord Group.
partnership.
Owned by you.
Now everything, Lord, she says they fall under this. She wants to implead me. Lord, that, Lord, issue is pending separately. Now she wants to implead, Lord, all the bankers, Lord. That is the allegation in the application.
Where is that application?
But that application, Lord, should get it.
Now, what are you challenging?
But I'm
Impleadment
challenging
of
the
bankers
order
or
that-
impleadment of Concord?
No, Lord, I'm challenging the order wherein, Lord, the court says take out paper publication.
So what?
But the issue of paper publication, in fact, not earlier, the application, Lord, was recalled and the court said, let me first hear whether the application should be considered.
Where is
Whether
that?
Page 139, Lord, please turn to. But whether the bankers are required as a party, but court can hear while before issuing notice on impleading
Now,
application.
you are not aggrieved by the other order of Concord being bought in.
No, that note is challenged and there's an interim order.
Wait, writ petition.
Please note, that is page 110, Lord should get it. Stay.
110.
I'm sorry.
Case status.
I'm sorry.
Idena?
Page 66, Lord. I'm sorry.
No, it's writ petition. Na?
Howdu. So bottom of page 67, order dated 5/3/2021.
All right, we'll tag it and grant the same order. The learned counsel appearing for the petitioner submits, when identical effort was made by the respondent to drag in every person of the Concord group, this court in writ petition 1485/2021 has granted an interim order of stay, and the same is continued from time to time, which is in subsistence. Therefore, tag this petition along with 1485/2021, list them both on 25th. Emergent notice to the respondent in the light of the interim order subsisting in the companion petition, there shall be an interim order in the case at hand
I
as
don't
well.
think it is continued thereafter in that matter. The issue is slightly different in this.
Continued.
Whether or not interim order is continued, not the.
Allah, is it vacated by?
It is not vacated,
then-
but there is no continuation.
In the
to
light of
orders.
Beda, there shall be an interim order as prayed for till the next date of hearing.
Please.
Yes.
Section 37.
Pension papers. Muralidhar HM. Nimda. Yes, sir.
For the petitioner, my lords. We have challenged annexure A, my lords.
Are you ready?
I'm ready.
Pass over. Yes. We'll hear it. Wait.
My lords, small submission, my lords, not for the entire argument. Sir. Annexure A is just a letter given by the administrative branch to prepare the pension paper, my lords. There is no order passed by the executive authority, my lords.
No.
Wait. Pass over. Yes. Yes, next.
38.
Vivekanand, refund of court fee.
Yes, my lords.
Just let him come. Vivekanand. Yes.
This is a case where a memo for withdrawal of the suit was filed. And, the plaintiff was.
No, was it suffering from want of jurisdiction?
According to them, the civil court lacked jurisdiction because.
If it is a court without dehors jurisdiction, then.
The best course of action should have been filing an application for return of client with permission to present
So
before the
whatever
proper
course
court.
of action it is,
Section
the
6.
question, if the question is the court has no jurisdiction to try the suit, and if it is correct, if the court has held it to be correct and transferred the suit to an appropriate jurisdiction.
If it were to be an order transferring the suit to.
Now what has happened? Withdraw madida.
It is just withdrawal, therefore the withdrawal of
Where
the
is
suit.
the memo for withdrawal?
It's, that is produced, my lords, along with the.
Which is
That is a
Delhi High
page
Court
one.
judgment you have given?
Page 107, my lords.
101.
101.
Yes, my lords.
Yes.
My lords, judgment compilation, page number 8. Delhi
Affidavit
High
and-
Court judgment, my lords,
One
Amit
minute,
Jain
one
versus-
minute. Amal, where have you preferred DRTA?
Yes,
Gone
my
before
lords.
the DRT.
Yes, my lords.
Sir, civil court has no jurisdiction at all.
It's, here there
In
is
a
no.
proceedings as arising out of the Surface Act, civil court has admittedly no jurisdiction. The settled principle of law.
My lords,
ಇವ್ರೇನೋ
RDBI.
ಗೊತ್ತಿಲ್ಲದೆ ಅಲ್ಲೋಗಿ ಹಾಕಿದ್ದಾರೆ ಏನ್ ignorance of law. Which is that judgment?
My lords, judgment compilation, page number 8, my lords.
Page?
Page number 8, judgment compilation.
Judgment compilation, which is that?
On previous date, my lords, I have filed it.
All right, yes. That's what Amit Jain.
Yes, my lords. My lords, para number 10, my lords. Page number 11.
Yes, sir. Anything else?
There is one judgment, my lord, of the
Pudi.
Delhi High Court. Whether the request, my lord, made by the petitioner plaintiff for refund of the court fee would
Under
come,
what
would come within the
circumstances?
ambit of section 66.
No, correct, 66, 66A.
Yes.
Now, this, under what circumstances was this passed? Here it was a settlement under section 89 of the CPC where it was closed pursuant to mediation.
Yes.
There definitely refund of court fee.
No, let's say what the Honorable Supreme Court has said is, my lord, para 20 minutes.
ಇದೆಲ್ಲ ಹಳೇದು
Such-
2021 3 SCC ಇದೆ.
Let's say,
Justice
last three
Mohan
sentences,
Shantangoda.
last three sentences, my lords, of para 21.
Hmm.
However, as held by the division bench of this court in Syed, para 21, 20 minutes.
Yes, sir.
If the element of provisions are not satisfied, then the refund in terms thereof cannot be granted. It may be then examined as to whether the conditions laid down in section 16A have been fulfilled, so as to grant refund of 50% of the court fee paid. If the prayer is not as required under sections, the provisions of section 66, it's the refund of court fee, my lord, is not automatic, my lord, is my submission. And further, there is
So
no
they have to
material.
make a separate, they have made a separate application now.
No orders are passed on that application. Let's.
Where is the application filed by you later after withdrawal of the suit?
101, my lords.
Page?
Page 101, my lords.
No orders are passed on this?
This was filed, my lord.
One order was passed, my lords.
This is
Page
withdrawal of
110,
the suit,
my lords.
madam. In this you have claimed refund of the court fee?
Yes, my lords.
Where is it?
105.
Plaintiff is also filing another application seeking refund of court fee paid at the time of institution of the suit. Where is that application?
My lords, page number 105, my lords.
What happened to this application?
My lords, impugned order was passed, my lords, page number 117, which mentions that hereby directed the office to deal with the issue with respect to the court fee as per the law. Page 117, last line, my lords.
While memos accordingly suit plaintiff dismissed is not pressed, hereby directed the office to dealt with what syntax is this? Deal with the issue with respect to what did the office do?
My lords,
Office
page number
note, next page,
118,
my
yes, my lords.
Section 66, no provision to refund in case of dismissal of a suit. Salpa kashta ala.
But after, my lord, withdrawal of the suit.
That is true. If it was a court with jurisdiction and they have just like that withdrawn the suit, then definitely they cannot. It was the court which had no jurisdiction even to entertain the plaint.
But even here, my lord, there is no proof that after withdrawal of the suit, they instituted a proceedings before the other authorities, the other
DRT
forum.
hakilwa. You have not approached the DRT. They bank, sir, they would have gone immediately.
In the writ petition, my lord, there
Surface proceedings before the civil court is admittedly not maintainable.
Manoj, OA number 1235 of 2025 and.
They had to prefer an original application before the court. If it's a borrower, it is SA. If it is the lender, it is OA.
an order should have been passed on the application regarding maintainability of the suit, then my lord, it would a different circumstance.
No, but
What
the
happens?
affidavit in support of the withdrawal clearly says the suit is
Correct.
not maintainable.
Correct. That is there. That is
Court does not pass an order. In terms of the memo, it is withdrawn. What do you mean?
But in all cases where simple withdrawal of suit, my lord, ought to be-
Simple withdrawal, not at all. I will qualify saying that if it is a question of jurisdiction and the court does not have jurisdiction to entertain or not competent to decide the issue, then refund of court fees.
Manoj, we have filed judgment of this honorable court also, Narayan Murthy versus Registrar of Debt
Page,
Recovery Tribunal.
madam.
Manoj, separate memo is filed with the judgment.
Elladukku separate memo. Which memo?
Same date, Manoj, I have filed one paragraph number 25, Manoj.
That's following Amit Jain
Yes, Manoj.
and several other judgments. Is there anything else, sir? We'll close these. All three common orders. Three nights. How many matters are there?
Three matters.
3.
Petitioners in all these cases is the HDFC Bank. The bank is calling in question an office note by the registry of the concerned court, which directs that there is no warrant to refund the court fee in the light of the dismissal of the suit. The petitioner is heard so and so. As observed here in, the petitioner is the bank. The respondent initiates certain proceedings for recovery of the money, money that it had lent to respective borrowers by instituting a suit in OS 3785 of 2023 on 20th June 2023. It transpires that the amalgamation of the bank takes place after the institution of the suit on 6th November 2023. The amendment was carried out before the concerned court on such amalgamation on 19th June 2024. The bank then files an application, files a memo or slash application other.
Application.
Files an application seeking withdrawal of the suit on account of the fact that the civil court had no jurisdiction to entertain the proceedings that ought to have been instituted before the Debt Recovery Tribunal under the RDB Act. The concerned court allows the application seeking to withdraw the suits and leaves the issue of court fee to the registry to decide. The registry then, by its office note dated 22/1/2025, rejects the application insofar as it concerns the refund of court fee. It is this that has driven the bank to this court in the subject petition. The learned counsel appearing for the petitioner would take this court through the application seeking withdrawal of the suit to contend that a separate application seeking the refund of the court fee was also made. And in the application, it was clearly narrated, in the affidavit in support of the application, it was clearly narrated that the concerned court had no jurisdiction or competence to try the suit. The learned counsel would seek to place reliance upon a judgment of the High Court of Division Bench of the High Court of Delhi and that of the coordinate bench of this court to buttress her submission that the refund of court fee is a consequence of the fact that the concerned court had no jurisdiction to try the suit. Per contra, the learned counsel
First respondent.
The learned counsel for the first respondent, Shri T.P. Vivekanand, would submit that refund of court fee cannot be done in cases where they have filed a memo for withdrawal.
In cases where a plain memo for withdrawal is filed, refund of court fee, directing refund of court fee will have a catastrophic effect, as every suit that is withdrawn will come up with an application seeking refund of the court fee. He would submit that the order or the office note of the registry would not warrant any interference, as the application admittedly filed is contrary to the language of section 66 of the Karnataka Suits and Violation Act,
Court fees and suit
Court,
violation.
so and so Act, the Karnataka Court Fee and Suits Valuation Act 1958. I have given my anxious consideration to submissions notes. The petitioner bank institutes a suit in OS 3785 of 2023 against several borrowers who had the borrowers who had sought finance from the hands of the Housing Development and Finance Corporation Limited, the HDFC. The notice was issued in the suit. After the issuance of notice, the Housing Development Finance Corporation, HDFC Corporation Limited, gets merged with HDFC Bank. The suit is amended. The petitioners file an amendment seeking modification of the cost title, which is permitted. When the HDFC Bank comes into picture, it is noticed that the suit that they had filed for recovery of money, i.e. the loans advanced to the borrower, was not maintainable before the concerned court, as they had to approach the debt recovery tribunal. In that light, an application comes to be filed before the concerned court in IA1 seeking withdrawal of the suit. The affidavit in support of the application reads as follows, page 102 to 103. The affidavit in its narration was unequivocal that there is a bar on jurisdiction with regard to the suit, with regard to the concerned court deciding the suit, and it had to be preferred before the competent tribunal. Another application is filed seeking refund of the court fee. The application is verbatim similar, except refund of the court fee that is sought for. The paragraphs which concern refund of court fee in the affidavit reads as follows, page 108. Pursuant to the affidavit so filed, the memo is filed for not pressing the suit. The memo reads as follows, page 110. On the said memo and the affidavits, the concerned court passes the following order, dismissing the suit on such memo for withdrawal. The order reads as follows, 117. The concerned court directs the issue with regard to refund of court fee to be dealt with by the office. The registry issues an office note which reads as follows, 118. The registry declines to grant the refund of court fee owing to the rigor under section 66 of the Act, as the suit had been dismissed. The issue is whether dismissal of a suit on account of a memo for withdrawal being filed by the plaintiff would entail automatic refund of the court fee. The issue need not detain this court for long or delve deep into the matter. The issue The High Court of Delhi in so and so has held as follows. Where is that judgment? Para 2, para 6 and paragraph 10, 9 and 10. Against the said order of the division bench, the respondent therein had preferred an SLP in SLP 18102 of, SLP another?
Manoj, this is a different case.
Oh, that's a different one. Why are you?
Yes, Manoj.
The so and so. The said judgment of the division bench of
the High Court of Delhi is said to have become final. A little earlier to the said judgment of the division bench of the High Court of Delhi, the apex court in so and so, to the page 13 of the memo, so and so is held as follows. After the aforesaid orders, the coordinate bench following all these orders has held as follows. In the case of so and so 11, 2024 SSC online SC 1309.
Paragraph number 25, Manoj.
Para
25.
25 matra haki saku. A perusal at the new one,
That is,
we'll see. A perusal at the aforequoted orders of the apex court, the High Court of Delhi, and that of the coordinate bench, what would unmistakably emerge is when the court does not have competence to try a suit and the suit is preferred before it, and the suit is withdrawn on a memo on the question of jurisdiction of the concerned court to try a suit or competence to try a suit, refund of court fee is axiomatic. Not in all other cases where the suit is dismissed on a plain withdrawal of a memo filed by the plaintiff. This is the only qualification that would emerge in the only qualification / clarification that would be necessary to be rendered. In the light of the rendered sounds, the learned counsel for the respondent has relied on the judgment of Division Bench of Delhi High Court, which directed 50% of the court fee to be
following the earlier judgment.
Refunded on certain circumstances. The said judgment is distinguishable with to the facts obtaining in the case at hand without much ado, as the issue therein was with regard to settlement under section 89 of the CPC, which is not the case at hand in the subject petition. The subject petition is plain and simple that the concerned court did not have jurisdiction to try this suit. If a concerned court does not have jurisdiction to try a suit and the suit is instituted, a suit is instituted and withdrawn on the question of jurisdiction, the order that is passed by the concerned court or the registry in the office note is on the face of it erroneous. The petitions thus succeed and the concerned court is directed to refund the court fee that was paid at the time of filing, at the time of instituting the suit, which has now stood withdrawn, ordered accordingly.
Permitted to file wakalat minutes within 2 weeks.
No,
not yet filed.
The learned counsel TP Vivekanand is permitted to file his memo of appearance of wakalat. File his wakalat in the next 4 weeks.
Next.
39.
So, it's petition against the order rejecting the filing of additional documents.
Emergent notice to the
His
respondent.
Lordship, the matter is posted on 11/6.
Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represented the respondent in the trial proceedings. List on 27th. There shall be an interim order of stay of further proceedings before the
One
concerned
submission,
court.
Lordships. Matter is posted on 11/6 of this month for
You don't
final
want to stay?
arguments. Yeah,
You don't want to stay?
I want to stay.
So, further proceedings shall remain stayed. Yes. List on 27. Next.
40.
This case, my lord.
Order 14, Rule 5.
Yes, my lord. In the written statement, my lord, the defendant taken several contentions. They said that, my lord, my property, my lord, they have contributed the amount to the purchase of my property. And second, my lord, the B schedule property is the granted land of my father. They said, my lord, we have given application in the name of my father, my lord. And my lord, all the properties are the joint family properties and tell.
Anyway, you serve on him and get it.
Please.
Counsel for the, who is the contesting defendant?
Contesting, my lord, I have, my lord, 1 to 7 dispensation actually. 8 to 17, my lord.
Counsel for the petitioner has filed a memo seeking dispensation of issuance of notice to 1 to 7. The memo is accepted, service dispensed.
service of notice dispensed at the risk of the petitioner. One emergent notice to respondents 10 to 17. The petitioner shall serve on the counsel who represents.
8 to 17. 8 to 17.
8 to 17. Okay, serve on the counsel who represents the respondent in the trial proceedings. List on, ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ ನಾಳೆ ಸರ್ವ್ ಮಾಡಿ.
ಮಂಡ್ಯ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಮೇಲೆ
ಅಯ್ಯೋ
ನಾನು ಅದನ್ನ
ತುಂಬಾ ದೂರ ಐತೆ.
ರೆಡಿ ಮಾಡಿ ಕಳಿಸ್ಬೇಕು.
ರೆಡಿ ಮಾಡಿ ಕಳಿಸಿ. List the matter on next Monday. Yes, next.
41, 42, adjourn 43.
Petitioner, an order directing payment of duty and penalty. I pass on the judgment of the apex court. I made an.
It has no 33 ಅಲ್ಲಿ no power to determine. Don't worry.
My lord, may I pass on one judge, the judgment.
I am speaking in your favors. Badwa. Yes. Question ಕೇಳಕ್ ಮುಂಚೆ ಉತ್ತರ ಕೊಟ್ಬಿಟ್ರಿದೆ ಆಗ.
Sorry.
Yes. The petitioner is before this court, calling in question an order of the concerned court which determines the penalty that is to be paid on the instrument. The determination of penalty by the concerned court is admittedly erroneous. Should have referred the matter to the competent authority for determination of the penalty. In that light, there shall be an interim order of stay as prayed for till the next date of hearing.
Except respondent number 1, other respondents I am seeking dispensation I have mentioned in the petition also. I'll file a memo.
Where is it?
Under the cause title itself. Immediately.
A definite number?
My lord, respondent number 2 to 32, my lord.
2 to 32 Badwa.
They are ex parte before the trial court.
The learned counsel for the petitioner submits that the respondents 2 to 32 have remained ex parte before the concerned court, though therefore notice we issued to respondent number 1. The petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings. Yes, list on 4th. Next.
Objection.
Dispense with. Memo finding in the. Yes.
40, 44, 45, adjourn 46.
My lord, the appeal is the writ petition by the defendants against the divergent findings.
43-1.
Yes, ma'am. The trial court has discussed all the documents and said and dismissed the application. But the first appellate court, without looking into those documents and referring to, my lord has reversed the order by allowing the appeal, against which my lord the present writ petition is filed. My respectful submission to my lord is there is nowhere in the plan or anywhere it is shown as a
Will direct status quo to be maintained.
My lord?
Will direct status quo to be maintained. Bedwa?
I leave it. I have sought for stay. I leave it to my lord.
Well, let them come.
My
Yes.
lord appeals, because reason is they were not at all. There is no road at all. There is no passage, no nothing of the kind in my lands, and that too the plaintiffs are 18. All of them wants to move into my land.
The emergent notice to the respondents. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. Status quo as obtaining today be maintained by the parties till the next date of hearing. List on 25th.
Please.
Yes. Next.
47, adjourn 48.
Password.
49.
Where is the order? Separately anta ide order ellide?
That itself is an order.
Huh?
This is
That itself is an order.
Yes.
Vide separate order anta melide ellide adu?
43, 44.
43
and 44. Page 43 and 44.
This is the order.
Yes, ma'am. Without providing an opportunity, but straight away.
1 minute. Emergent notice to the respondent. Petitioner shall also serve on the counsel who represented the plaintiffs before the concerned court list on 2nd July till such time further proceedings before the concerned court shall remain stayed. Next.
50.
Take a decision to hold election. They don't conduct.
Correct.
That's why I'm before.
Election ಬೇರೆದ್ರಲ್ಲಿ ಇನ್ನೊಂದು proceeding ಇದೆಯಲ್ಲ ಅದೇನು?
Please, minutes.
What is the other proceeding?
No, this arising out of the same minutes.
Ah,
Yes, please.
yes, sir.
Kindly see minutes of the page 31 for a moment. Same proceedings.
No, no, there is one more I read. Where is the order?
Order is at page 31. 17/12/2024 is the first order. And the second order is 23/1/2025.
ಇಲ್ಲಿ ಯಾವುದೋ ಒಂದು ಪ್ರೊಸೀಡಿಂಗ್ ರೆಫರ್ ಮಾಡ್ತಾರಲ್ಲ ಅವರು.
ಇಲ್ಲ ಅದರಲ್ಲಿ ಇದು ಎಲೆಕ್ಷನ್ ಮಾಡೋದು ಅಂತಲೇ ಮಾಡ್ತಾರೆ.
ಆಯ್ತು, ನೋಟಿಸ್ ಮಾಡು. ರೆಸ್ಪಾಂಡ್ ಸರ್ವ್ ಮಾಡಿ.
They also admit. ಮಾಡ್ತೀವಿ ಅಂತ.
You serve them.
Yes.
Emergent notice to the respondents returnable by, you'll serve them by any other means?
By hand also minutes.
The petitioner is also at liberty to take out hands, shall also serve the respondents by way of hand summons put up immediately after service of notice.
And also minutes I may be permitted to serve on the councils who are representing them.
Hand summons.
Hand summons to the parties.
Saku, yes. Next.
51.
For the petitioner.
Will direct passing of the order.
Please, ma'am.
Yes. The petitioner, plaintiff is at the doors of this court seeking a direction by issuance of a writ in the nature of Mandamus to the concerned court to pass orders on application filed by the petitioner under Order 39 Rule 1 of the CPC seeking temporary injunction. The narration in the petition is that the concerned court yavat hakiddu?
It is filed on 9 May 2024, my lords.
The learned counsel takes this court through the order sheet maintained before the concerned court to demonstrate that though the application was filed on 9/5/2024 till today, the concerned court has not passed an order on the application on Order 39 Rule 1 and 2. In that light, I deem it appropriate to dispose the petition answering the prayer and directing the concerned court to pass necessary orders on IA2 in order filed under Order 39 Rule 1 and 2 in OS 124 of 2024 with an outer limit of 15 days from the date of receipt of the copy of the order, if not earlier, ordered accordingly. Yes, next.
52.
Injunction has been ordered against Mullard injunction.
Correct, concurrent, ಎರಡು ರಿಜೆಕ್ಟ್ ಮಾಡಿ.
Please.
ಅದಕ್ಕೆ ಬಂದಿಲ್ವಾ?
ಬಂದಿಲ್ಲ.
ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ. Yes.
53.
Lord, I'm the purchaser of property.
Correct,
Lord.
despite withdrawal, clubbing of suit.
Please.
Yes.
Straight against the judgment of the.
Judgment act ಬೇಕಾದ್ರೆ. Yes.
Honorable, Lord, I have quoted.
Emergent notice to the respondent. Two suits are instituted. One in OS 571 of 22 and in OS 307 of 23. An application is preferred by the defendant seeking clubbing of the two suits under section 24 of the CPC. The said application, before the application could be answered, one suit in OS 307, OS 307 is withdrawn by the plaintiff. Despite the said withdrawal, the court orders clubbing of the suits, clubbing of a non-existing suit, clubbing of the suits in that the withdrawal is not answered.
Withdrawal is not.
Without answering the memo for withdrawal that is filed by the plaintiff, the order is clubbing of the suit. In that light, there shall be an interim order as prayed for. Yes, next.
54.
Emergent notice to the respondent. No? Yes, next.
Pay for the plaintiff, my lord.
Notice order 1 Rule 10.
No, my lord, order 6 Rule 17.
ಯಾವ್ದಿದು? 54. Already. Order 6 Rule 17.
Order 6 Rule 17. Preliminarily, my lord, she had deleted the property
After issues were framed, my lord, once again, now they are seeking to insert the property. It is the
Second,
self-applied.
after issue, second application.
Yes, ma'am. Not the application, my lord. At the time of filing of the plaint itself, it was there. They got it deleted.
But they want to
Now they want to read.
So what?
Lord, issues have been framed. Suit was filed in the year 2020.
So what?
What?
Yeah.
Non-speaking order also.
That's all right. Yes. They ವಾಪಸ್ ಕಳಿಸಿದ್ರು ಅದೇ ಆರ್ಡರ್ ಆಗುತ್ತೆ. Withdrawal. Withdrawal or dismiss ಮಾಡಲ?
Dismissed.
Dismissed. Yes, dismissed. Next.
55.
Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent. The petitioner is before this court calling in question. Petitioner's plaintiffs are before this court calling in question an order passed under Order 6 rejecting an application filed seeking amendment of the plaint under Order 6 Rule 17. The amendment sought would not in any way change the nature of the suit. The rejection of it is on the face of it erroneous. In that light, there shall be an interim order of stay spread for till the next date of hearing, 30th June. Please, next.
56.
Order 1 Rule 10.
Order 1 Rule 10.
For
the respondent number 3, Lords, there was a suit for partition in separate possession, in which an application came to be filed for impleading. The facts is like this. One Chandrappa is the original propositor, and he had died, leaving behind.
Now, who is he? Australia.
We are disputing her entitlement as a daughter of the property.
No, on what the basis is the claim to get into the suit?
She says that she is also a daughter. She is entitled to a share in the property. Permit me to complete the facts.
Let it be adjudicated.
No, there is another suit pending, which I have brought to the notice of this honorable court, when which her status is under challenge. Whenever there's a status is under challenge, in section 34 of the Procedural Act, that required to be declared first.
Which is that?
Not that suit is I have produced before this honorable court that at page number. There's a suit in which that it's under challenge.
Why are you
441 of 2022.
Why are you afraid of the entry itself?
441. But the entry is because unless she has filed a suit in which it is under challenge. The entry, the reason
claims to be a daughter, that she is also entitled to a share in the property.
May no, permit me to put the points into perspective. There is a challenge with respect to her entitlement in this suit. With respect to her, without an entitlement, she wants to implead as a daughter, and that issue cannot be agitated in the suit.
Who has instituted a suit, her right or entitlement, or you against her? She has instituted.
No, she has instituted in which under challenge. Under section 34.
I have sought for partition.
She had sought for partition. I would request the honorable court to kindly look into page number 80 for a while. I understand this.
Yes, sir.
My lords, the prior therein is one for partition. In the suit, her entitlement is under challenge, being a daughter. Status is challenged. Once the status is challenged.
What status is challenged?
Her status as a daughter is challenged.
What suit is instituted by her?
Suit is instituted by her.
441 of 2022.
441 of 2022.
All right. There you have contested saying that she's not a daughter at all.
She's not the daughter. Her mother is not a legally wedded wife. And it is not legally wedded wife. She is not the wife even. That's what we are challenging the relationship itself. But kindly, when the status is challenged,
anything else?
Appropriate remedy would be she required to get it declared under section 34. Status required to get, unless declaration, she is trying to attempt into attending to enter into another suit, which is between us, between the mother and the daughter-in-law.
Her claim is also there.
But her claim required, her status required to be adjudicated. If she had added these properties in that suit, I have no objection. But kindly, this is a separate suit.
That is the next step they will take.
No, that should be the first step. Because whenever there's a challenge to the status, there must be a suit required to be converted for declaration first. Unless status is declared, the question of partition. Now, may kindly see the problem in this particular suit. I as a plaintiff, is required to seek a negative declaration that she is not the daughter. That would be the consequence in this suit. May kindly see this, because she is not in a position to come and seek a declaration as to her right in this suit, because she is only a defendant.
All right, You have set up that negative declaration in OS 441 of 2022.
I have not set up anything
So
over
what
there. I
else
only
have you
took
said? Written
up a
statement,
defense.
not the daughter, not
No,
the
no, I
mother.
took up a defense. She required to seek a positive declaration. But kindly see the nature
That is
of
what
the
she
prayer.
has filed for.
No, she is not filed for that.
Filed for
That's
partition.
precisely for that she is not filed for.
There are
But
prima
kindly the
facie
suit is
documents.
not converted yet.
Daughter entitled to a share.
If she is a
The
daughter, I have
legitimate,
no objection.
legitimate or otherwise will be
Lord,
decided.
legitimate, otherwise is also not there. We are very challenging the very relationship itself. If legitimacy is not the question here. My lords, the question, I would.
Birth certificate, my lords, 10th mass card, PUC, passport, everything, my
Court
lords.
will
That's
decide,
supposed
sir.
That,
No,
my
but
lords, I am the
that could be
daughter of
decided
CM
in other
Chandrappa.
suit. I am not saying it not be decided. Unless it is decided, she can't implead herself in this suit.
No, a rank stranger cannot come into the partition suit, no
Precisely,
problem.
Precisely.
Rank stranger alvala.
Other rank stranger, I can.
Say, yes, she is the daughter of Yaru.
JM Chandrappa. One
We
JM
are
Chandrappa.
disputing that itself. Not only that she is legitimacy is not the question over there in that suit. May kindly see the return statement. We are disputing the very marriage itself. Very marriage itself we are.
Dispute everything now.
I disputed in that suit. Unless that is decided, the question of getting into this suit. My lords, now she has been implemented as a daughter herself.
Not alive.
After his death only, my lords, all these
The
issues.
problem ಬರೋದಲ್ಲ ಅವಾಗ.
Please.
Death.
Unfortunately, he died during COVID, my lords. So he died intestate. During COVID, the father expired, intestate. That is when, my lords, thereafter I filed a suit in the year 2022 seeking for partition. Then, my lords, she is my grandmother. She files a suit. In my suit, my lords, she files a written statement that I am not her granddaughter and I am not the daughter of the father. And, my lords, thereafter they file, my lords, only with respect to some 8 schedules. They file a separate partition suit.
No,
Already, my lords, all these schedules are, my lords, part of my partition suit.
No, if these
So I
schedules
filed
are
an
not part of
impleading
the partition
application
suit, that's
seeking
what
my
kind of
lords,
problem we are facing. If these properties are part of that schedule, I have no objection virtually. These are independent properties, my lords. These are independent properties which we are claiming ostensible ownership over.
Now
there
that
of
is
the property.
allowed.
That application
That is
came
been
to.
allowed.
Return is allowed, nothing wrong with that.
My lords, my submission is only this much, my lords. Unless her status is declared, she can't enter into as a daughter into the suit. Because here I cannot establish that she is not a daughter. Because if she's been impleaded, as a plaintiff, I don't have any other prayer that could be sought for in this suit. Because that results in a negative declaration.
ಎರಡು ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳಿ.
ಎರಡು ಒಟ್ಟಿಗೆ
There are
ತಗೊಳ್ಳೋಕೆ
four
objection ಇಲ್ಲ.
There are 4 suits, my lords.
4 suits ಎಲ್ಲ try, let that be
And
tried.
there is a
altogether.
already there is a
In fact,
direction
there
by
is a
this
direction on
honorable.
this matter.
24
Already
application
there is a
ಹಾಕಿಲ್ವಾ?
direction by this honorable.
Already a direction.
There is already a
Anything
direction,
else,
we have
sir?
absolutely no issue.
Anything else?
No, nothing.
Dismissed.
Kindly.
What?
Lords, but unless her state, lords, let there be an observation at least. Her status required to be declared before granting it, because
there
she's
cannot-
been impleaded as a party to the
This
proceedings.
court has already directed all the suits to be taken together. Superfluous directions I will not.
And, my
give.
lords, dispose it off within a period of 1 year. There is a direction, my lords. That is why they file, my lords, this writ petition
Lords,
in order to protract the proceedings before the learned trial court.
No, we have not filed this application. We have filed this writ petition before this court.
It is Chandrapa's problem. He is not there. So let them decide. So what?
Whether they are the wife and daughter of Chandrappa is a
Everybody-
question,
See,
is a question which required to be decided.
No. Whatever Chandrappa has done, the others will definitely, properties ಎಷ್ಟಿದೆ? 60 ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇದೆಯಾ?
ಜಾಸ್ತಿ ಇದೆ. ಸುಮಾರು
There are about, my lords,
ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
there are-
ಅಲ್ಲ 18 schedule ಇದೆ. That's why the second wife, second daughter and all these things have arisen. They are content.
No. You don't give ideas. Multiple may spring.
They are spinning already. Spinning has already started.
But anyway, we'll see. There is nothing wrong in this order.
But she has been implemented as a daughter. That is the only submission that my problem is.
Impleaded ಅಂತ ತಗೊಳ್ಳೋಣ. Daughter, whatever we'll see.
But in the order it has been written.
Just
As a
because she
daughter, she is
one ನಿಮಿಷ.
entitled.
Just because she impleads as a daughter, she becomes the daughter without adjudication.
No, but that issue
Only
is,
entry, sir.
no, that issue cannot be decided in this suit. That is the
Yeah,
problem.
that's all right. Why? If she comes into the suit, you decide if it's not a daughter, not a daughter.
No, I am as a
Okay, if
plaintiff.
all the suits are taken up together, it will have a bearing. They are all,
Kindly, at least
they are
that.
all intertwined.
my lords, they are all
My
before the
contention
same
may
court,
kindly
my
be
lords,
noted.
and, my lords,
And that
been
then
adjudicated
Yes.
by the-
I can take up that contention at least in the trial court.
Yes, we'll declare 230.
Yes.
Next,
7.
But 230, I may be excused over there.
please don't. Yes. The burden is on me. Why do you? Yes.
My lord, 57, my lord, I seek for a short passover. My senior is held up in another court.
Where is Manu?
Sir is arguing a matter before the commercial court, my lord. It got taken up.
Commercial
on
court. Tell him it's dismissed.
He's on his legs, my lord.
Wherever he is, he's not in the high court.
My lord,
He's not in the High Court, alva?
not in-
Dismissed.
My lord, please, my lord, pass
He
over.
can't stand somewhere in the other court, in the courts, at the trial court, and say he's on his legs,
My
so
lord,
he take a
he's
pass.
on his way back, my lord. My lord, may kindly give a pass over.
Dismissed. When he comes, I'll recall it.
My lord,
So I'll pass over.
much okay.
ಹೇಳೋದಾದ್ರೂ ಪಕ್ಕದ ಎಲ್ಲೋ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು. Yes.
Allot three.
Notice served. Yes. The respondent appeared illala?
Illa.
KSIDC.
Yes.
IIDC.
Yes, I.
Petitioner to serve on the panel counsel representing the corporation KSIIDC and file an acknowledgement of such service with requisite set of papers. Put up, list the matter on 25th.
My lord, interim stay in the meantime.
On interim stay idea.
23rd is this.
Maybe list the matter on 25th bedanga 23rd. Yes.
Okay, obliged.
59.
My lord, kindly pass on, my lord. Senior held up in another court, my lord.
Pass over. Which court?
Court hall 12.
Court hall 12. You're smart. Yes.
60.
Here for the petitioner, as additional issues.
Order 14 rule for rejected.
Please, ma'am.
Emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. Petitioner is before this court calling in question an order which rejects the application seeking framing of formulation of an additional issue. It is rejected, though by a detailed order which does not inspire confidence. The additional issue ought to have, as sought for, ought to have been framed as the purport of Order 14 Rule 5 is that all the issues should be dealt together, including the additional issue that is sought for. In that light, there shall be an interim order of stay spread for till the next date of hearing, 27th. Yes, next.
61.
After issues up, before issues. Before issues. After
I'm sorry,
issues.
after issues.
What, sir?
I'm sorry. To say ಹಾಕಿದ್ದೀನಿ.
ಮತ್ತೆ?
After the issues. ನಾನು ಡಿಪೆಂಡೆಂಟ್.
You're challenging that.
ಹೌದು.
Then it should be stayed. The emergent notice to the respondent. You long after the issues. Yes. The petitioner is before this court. Petitioner defendant is calling in question an order permitting allowing an application under Order 6 Rule 17 seeking amendment of the written statement long after the issues were framed. In the light of, in that light, there shall be an interim order. Issues were framed, which would undoubtedly change the nature of the suit. In that light, there shall be an interim order of stay of the order impugned till the next date of hearing. List on 4th. Yes, next.
For the petitioner in this case, suit for partition was filed in the year 2007, my lord. That was said to be compromised on 11/9/2012.
Take out notice.
Please, my lord. Respondent number 1 was only the contesting party before the trial court.
File a memo.
In the RP.
File a memo.
Please, my lord.
Yes. Emergent notice to respond number 1. Memo, my lord. Memo ಕೊಡದೆ ಹೋದ್ರೆ ಆಮೇಲೆ ಇದು ಆಗಲ್ಲ.
ಇಲ್ಲ ಕೊಡ್ತೀನಿ ಈಗಲೇ.
ಎಲ್ಲಿ lunch hour. Yes. The learned counsel for the petitioner files a memo seeking dispensation of issuance of notice to other respondents except the first respondent who was the only contesting respondent before the concerned court. On the separate order ಮಾಡಿ ಆಮೇಲೆ ಇದು ಮಾಡಿ. Yes, next.
May be permitted to serve on the trial court.
The learned counsel of the petitioner is also at liberty to serve on the counsel who represented the first respondent before the concerned court. Next.
RP that was dismissed.
Whatever. Dismiss ಆದ್ಮೇಲೆ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ನಾವು? Yes, serve ಮಾಡಿ.
63.
What stage? Order 26 Rule 9.
Yes, ma'am.
What stage?
Evidence.
Anything else?
That's the
the petitioner is a tenant under the
Correct.
respondent
ಅದಕ್ಕೇನೆ
for a
ಹೇಳಿದ್ದು.
very long time, my lords.
Nothing else.
My lords, he was the tenant under the father of the petitioner, my plaintiff, my lords. He was there for more than 20 years.
Tenancy
and-
determine ಮಾಡಕ್ಕೆ you want court commissioner to go and measure the property.
ಅಲ್ಲ ಟೆನೆನ್ಸಿ ಅಲ್ಲ ಸ್ವಾಮಿ, ಫಾರ್ ದಿ ಡ್ಯಾಮೇಜಸ್ 25 ಲಕ್ಷ ಖರ್ಚಾಗಿದೆ ಅನ್ನೋದನ್ನ ಕೇಳ್ತಿರೋದು. During the tenancy, he has spent for the maintenance. When he took the building, it was a 50 years
ಅದಕ್ಕೆ
old
what will
building.
court commissioner go and do? Documents
ಅಲ್ಲಿ-
produce ಮಾಡಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಅದ್ ಬಿಲ್ಡಿಂಗ್ ನಾವ್ ಏನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ವರ್ಕ್ ಮಾಡಿದೀವಿ ಅನ್ನೋದನ್ನ ನೀವು ಅಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ ಸ್ವಾಮಿ. ಹಂಗಾಗಿ 25 ಲಕ್ಷ ಅಸೆಸ್ ಮಾಡಿದೀವಿ ನಾವು.
There is no counterclaim. The learned judge says that there is no counterclaim because now at the stage of evidence, he has to cross-examine me. There is a direction by this court to complete the proceedings by December.
ಇಶ್ಯೂ ಇದೆ ಸ್ವಾಮಿ. ಇಶ್ಯೂ ನಂಬರ್ 6 is framed on me.
He can lead evidence if he wants to. There is documents he has to produce in his evidence. Now for 3 dates, my lords, he is taking time. I have to travel from Bangalore to Mysore every time.
Issue number 6 is on the defendant, whether the defendant proves. ಅಲ್ಲ ಸ್ವಾಮಿ, issue number 6 is on the defendant, whether the defendant proves that he is entitled for a sum of 25 lakhs.
26(9) ಬರೋದೇ ಇಲ್ಲ. Anything else? Not at the court should find something amiss or confused to get it. You cannot fish evidence in your claim now by appointment of a commissioner, nothing else.
ನಾವು ರಿಪೇರ್ ವರ್ಕ್ ಮಾಡಿದೀವಿ ಅನ್ನೋದನ್ನ ಅಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Document ಕೊಡಿ, cross examination ಹೇಳಿ.
It was an old building, my lord.
Cross examination ಹೇಳಿ, whatever, you produce everything and ಇನ್ನು arguments ಆಗಬೇಕಾಗ. Court commission, what will you do, madam? Nothing. It's only to drag the proceedings ಅಷ್ಟೇ, because you are a tenant. Anything else?
To drag the proceeding, ಅಲ್ಲ ಸ್ವಾಮಿ, not to drag the proceedings. They only took time till last date for to lead their evidence. Now after
This is completed. I think my friend is not aware of the stages. My friend is not aware. I have completed my chief last year.
And cross examination pending.
Oh, pending is there. They should proceed with the cross examination.
I think you should do that instead of this.
cross ಮಾಡ್ತೀವಿ ಸ್ವಾಮಿ, ಕ್ಲೋಸ್ ಮಾಡಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ.
Cross ಮಾಡಿದ್ಮೇಲೆ
they have taken direction also to conclude the matter within 6 months also without notice.
ಅದಕ್ಕೆ ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ. Conclusion of the between the court and the plaintiff. Anything else, man? Order 26 rule 9 will not. Unless there is warrant.
Liberty may be granted to file application in.
Under what?
ಅಲ್ಲ ಮತ್ತೆ
ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡ್ಬರ್ತಾರೆ.
ಅಲ್ಲ, in the
Not on the same cause of action.
In the later stage if it is necessary.
Cross examination ಆದ್ಮೇಲೆ ಬೇಕು ಅಂದ್ರೆ. Yes. Learned counsel for the petitioner, after arguing the matter at length, seeks leave of this court to withdraw the petition to avail of such remedy as is available in law at the appropriate stage in the proceedings. Reserving such liberty, petition stands disposed.
54.
You are the plaintiff.
I am for the plaintiff.
TI is in your favor. Police protection act ಕೊಟ್ಟಿಲ್ಲ ಮತ್ತೆ.
Only on the ground that the respondent didn't appear before the trial court.
ಅದಕ್ಕೂ police protection gains.
Please ask.
Even ex parte injunction can be directed.
Please.
Police protection can be directed even again in an ex parte injunction.
Ex parte injunction is granted. Annexure is the order. Page 20.
But ಇಲ್ಲಿ ಸ್ಟೇಟ್ ನ ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ರೆ ಇಲ್ಲ ಡೈರೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅವ್ರ ಸರ್ಕ್ಯುಲರ್ ಇದೆ 4/11/2018 to enforce injunction orders, police protection will be granted. ಮಧ್ಯಾಹ್ನ ತಗೊಂಬನ್ನಿ.
Please.
Yes. Password. Notice. Yes. Emergent notice.
Senior is in
emergent notice returnable by previous 65 ಅಲ್ಲಿ. Returnable by 4th ಅಲ್ಲ 3rd. Petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings. Next.
Senior is held up in court hall 2, my lords. Kindly have password.
Password. Yes.
Much obliged.
57.
Counsel impersonation is emergent notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings or on the panel counsel representing the board till such time there shall be an interim order as prayed for.
Shorter date may be given. It can be disposed of.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. 4th, 2nd July. ನೀವ ಬೋರ್ಡ್ಗೆ ಅಪೇರ್ ಆಗ್ತದೆ. ನಿಮ್ಮ ಹೆಸರು? So and so, learned counsel so and so accepts notice for the Karnataka KIDB. So register to print the name of so and so is appearing for the KIDB. Others you serve.
Lords, in those two applications, amendment
The-
application has to be allowed first.
Correct. Yes, we'll
The
do that.
leading application
The
has been
petitioner is before this court calling in question an order passed in allowing an application or order 1 rule 10 seeking impleadment of the respondent into the proceedings. Two applications are filed by the impleading applicant, one on order 1 rule 10 for seeking to implead into the proceedings, and an application seeking order 6 rule 17.
Both have been filed by the plaintiff.
Correct, by the plaintiff, by the order 6 rule 17 seeking amendment of the plaint. The learned counsel for the petitioner would contend that the application under order 6 rule 17 ought to have been decided at the outset, and then the order under order 1 rule 10 seeking impleadment. The submission merits acceptance prima facie. Therefore, there shall be an interim order of stay of the further proceedings before the concerned court till the next date of hearing. List the matter on 2nd July.
69.
For the petitioner, suit for recovery of money.
Correct.
The debt is time barred. My lord, 9/1/2017 is the last payment.
Suit is
of-
dismissed.
No, suit is not dismissed. My application under order 7 rule
Rule 11 is
rejected-
dismissed.
Is rejected.
Take notice. What is the, how do you say it is time barred?
My lord, 9/1/2017 is the last transaction between the parties.
What is the date of the institution of suit?
My lord, there was a suit that was instituted on 7/1/2020.
Hmm.
It came to be rejected on 9/1/2020 because of non-compliance of section 12A of the Commercial Codes Act, pre-institution.
All right.
And thereafterwards, my lord, on 29/1/2020,
You undertook PIM, pre-litigation.
29/1/2020.
All right.
So by then the court, by then it was,
Failure of 12A,
that was filed on,
4/9/2020.
yes,
Suit is instituted.
23/9/2020. No, by the time he instituted a pre-mediation, my lord, the suit had become time barred.
Let's see, anyway. Take out notice.
Tomorrow.
He's in UAE, yeah.
My lord, he's in UAE.
United Arab Emirates, is it?
Yes, he's.
PA holder. Emergent notice to the respondent. Petitioner is at liberty to serve when the counsel or represented the plaintiff before the concerned court. Yes.
My lord, tomorrow is the cross-examination.
In the learned counsel for the petitioner, the defendant sets up a plea that the suit itself was barred by limitation. Sir, limitation is a question of
No,
fact
please.
and law.
Please have a look at page 36, my lord.
Limitation as by the time the proceedings under section 12A was instituted by the plaintiff, the cause was already barred by limitation, as the last transaction between the parties was on 9/1/2017, and the commercial OS in 22 of 2020 is you have filed.
He has filed.
The respondent then files commercial OS 22 of 2020, which is barred by limitation, is the submission. In that light, further proceedings before the concerned court in OS 236 of 2020 for recovery of money shall remain stayed till the next date of hearing. List on 25th. Petitioner to serve on the counsel or represent. Yes, next.
70.
Registered lessee, your lordship, registered deed. The owner in fact
Now
purchased
have they
it.
represented?
Before-
Defendants are represented today.
Defendants are represented.
ಮತ್ತೆ hear ಮಾಡಕ್ ಹೇಳ್ತೀನಿ ಅಷ್ಟೇ.
Your lordship, we only need to be protected, your lordship. The difficulty is they themselves admit in their earlier
I will
OS.
direct status quo to be maintained and hear the parties and pass orders.
Not to interfere, your lordship. Difficulty is this, even if
Then
I'm a trespasser, I would still have
2:30
to.
I'll pass.
Please.
Yes, we'll take it up at 2:30.
Please.
Yes, call next.
71.
appointment of a court commissioner, my lord.
It has been rejected.
2015 suit, sir.
Please, my lord.
We'll dismiss this also. Odd is there.
There is already a
Order
commissioner
26, rule 9, nothing.
My lord, I'll point out, my lord, because there is an admission in so far as what the properties are, whose property. He says my property is mine, his property is his. Where the construction is, my lord, is what is that, because there's an encroachment.
Matters at argument stage.
At the argument stage, which is why, my lord, after evidence was
22.
concluded, only we came and filed an application before the honorable trial court. And my lord, I'll point out, my lord, please.
Rightly rejected.
My lord, I'll point out. My lord, it says that it is for collection of evidence, not for collection of evidence. All that is there, my lord.
Collection, correction, ಏನು
Collection
ಮಾತಲ್ಲ.
wala correction wala. My lord, what I'm asking for is it should be based on a Hissa Tippani of the year 1980. That is when my predecessor and title had purchased the property. I'll point out, please.
All right.
Please.
Anyway, adjournments are back. I'll just call the case. 119. Page wise ಕರೆದ್ಬಿಡಿ madam.
Page was adjourned, page 9, 72 to 80. Page 10, 81 to 89. Page 11, 90 to 92. Page 12, 93 to 96. Page 13, 97 to 98. Page 14, 100 to 106.
98. Yeah, the orders, I'll pass an order.
Page 14, 100 to 106. Page 15, 107 to 111.
Serial number 104, my lords.
One ನಿಮಿಷ sir. ಅದರಲ್ಲೇನು yes.
Page 16.
121 to 127. 119. So the learned counsel appearing for the respondent seeks a week's time. List on next Monday, bada. It's the 23rd. Yes.
Serial number 10.
Wait, sir. Orders are little. Wait.
Great.
List number 2, serial number 55 as withdrawn, my lord.
My lords,
List number 2, serial number 55. Reflections. The
we'll
lower court order.
call that list waited. That's what my
Your
lord.
lordship with
Island application.
No problem.
your lordship with the leave of this. This
My lord, may I
matter
make mention, my lord?
1 minute.
This matter pertains to the special investigation team constituted by your lordship in that new space research matter.
All right.
Just filing an application since one of the member has been transferred as Commissioner Belgaum. So there's some inconvenience for him to be part of the SIT team. Just suggesting an alternate name, your lordship.
Your lordships, I appear on behalf of the respondents, my lord. This matter was taken up on 6/6 and reserved for judgment. I'm only filing my written submissions along with the same, my lord.
On this application.
Much obliged.
Which was that?
9659. The question whether the commercial courts can execute the arbitration. The question if the commercial court can execute an arbitral award that is passed by under the arbitration.
For execution.
Very well.
Yes, yes. With my lord's kind permission, please. Serial number 132, list number 1. My request your lord kindly have it on Wednesday 2:30. ನನಗೂ ಆಗಲ್ಲ. We'll see some other day. Wednesday, my lord. ಅದು ನೋಡ್ತೀನಿ ಯಾವತ್ತು ಅಂತ. Friday half day ಆಗಲ್ಲ. Wednesday we'll see. Please. Yes.
My lord. May I make
Yes.
mention, my lord?
Yes.
My lord, serial number 89, I appear for the petitioner. There's some office objection raised on that. May I be permitted 2 weeks' time?
Seriously, you want to make a mention of this sitting in your office? Wait.
Yes, my lord. I'm sorry, ma'am.
Office objections first time. Number 1 to 29. One withdrawal.
One withdrawal. I think one in terms of the memo. 2 to 29.
My lord, small submission.
Delivery warrant issue.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 28.
20?
Small submission.
ಏನಾಗಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಬರುತ್ತೆ ನಾಳೆ ನಾಡಿದ್ರಲ್ಲಿ ಬರುತ್ತೆ.
ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ? ಡೆಲಿವರಿ ಆಗೋಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ ಮೊನ್ನೆ ಆಗಿರೋದು.
ನೋ ಪ್ರಾಬ್ಲಮ್. Yes.
Small submission, my lord.
You will comply it, it will come on Monday. Yes.
Small submission. Serial number 29. The petitioner. Lordship, please pass an order staying execution case at annexure.
Office objection ಬಂದಿರೋದು.
Small objection, I will complete.
Comply it, sir.
Small observations.
ಏನ್ ಬೇಕು?
ಯಾಕಂದ್ರೆ ಅದು execution case is posted to tomorrow. They
For
may
what
execute,
purpose?
to execute the judgment and decree. That leads to demolition of gigantic wall which is existing.
Demolition ಆಗಲ್ಲ ನಾಳೆ. Accepting the submission of the counsel for the petition 29 ಅಲ್ಲಿ. Office objection stands overruled. List the matter on Wednesday in preliminary hearing. Yes. ಅವತ್ತು Wednesday.
ನಾಳೆ ಇದು execution.
ಅಲ್ಲಿ ಟೈಮ್ ಕೇಳಿ.
ಆಯ್ತು.
Otherwise 2 weeks ಅಲ್ಲಿ. Ensuing Monday ಅದು ಫಾರ್ಮ್ಯಾಟ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ಅವ್ರ ಹತ್ರ ಕೊಟ್ಟು. Second time. 10 days. Same order.
30 to 44. 30.
Number 39. The suit is decreed. The petition has become infructuous.
ಯಾವುದು ಮೇಡಮ್?
Serial number
37.
39.
37 ಏನು ಹಾಕಿದ್ದಾರೆ ಎಂದು? 35. Memo for withdrawal. 35 in terms of the memo. 39. The learned counsel for the petitioner submits the suit itself is decreed. In that light, the petition is rendered infructuous. The submission is placed on record. Petition is disposed as having become infructuous.
My lord,
serial number 37, my lord, may I make a mention, my lord? Serial number 37. My lord, the office objection is that my prayer that I have sought is wrong anta avaru office navaru ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Office objections overruled. List the matter day after tomorrow in the fresh matters list. 37.
Serial number 42, my lord, list. The petitioner, the parties have settled, my lord. The petitioner
The
has
learned
become
counsel
infructuous.
for the petitioner.
Please, my lord.
The learned counsel appearing for the 42 only, madam. Learned counsel appearing for the petitioner submits the list has been settled out of court by the parties. In that light, the petition is rendered infructuous, disposed as having become infructuous. third time. Second time, 10 days. Third time, 1 week. In the event of non-compliance, would be dismissed for its non-prosecution. Yes. Fourth time, same 1 week. Sixth, same 1 week. Now, pass over. 50. 50.
ಅದೇ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ
Second list.
ಹಾ
The submission in that one.
ನೋ ಸಬ್ಮಿಷನ್ ಒಂದು ವಾರ 6ನೇ ಸರಿ ಆಗೋರ್ ಕಾಯ್ದು ಈಗ ಸಬ್ಮಿಷನ್
ಇಲ್ಲ submission ಅಂದ್ರೆ ಮೇಡ್ ರಿಟರ್ನ್ ದಿಸ್ ಥಿಂಗ್. ಅಬ್ಜೆಕ್ಷನ್ ಏನಂದ್ರೆ ಎಲ್ಲಾಸ್ ರೆಕಾರ್ಡ್ ಬಂದಿರೋದಕ್ಕೆ
ಕಂಪ್ಲೈ ಮಾಡಿ.
ಕಂಪ್ಲೈ ಆಗಲ್ಲ ಮೈಲಾಸ್.
ಆಗಲ್ವಾ?
ಇಲ್ಲ.
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
ಮೈಲಾಡ್ ಅದು
ವೇರ್ ಇಸ್ ದ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್?
ಇದೆ ಸ್ವಾಮಿ ಬರೀ
ಎಲ್ಲಿದೆ?
ಐ ಹ್ಯಾವ್ ರಿಟನ್ ಇಟ್.
ಕೊಡಿ ಮೇಡಮ್.
This is decree of 1998 Milas. A decree ಅಲ್ಲಿ the party have got expired, so I have made the LAs as a party to this writ petition Milas. I am seeking to set aside the decree, compromise decree passed Milas fraudulently on the ground that it is void ab initio and is nullity Milas.
ಅದು ಮುಂಚೆನೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಕೋರ್ಟ್ಗೆ. 6 ಸರಿ ಬಂದಿದೆ. You are not present. That's the whole problem. List next Monday and preliminary hearing.
There's one urgency in this case.
The comply ಮಾಡಿಲ್ಲ 6 ಸರಿ ಮತ್ತೆ urgency ಅದರ ಮೇಲೆ next Monday.
For a second Milas.
No sir, next Monday.
Grave injustice will be caused.
No. It has been coming up for the last 6 months and nothing has happened. So Monday.
Question was about the maintainability.
No sir.
Maintainability, my lord. Which
I will uphold the maintainability and dismiss it now. Next Monday. Yes. ಅದನ್ನ ಫಸ್ಟ್ ಆ ಕೋರ್ಟ್ಗೆ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. 6 ತಿಂಗಳಿಂದ ಬರ್ತಾ ಇದೆ, ಅದು ಹೇಳಿಲ್ಲ. ಯಾಕಂದ್ರೆ ನನ್ನ ಅಪಿಯರ್ಸ್ ಎವ್ರಿ ಟೈಮ್.
ಇಲ್ಲ no appear.
Every time ನನ್ನ ಅಪಿಯರ್ಸ್.
I think only one time we have not appeared.
Next.
Just kindly for a
Monday sir.
Deputy commissioner
Monday.
order ಮಾಡ್ಬಿಡ್ತಾರೆ ಸ್ವಾಮಿ. ಮಾಡ್ಬಿಟ್ರೆ I will have.
You should have known the urgency at the first instance. Appear before the court and had told that office objections cannot be complied. You are telling it on the 7th time that it has come before the court. Correct? So Monday.
At least short date Milas.
Illandre adjourn by 4 weeks. Yes.
Pastor matter still number 6. Serial number 6.
There is no representation on behalf of the petitioner both in the forenoon and in the afternoon. List after 8 weeks. Registrar is directed not to list the matter prior to the expiry of 8 weeks.
24.
Ganesh Prasad judgment, your lordship had mentioned in the morning.
Huh?
6 rule 17 Ganesh Prasad judgment, your lordship had mentioned in the morning. Paragraph number 37, my lords.
Correct.
Plaintiffs and defendants are entitled to amend the plaint, written statement or file additional written statement. It is however subject to an exception that the proposed amendment and opposite party should not be subjected to injustice and that any admission made in favor of the other party is not but wrong. In this present case, my lord, I am seeking amendment of written
Emergent
statement.
notice to the respondent. Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement list on 27th. There shall be an interim order of stay spread for till the next date of hearing.
Grateful, my lords.
Yes.
28.
Aviator.
ಈಗಲೂ ಇಲ್ವಾ?
ಈಗಲೂ ಇಲ್ಲ.
Counsel for the caveator has remained absent both in the forenoon and in the afternoon. In the light of the prima facie case made out by the petitioner, there shall be an interim order of temporary injunction.
Now that further constructions have come, I have sought for not to put up construction.
There
So
shall
no
be an
further
interim.
construction.
Where is your prayer?
That's my prayer, my lords, at page
Yes.
21.
There shall be an interim order spread for till the next date.
Great.
Next.
37.
ಇದು ಒಂದು ನಿಮಿಷ ಏರ್ ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ.
48.
Rejection of application under order.
Where were you, sir?
Morning I was in another court.
Yes, sir.
Rejection of application for sending the document to the.
2610A.
Please.
Now what's wrong?
My lord, the cross examination, I confronted the document and he denied the document also. And even I made a suggestion to.
Only notice, check out notice. Petitioner is permitted to serve, directed to serve on the counsel who represented the respondent in the trial proceedings list on 23rd.
11th is the date for your.
ಏನ್ ಮಾಡಕ್ಕ? There is no warrant for interim order here. Yes, next.
52.
ಬೆಳಗ್ಗೆ ಇದ್ದೀರಾ?
There is no representation on behalf of the petitioner, both. ಇಲ್ಲ madam. There is no representation on behalf of the petitioner both in the forenoon and in the afternoon. List the matter after 8 weeks. Registry is directed not to list the matter prior to the expiry of 8 weeks. Next.
56.
Respondent number 2. Lord, this is that order 1, rule 10.
Barley, will pass, will dictate the order.
The petitioners in the morning session sought for not being present.
Oh, not being present.
That,
Correct.
excuse
We'll
him.
pass it or we'll do it. Yes.
57.
A defendant without.
We'll dismiss it. Commercial court ಅಲ್ಲಿ high court ಬರಲ್ಲ ಅಂತೀರ because it is commercial court.
No, sorry. Lord, the defendant without filing.
You are the defendant.
No, my lords, I am the plaintiff.
Plaintiff, correct.
Without filing written statement, he makes an application for production of certain documents. I object to it saying they are not relevant. The honorable court says the question of relevance is irrelevant.
The learned counsel Manu Kulkarni appearing for the petitioner. Petitioner is the plaintiff. Institutes a commercial OS, alla?
No, my lords.
Alla, institutes a suit in OS
684 of 2024.
684 of 2024. The defendant therein files an application under Order 12, Rule 8, seeking production of certain documents from the hands of the plaintiff, the petitioner. The concerned court allows the application. This is what has driven the petitioner to this court. Prima facie, an application under Order 12, Rule 8, particularly from the hands of the defendant, directing the plaintiff to produce certain documents, shall be only after putting up defense by way of filing of a written statement and not before the said date. Written statement is yet to be filed by the defendant. Before the filing of the written statement, there cannot be a warrant to file an application but by the defendant under Order 12, Rule 8. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. Emergent notice to the respondent. Returnable by the 4th.
Sorry.
59.
ಅದು ಬೆಳಗ್ಗೆನೆ ಕೊಡ್ತಾ ಇದ್ದೆ ಕಮರ್ಷಿಯಲ್ OS ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಅದಕ್ಕೆ.
There is already, kindly see page 19, my lord, actually. It's not for partition, my lord, which has already been decreed, my lord.
Both courts have held against you.
Both courts, my lord, kindly see, my lord. Second I filed wakalat, my lord. Third court issues an interim order of status. No prima facie reason, nothing has been assigned, my lord. Now kindly see the first document, my lord, annexure A. Suit has been decreed, kindly see, my lord. Partition, he has no exclusive right to claim injunction, my lord. One of the party, my lord. I have been in possession of the property, I have produced
You are
documents.
the plaintiff, sir.
Pardon?
You are the defendant.
I am the
sorry,
defendant,
please.
my lord. Now kindly see page 19, my lord. 19, this is one of the family member files a suit at page 19, my lord. This was filed in 2009, my lord. Decreed in 2024, my lord. Now kindly see the
No warrant to grant an ex parte again. Yes, emergent notice to the respondent. Petitioner shall also serve on the counsel who represented the respondent. Registry to put up after the service of notice. Next.
interim order of status. My lord, status quo has been granted.
Oh,
my lord.
no, sir.
This is, my lord, reins are there, my lord. Kindly say, I have.
Move it. Yes, next.
Next week, my lord.
No, sir. You move it after service. Next.
64.
Circular.
4/11/2018.
14/11.
14/11, sorry, on 10 days. Yes. Government. The petitioner plaintiff is before this court calling in question a rejection of an application filed seeking police protection on the strength of the ex parte interim injunction granted, ex parte temporary injunction granted by the concerned court. The concerned court rejects the application on the score that it is a temporary injunction. The temporary injunctions also can be
uh, enforced by
tenure.
Can be enforced in the light of the circular issued by the state on 14/11/2018. Insofar as 2018, the clause reads as follows. Clause 10 if you like. In that light, the petitioner is entitled to a police protection as sought for at the hands of the concerned court. A emergent notice to the respondent. The police shall now accord police protection to the petitioner during the subsistence of the subject petition, subject to further orders at the hands of this court. Next.
66.
Let's suit for declaration and other reliefs for cancellation of the sale deed has been filed. When it was
Are the
pending,
defendants represented now?
they are represented in the suit.
ಇದು on merits after hearing both the parties ಮಾಡ್ರದಾ?
Yes.
ಅಥವಾ expert?
ಇಲ್ಲ, after hearing.
Yes, sir.
My submission is that the findings and especially at page 28, Lordship may kindly turn to the ink page 28, internal page 9. The learned judge comes to the conclusion that the court is unable to find out when the defendant is permitted to mark those documents which are admitted by the plaintiff, which is the inconvenience or prejudice.
What application is this?
Order review application, page 69. Earlier, an application was filed, my lord, for production of documents.
All right.
Thereafter, my lord, the matter came up to this honorable court at page 121 is the order, my lord. On 12th December 23, I made a submission saying that whatever available documents are there, the tenant has already left after a few months. Those documents I will furnish. He is trying to fish out evidence from me to prove his claim for damages. So I made a submission before this honorable court that I would furnish whatever documents are available. When I have furnished those documents in the form of Xerox
So this
copies,
court has permitted him to produce with regard to forcible dispossession. If he proves that, then he will be entitled to damages.
that is subject to that manner. Now the question is,
Yes.
they want to mark those documents which are
so
Xerox copies.
So what?
Xerox copies.
Now the documents which shall be produced by the petitioner plaintiff, that is the tenant.
Yes.
All right.
Tenant
as well as without accepting denying the allegations, forcible dispossession.
That was
Yes, sir.
that was decided by this honorable court
Anyway,
that in writ petition, my lord.
Let the respondent come.
Now they want to mark the documents listed today.
So what? Yes.
We requested for time, but still they are trying to mark the documents.
You were before the court.
Yes, ma'am.
The coordinate bench decides that he is entitled to prove forcible dispossession.
No, my lord, as far as page 121 al order is there.
Page 125 al order ಇದೆ ನೋಡಿ.
Adralle I have undertaken, my lord, that I will produce whatever.
You have undertaken Allah, sir.
I have produced it all.
Last 5 lines.
The documents which shall be produced by the petitioner will be without
Accepting
prejudice,
and denying the allegations.
as well as without accepting or denying the
Now you have
allegations.
denied forcible dispossession.
No, there is no forcible dispossession.
That you have denied before the court. He is claiming damages on the ground that it is forcible
Yes, we
dispossession.
have denied, we have been in possession.
You have denied. So he has to prove that. Or if you are permitted to mark the documents, he also will be permitted. So what?
But damages, he will prove damages.
So we let him prove. You disprove it there.
Let
Where is the
others-
question of stopping him from producing documents for proving forcible
At least
dispossession?
let the other side appear, my lord, and let them have they say till such time, my lord, let them
No,
not
till such time.
precipitate. All right, my lord, I'll take notice if your lordship directs.
No,
Let them
take
be
notice.
presented.
Yes. Heard the learned senior counsel, Srinivas Lokre appearing for the petitioner. The petitioner is the plaintiff. Plaintiff is the landlord. The respondent, the tenant. The plaintiff was before this court in writ petition 24932 of 2023, which comes to be disposed on 12th December 2023, while observing that the petitioner is entitled to produce all the documents without prejudice to the rights, as well without accepting or denying the allegations of forceful dispossession as alleged in the affidavit of the defendant. the petitioner, the plaintiff produces all the documents and contends that there is no forceful disposition. The defendant now comes up with an application seeking production of documents to show forceful disposition. That is now objected to. Prima facie, there is no warrant of interference. However, the petitioner shall serve on the counsel who represents the respondent in the trial proceedings. List the matter next Monday. Ashte agada. Yes.
70.
Plaintiffs file suit for just an injunction, Your Lordship. This is a matter wherein he's a lessee, 30-year-old, 30 years period of. Your Lordship said that it could be a status quo. Difficulty with the status quo is it's already a constructed commercial building. Then he would not be allowed to let it out to anybody, and then that status quo order will affect. Your Lordship, this is a matter even when the previous order of this honorable court has already observed. There are different parties who have tried to come in and disturb a 1996 sale deed.
Page 150.
Please, page 150, yes.
Heard the learned senior counsel, Srimati Lakshmi Iyengar, appearing for the petitioner. Petitioner, the advocate on record, shall serve on all our contesting respondents. Shall serve on the counsel who represented the defendants/respondents before the concerned court. List the matter on 2nd July. After service of notice, there shall be an interim order of stay spread for till the next date.
Obliged.
Yes. Next.
Continue. 71.
For the petitioner seeking a short.
Post lunch has vanished.
Malas is here only on his legs before the other court.
Yenilla. Nothing.
Short passover.
Short passover. How short?
As soon as.
As short as possible.
Please.
All right. Short passover.
72.
Okay, for the petition in this matter, Manoj. I'm the plaintiff in this matter, Manoj. I had filed an application. No, Manoj, this is a suit, Manoj, for redemption of a usufructory mortgage. There are two properties involved, Manoj. One portion, Manoj, he says I'm not in possession. And it is my specific contention that he is in possession of the property. He has denied it in his cross-examination, but has admitted in his written statement.
Come to page 30, para 10.
Please, Manoj. Manoj, this is contrary to what is pleaded by the party, Manoj.
No. Yes.
In the written statement also.
Then petitioner shall serve on the counsel who represents the defendants before the concerned court. List the matter on 23rd.
My request for a stay of the proceedings.
No, it's a case for dismissal because you said it's contrary to the pleadings. Yes, next.
No, Manoj, in the written statement, he has said he is not in possession. He is in possession in the. Please, Manoj.
73.
Manoj, one request, Manoj. What's my dispense notice to the other defendants? I'll file a memo to that effect. It is only being.
File a memo. What memo is it? No dispensation.
Notice to the other respondents. It is only contested by respondent number 8.
8 matra, na?
8 matra.
Learned counsel files a memo. Previous matter, madam. Learned counsel files a memo seeking dispensation of service of notice upon all other respondent except respondent number 8. The memo is accepted. Notice service of notice dispensed at the risk of the petitioner. Yes, same one. Next.
73.
Emergent notice to the respondents.
Instead of
Petitioner is at liberty to serve on the counsel who represents the respondent in the trial proceedings. List the matter on 27th till such time parties to maintain status quo acquire the property. Next.
Much obliged.
74.
The plaintiff suit for partition separate possession.
Dismissal of suit.
Yes, means dismissed for non-prosecution.
Concurrent. ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರಿ ಸರ್?
Immediately, my lord. After
immediately.
Yes,
Where
my
is
lord.
Immediately here.
My lord, on 15/2/2016, the suit is dismissed for non-prosecution.
Correct.
And immediately, my lord, on 33/2016, after delay of 15 days, my lord, filed a miscellaneous petition before the trial court, my lord.
Why is it rejected, sir?
My lord, it is rejected, my lord. The application should file instead of order 9 rule 4, order 9 rule 9. My lord. but it is wrongly quoted the provision order 9 rule 4.
Where is your application?
My lord, that annexure E, page 76, my lord.
Defendants were served.
Served, my lord. Served, filed a written statement.
Then serve on them. Petitioner to serve on the counsels who represented the defendants in civil miscellaneous 33 of 2016.
And 2 of the defendants are not served. 9 and 10. I have to take the process steps and sit.
Emergent notice to respondents 9 and 10, returnable by 2nd June, list on 2nd June.
75.
Petitioner ಮೇಲೆ
ಸರ್ಫೇಸ್ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಸರ್ಫೇಸ್ ಅಲ್ಲ ಮೇಡಮ್ OS ಮೇಲೆ ಕಾಮ್ OS
ಗೊತ್ತು OS ಅಂತ ಫೈನಾನ್ಸ್. Yes sir.
Yeah, the petitioner paid the regular EMI my lord up to 3,59,000 my lord. She borrowed 5 lakhs my lord. Now she is ready to even for the settlement.
Petitioner to serve on the counsels who represented the respondent in the trial proceedings. Execution proceedings.
Yes my lord.
Execution proceedings. The learned counsel for the petitioner submits that the petitioner is ready and willing to clear the entire amount that is in due.
Not entire amount my lord.
Then what?
They are ready to mediation my lord. They are not come forward for mediation.
We'll see. Yes.
They are ready to 2 lakhs rupees my lord.
The matter. Petitioner to serve on so and so, list on next Wednesday. Next.
My lord, interim order my lord.
Next Wednesday sir. Yes.
76.
For the petitioner. Rejection of application filed for repair the
Order
dwelling
20
house.
rule 18 application. So what? Nothing wrong.
During the pendency of the final decree proceedings, the house was collapsed in which the petitioner was is residing, my lord. The petitioner will
Not
not.
this stage. Amale.
The petitioner will not seek any equity, my lord. Without considering the application, the petitioner is.
Nothing.
The petitioner will not seek any equity, my lord. Because of the rejection of application, the petitioner is made to reside in the rented house, my lord. Other co-sharers are residing in the same suit schedule premises, my lord.
Yes. Yes, nothing.
Notice may be ordered, my lord.
Notice. Emergent notice to the respondents.
I may be permitted to serve the notice.
To serve on the counsel or represent the respondent in the trial proceedings. Next.
77.
This is specific order by the Honorable Court. Petition 31603, page number 60, my lord.
Emergent notice to the respondents returnable by the 4th of July, list on 4th of July. What is now sent for determination?
The determination along with the agreement, there is a development agreement. I have not relied on the development agreement.
There shall be an interim order of stay as spread for till the next date.
Much obliged.
78.
Okay, for the petitioner, please. Defendant is the petitioner.
Are the respondents served today?
No, please.
Have they represented as on date?
They are represented.
Then let the court hear all of you and pass orders.
No, this is order 16 rule 1 application.
Serial number?
78. Order 16 rule 1 application has been allowed.
Not 39 one. Sorry.
The plaintiff respondent.
List of witnesses.
List of witnesses kindly be looked. I produced it along with the application, please. There are some random people have been mentioned to be brought as witnesses in this case. They are not expert witnesses, neither they are attesting witnesses. Suit is of the year 2012, seeking cancellation of decree passed in the year 1989, please. And lot of, after the completion of the cross-examination, just to drag on the proceeding.
Where is the application?
At annexure C, please. In page 34. In page 34.
34.
It is handwritten, so I have produced the type copy at ink page 40, please. For the reasons sworn to
serve on the counsel. Petitioner to serve on the counsel who represented the respondent in the trial proceedings and file an acknowledgement. List the matter on 23rd.
Tomorrow is the
till such time further proceedings before the concerned court shall remain stayed. Next.
Grateful.
79.
Petitioner. Your order 39 rule 1 2, my lord.
Hmm?
Initially, my lord, suit for partition. My lord. Initially, order 39 rule 1 2 was allowed, my lord. After my lord, the defendant number 4 filed a application under 39 rule 4, my lord.
Hmm.
Interim order was vacated, my lord. Agreed by that, my lord, I have filed a.
It is granted on suppression. Come to page 25, sir. Para 15.
Please, my lord, there was an execution petition, my lord, wherein I have participated. My lord,
Emergent notice to the respondents.
My lord, in this case, I will undertake to file wakalat on behalf of respondent 1 and 8, my lord.
Haki, sir. Yes. Next.
80.
Order 1 rule 10 application.
Rejected.
Rejected.
So what?
It's the suit for declaration and injunction, my lord.
OS of 2008.
Please, my lord.
Yes, sir.
I am subsequent purchaser, my lord. Subsequent purchaser, my lord. The trial court rejected the application on the section, it by section 52 of TP Act, my lord.
Yes, sir. Nothing wrong.
I rely upon the judgment of a apex court, my lord. Please. Page number 42, my lord. And one more judgment, my lord. Same similar circumstances, my lord. Allowed the application, my lord. Sorry. Page number 16, para 16.
Compromise enter ಆಗಿದಾರಾ ಇದರಲ್ಲಿ?
They will collude, my lord. In case they will collude to protect my interest, my lord. I am necessary party.
Yes. Emergent notice to the respondents. Petitioner shall serve on the counsel. Apart from taking out steps, the petitioner shall serve on the counsel or represent the respondents in the trial proceedings. We'll say not to alienate.
I'm not.
Yes. There shall be an interim order of stay of further proceedings before it's 17-year-old suit, sir.
Please, my lord.
So
Appeal is pending, my lord.
the next date of hearing, list on 23rd in preliminary hearing.
Please, my lord.
ಇವತ್ತೇ ಸರ್ವ್ ಮಾಡಿ. Yes. ಕೇವೇಟ್ ಇದೆಯಾ? Which serial number is it?
18.
Where is the counsel for the caveator is not present? Chetan V. Chetan.
Till number 80, Chetan.
ಅಲ್ಲಿ none appears for the counsel for the caveator ಅಂತ ಮಾಡಿ. ಆಮೇಲೆ ಇದು ಬಾಡ.
81.
This case I appeal for the petitioner counsel. We called in question, my lord, after the trial court learned judge. That is page at annexure A.
Order 6 rule 17 rejected.
The court will have rejected.
Correct.
It is my suit.
Survey number 16 61 ಮಾಡಬೇಕು ಅಂದ್ರೆ ಹೆಂಗೆ?
Last week kindly.
61 60 ಮಾಡಬೇಕು.
Exactly, my lord. Withdrawing of the early 61 survey number. Now the whole case of the both the plaintiff and the defendant is.
If it is a typographical error, it is all right.
My lords, this application was filed at the very fag end of the proceedings.
No,
2011 is the suit. Matter was posted for final arguments. Plaintiff concluded, defendant concluded. It was posted for reply by plaintiff arguments. Then they filed it. They have to show, my lords, due diligence. And the only reason given by them for due diligence is the counsel happened to notice that 61 is part of the plaint. That is their application.
The entire suit is one for a bare injunction. The earlier, the whatever the contesting defendant derives a claiming the title through only through BDA. That is the contesting. Earlier, the suit for declaration and for an injunction, it was decreed. Now you are already, so far the title is concerned. So far the survey number 60/4 is the subject matter of the suit. It is his case is also the present site in question. Whatever he claims. It comes under the purview of the survey number 60/4 only. That is specifically pleaded in the recent statement. But here, my lord, what he tried to pursue is the survey number 61 is, so far the survey number 61, let there is not a disturbance in executing the decree. And that's why we filed the application for amendment. Now that learned judge as amendment is rejected only on the ground. No. This is the only, you are actually kindly by inadvertent in the later stage at the time of reply to the argument, we noticed it. Survey number 61 is nothing to do, and we are not pressing, and in fact, we are not claiming any other that we to permit it to amend the claim by withdrawing the whatever so far the pleadings are concerned with respect to survey number 61. That's all my case. So far the 61 is concerned, my family members also, that is between the new of the joint development agreement, all this question. Now there is your last may kindly assuming for an argument sake. Now
written arguments ನಡಿಬೇಕಾದ್ರೆ ಏನಿದು?
I may be permitted to place the
judgment.
Documents. No. Documents earlier it was a decree. And date may be fixed. Your last may kindly.
For what?
No. Here, my lord, I wanted to point out from the documents earlier there was a decree. So far the suit for declaration and injunction was decreed by the earlier in 2012. Your last may kindly appreciate what I tried to point out from the decree itself. Your last may kindly. May I request my lord from the document page at document number 12, page at 170. Your last may kindly see suit. So far with respect to survey number, schedule may be kindly wished. May I request my lord page at 173. The schedule is E60/4.
173 na.
ಹೌದು ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ
ಕೊಟ್ಟಿದ್ದ.
ಹೌದು ಕೊಟ್ಟಿದ್ದು ನಾವು ನೋಡ್ಬೋದು. Document number 12, page at 170. This was the
What is the suit for?
The suit is for a declaration.
Correct.
May I request my lord 172, the nature of the suit for declaration and for an injunction.
All.
Now you are like be against the BDA. Now the present contesting defendants, their claims through BDA only. Their claims to be the actual purchaser. Now, so far the title is concerned. Now, sir, the decree, you are made, I'll read the judgment and decree of the learned judge of the court below.
Now you want deletion of survey number 61.
Yes, exactly, that's all.
Why?
We are not, it is a plaintiff suit. In fact, survey number 61 is concerned. Both are notified earlier.
Survey number 61, now you want to convert it to 60/4.
No, we are not claiming. We are not here to convert. There is all a sufficient pleading.
Only deletion you want?
Okay, only deletion, nothing more than
that. Claim.
Themselves has to take.
Let us, even if he satisfies on merits, he still has to satisfy the proviso under Order 6 Rule 17, which states due diligence. Kindly pursue page number 74, my lords, of the writ petition. Page number 74, my lords, for a moment. Their application starts at page number 72. Their reasoning for due diligence is given in page number 74.
No. Now,
yes,
he has in the schedule, it is said survey number 61. He has no claim on survey number 61.
No, he says he inherited 61 from his ancestors. So, and his contention is that the defendants interfered in his possession over 60/4 and 61.
Your claim is 60/4.
Yes, only 60/4.
60/4.
But this is a suit for bare injunction, my lords, not for declaration.
Correct.
His contention
declaration
is no, that is some other judgment he has showed. This present suit is only for bare injunction. He has not even challenged my sale deed. The suit is not even maintainable, my lords, on the ground of.
Where is the?
There is already this.
1 minute, sir. What is the suit for? Let me see.
My lords, page number 53, my lords.
Present suit is only for a bare injunction, my lord.
But then declaration.
Earlier suit is decreed for a declaration.
My lords, kindly see page number 74, my lords. Para number 7.
I am not disputing.
Page number 74, my lords.
And only I am withdrawing so far the survey number 61. Let there not be a confusion.
74, para number 7, my lords. I submit that now the matter is posted for reply arguments on merits. At the time of preparing the arguments, my counsel noticed that survey number 61 was mentioned in the suit schedule property due to oversight, but the said survey number 64 is nowhere connected to the suit schedule property. Suit, my lord, is of the year 2011. For 15 years, how can they have overlooked survey number 61 and continued with the matter, my lords? The examination in chief, cross-examination.
His claim was on survey number 61.
Yes.
Now, is he altering his claim to something else or deletion 61? That's
He's
all.
deleting 61. My lords, even then,
1 minute, sir.
Due diligence has to be shown, my lords.
Either due diligence irilla 61 ತೆಗೆದ್ರೆ ಏನಾಗುತ್ತೆ?
61, there'll be a lot of prejudice to the defendants. Yes, my lords. The reason is, my lords,
he claiming 60/4.
Yes.
61 is the 61 ತೆಗೆದ್ರೆ ಏನಾಗುತ್ತೆ?
My lords,
if replacing it to 60/4, it's a different.
Not replacing anything.
There'll be prejudice caused to the defendants.
How, sir?
My lords, because he seeks to rely on another suit which is decreed in his
So
favor.
he may rely on that, not rely on that. He is saying 61 was erroneously inserted in the prayer.
My lords, I'm questioning that itself. How can he
ಆಯ್ತು,
have
due diligence
erroneously?
diligence ಇರ್ಲಿಲ್ಲ. Don't go on the plain meaning of due diligence.
I'll just pass over
What
one
is the
judgment.
prejudice that would
My lords,
cost you?
one
Tell me.
judgment, my lords, on due diligence. Matter is settled, my lords.
Due diligence.
My lords, kindly take
What matter is settled?
page number 25, my lords.
Yeah, ಎಲ್ಲ ಹಳೆ judgment.
No, my lords, page number 20.
Get Ganesh Prasad sir.
My lords,
ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ.
my lords, page
ಈಗ
number
ಒಂದು ಕೊಟ್ನಲ್ಲ ಗಣೇಶ್
20, my
ಪ್ರಸಾದ್
lords.
ಮೇಡಮ್ ಗಣೇಶ್ ಪ್ರಸಾದ್ಗೆ ಒಂದು ಜಡ್ಮೆಂಟ್ ಕೊಟ್ಟೆ ನೋಡಿ ಯಾವ್ದ್ರಲ್ಲ ಯಾವ್ದೋ ಫೈಲ್ ಇಟ್ಟೆ. ಎಸ್
My lords, page number 20, my lords, just for a moment.
Everything when it should be allowed, when it should not be, even after framing of the issues. ನೀವು ತಂದಿದ್ದೀರಾ?
The amount is some of the 22, 24, 25 is there.
ಕೊಡಿ.
Entire judgment on the order 6 through 17.
Due diligence ಆಗಿಲ್ಲ, it's all right.
Yes.
But you tell me what is the
Lords,
prejudice that
under 6 rule 17, proviso specifically states
Say,
due
it may
diligence
say,
has to be
sir,
shown.
I'm not saying that it may say
Yes.
he has not done due diligence.
Yes.
If he is going to delete that, what is the prejudice that is caused? If he is replacing your property, then tell me. He is not doing that.
Not doing that, my lords. But he seeks to rely, my lords, on another suit, which is decreed in his favor. His contention is that if he deletes 61, the present suit will conform with the previous judgment. And he can rely on the judgment to get a decree in his favor.
ಈಗ the earlier suit
Yes.
is between whom?
Between the petitioner and the BDA. I am not a party.
You are the purchaser later.
Yes, my lords, I am the
The
purchaser.
auction purchase.
Auction purchaser by the BDA.
Yes, my lords.
And
Now
Even
the decree,
my lords,
now he
even
wants to rely on the decree.
yes, even if that is to be considered,
Now, who is in possession?
my lords,
and in possession.
then
They are in
BDA states that I am in possession, but they have got an injunction against me. My lords, but even if they consider the previous suit, even then they cannot rely on it because the boundaries are not identical.
that will
May I request?
My lords, may I just point out
to
this
assist
one
my
judgment, my lords, it exactly on the point, my lord.
May I accuse-
Page
may I
number
request,
20.
sir?
My lords, it starts at page number 20, my lords. The relevant portion is at page number 25, para number 16. This is a case pertaining to amendment. The words due diligence have not been defined in the code. According to Oxford Dictionary, the word diligence means careful and persistent application or effort. Diligent means careful and steady in applications to one's work and duties, showing care and effort. As per Black laws.
I don't need to be taught about what is diligence.
Yes, my lords.
Yes.
They have clearly not shown any due diligence. And if a party wants to amend the pleadings after trial has commenced, they have to show, my lords, due diligence. That is part of the proviso under order 6 rule 17. And courts have held, my lords, we cannot ignore due diligence being proven and allow the party to amend the pleadings.
Yes, ಕೊಡಿ judgments ಏನು ನಿಮ್ದು?
In fact, I passed on the
ಇದಾ?
list of authorities.
2024 ಅಂದ್ರೆ ಯಾವ್ದು?
ಹೌದು, ಇದೆ. In fact, may I request?
4 ಬದಲು 24 ಅಂತ ಓದಿದ್ದೀರಾ?
2000, serial number 6, my lord. Page at 75, to
My lords,
83.
my lords, just one more case, my lords. Page number 16, my lords.
Wait, piecemeal better, wait.
Starts at page number 18.
1 minute,
Yes,
sir.
my lords.
11 and 12, my lord. Office stuff.
Office note.
ಹೌದು.
Huh?
2024, 11 and 12, my lord. Sorry, my lord. Your lordship's card. What copy is here? 11 and 12 is irrelevant. May I request? Ultimately, my lord, what is required is the determination of the adjudication of the case in controversy. Now, your lordship kindly is 11 and 12.
My lords, it starts at page number 9, relevant page, my lords, at page number 16. Starts at page number 9, my lords. Kindly take page number 16. Para number 19, my lords. It is the primal duty of the court to decide as to whether an amendment is necessary to decide the real dispute between the parties. Only if such a condition is fulfilled, the amendment is to be allowed. However, proviso appended to Order 6 Rule 17 of the Code restricts the power of the court. It puts an embargo on exercise of its jurisdiction. The court's jurisdiction in a case of this nature is limited. Thus, unless the jurisdictional fact as envisaged therein is found to be existing, the court will have no jurisdiction at all to allow the amendment of the plaint. Jurisdiction, what they're referring to, my lord, is due diligence.
We'll see. Yes, 2024. Dinesh Goyal. Yeah.
Lords, there are hundreds of decisions, my lords, which have
Hundreds
held
of one kodi sir, ಆಮೇಲೆ 23 ಆದ್ಮೇಲೆ.
23. I'll get it.
2 0 ತೆಗೆದ್ಬಿಡಿ, ಒಂದು ಕೊಡಿ ಸರ್.
I don't have early.
Yes. Heard reserved.
Lords, matter is posted on day after tomorrow. It's at the
The
final
concerned
stage,
court-
my lords.
The concerned court shall defer its proceedings till the pronouncement of the judgment.
My lords, at the final stage, my lords. 2011, we
We'll
have been
see,
fighting
sir.
for the matter.
We'll see.
At the end, my lords, they come and file this
They will
amendment
see-
application.
We'll answer all that. Na reserve ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
No,
Yes.
grateful, my lords.
ಇದು ಯಾವ್ದು ಮೇಡಮ್?
For the petition. My
80?
application is.
ಎಷ್ಟು ದಿನ ಡಿಲೇ, ಎಷ್ಟು ವರ್ಷ ಡಿಲೇ, ಎಷ್ಟು ತಿಂಗಳು ಡಿಲೇ?
1 year delay. Because they are the senior citizens.
ಅದೇ ಅದು ಡಿಲೇ ಕೇಳಿ, ಅದಕ್ಕೆ ಸೀನಿಯರ್ ಸಿಟಿಸನ್ ಉತ್ತರನ?
ಅಲ್ಲ, they are
ಡಿಲೇ
shown
ಎಷ್ಟು ಅಂತ ಕೇಳಿದೆ.
1 year.
1 year.
1 year, 2 months.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ಲಿಲ್ವಾ?
86.
What is sufficient cause shown?
That is in the application memorandum of facts
ಏನ್
filed by the
ಹೇಳಿದ್ದಾರೆ?
council.
ಏನ್ ಸಫಿಶಿಯಂಟ್ ಕಾಸ್ ಏನಿದೆ? ಎಲ್ಲ ಇನ್ಸಫಿಶಿಯಂಟ್ ಕಾಸ್, ಸೀನಿಯರ್ ಸಿಟಿಸನ್ಸ್ ಅಷ್ಟೇ.
In the lordship, may I kindly see the cause title. They have shown the age of the 13th defendant and 14th defendant. 49 and 49 years.
49 and 49.
47 years. Actual 56 years. I have produced the Aadhaar card along with the wakalat.
So that is the reason.
Because I could not able to contact the council.
Age verification.
And on medical ground also, is 86 years, and that is the reason. And against me only the injunction, and against other defendant suit for partition. Their father sold the property to me.
The petitioners, plaintiff, sorry, defendant 13 and 14 are before this court calling in question an order passed declining to grant time for the purpose of filing written statement. The learned counsel for the petitioner in the petition has averred with regard to the cause that led to non-filing of the written statement, though the non-filing of the written statement within time. The apex court has held in a non-commercial suit extension of time for filing of written statement. The time limit for filing of written statement should be liberally construed. The subject suit is not a commercial OS. Therefore, in the light of the judgment of the apex court in the case of 2005 4 SCC page 480, as followed by the apex court in 2022 SCC online SC page 163, 163. Further proceedings before the concerned court shall remain stayed till the appearance of the respondents. Petitioner shall serve on the counsel who represented the respondent in the trial proceedings and file an acknowledgement in the next 3 days. List the matter on 23rd in preliminary hearing.
Dispensation for respondent 4 to 19.
Yaar contesting yaru?
Only contesting 1 to 3 plaintiffs.
Respondents 1 to 3.
Contesting
Separate order
respondent.
sheet ಮಾಡ್ಕೊಳ್ಳಿ. a learned counsel files a memo seeking dispensation of service of notice upon respondents 4 to 9 on the score that they have not contested before the concerned court. The memo is taken on record. Subject to and service of notice is dispensed with the risk of the petitioner. Ad ಮಾಡ್ಬಿಟ್ಟು separate order sheet entry ಮಾಡಿ. Yes, next.
Admission 83.
My lords, I appear for the petition in this case, my lords.
Where are you?
My lords, I am outside, my lords.
You are in outside.
I may be
Come
permitted
come inside.
short accommodation. I'm in family court, my lords.
Then petition dismissed.
My lords, I may be permitted short accommodation, my lords. I will come for this court.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಂತ ಹೇಳ್ಬೇಕು. ಅದ್ ಬಿಟ್ಟು ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಂದ್ರೆ
Sorry, my lords. Apologies.
306 ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ. It has to be allowed straight away. Yes. ಕೊಡಿ ಮೇಡಮ್. Respondent served. ವಸಂತ ಕುಮಾರ ಅವರು ಇನ್ಯಾವುದೋ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. There is heard the learned counsel appearing for the petitioner. There is no representation on behalf of the respondent. Awaiting his appearance as a last chance, list the matter next Tuesday. In the event the respondent would not be present, orders would be passed on hearing the counsel for the petitioner. Yes. Interim orders subsisting will continue till the next day. Jagdish sir, accused number 5 ಮೇಲೆ ಏನಿದೆ A1 to A2 ಕಾರಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಹಿಂದೆ ಹೊಡೆದಿದ್ದಾರೆ, ಅವ್ರಿಗೆ ಎಳೆದಿದ್ದಾರೆ, ಎಲ್ಲ ಕಾರಿಂದ ಆಚೆ ಎಳೆದು ಹೊಡೆದಿದ್ದಾರೆ. A5 has done nothing except calling and telling ಅವ್ರು ಕೊಡ್ತಾರೆ ಅವ್ರ ಹತ್ರ ಇಸ್ಕೊಳ್ಳಿ ಅಂತ. ಅದು ಬಿಟ್ಟು ಬೇರೆ ಏನಿದೆ? 420 may get attracted to him but not 307 or 397. That's the prima facie. If you read the charge sheet page 53-54 ಹೋಗಿ, page 52-53. ಎಷ್ಟು ತೆಗ್ರಿ ಸರ್ ಅದೇ ಅಲ್ವಾ?
ಅಷ್ಟೇ
420 ಗ್ಯಾರಂಟಿ
420
ಅದು 100%.
ಅಲ್ಲ, ಅದ್ರ ಬಗ್ಗೆ ಕಾಗ್ನಿಷನ್ಸ್
initially ತೊಂದ್ರೆ ಇಲ್ಲ. I will observe that, take cognizance on that.
ಅಲ್ಲಿ ಹೈದರಾಬಾದ್ನಲ್ಲಿ ಒಂದು 420 ಕೇಸ್ ರಿಗಾರ್ಡಿಂಗ್ ದ
420 is now included in the charge sheet, sir.
That's correct.
Yes.
Regarding the same, one more trial is going on in Hyderabad. Those details I'll get it.
Maybe, but you can't escape 420 at all. You are lured the complainant.
Your Lordship may
No doubt. 307, 397, no problem. There is against accused 1 to 4.
But your Lordship may kindly consider this. It would be in the interest of prosecution itself that the things are made clear in the sense. If 420 trial goes on there and I get acquitted, then I cannot be tried for anything in this case.
Where is the 420 trial going on?
In Hyderabad.
Which are those proceedings?
Those details I'll get. Those details.
ಅವ್ರಿಗೂ ಕೊಡಿ details ನೀವು ತಗೊಳ್ಳಿ. Otherwise A5 ಮೇಲೆ ಅಷ್ಟು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನಿಲ್ಲ. A1 to A4 horrendous allegations. They can't escape 307 also. This man nothing. 420 correct ಆಗಿದೆ. You appear to be all over.
Yes. You know, now the cognizance has not been taken.
Let's see. ಅದು ಕೊಡಿ. Produce those documents. Monday ಹಾಕ್ಲಾ next?
10 days time ಬೇಕು.
10 days time.
Notice also. Notice.
Yes. ಅಲ್ಲ ಸ್ಟೇ ಕೊಡಕ್ಕೆ ನೋಟಿಸ್ ಬೇಕಾಗಿಲ್ಲ. 10 days time ಬರಲಿ. Yes. Till then ಏನು urgency? Produce that 420 ಒಂದು already ನಡೀತಾ ಇದೆ ಅಂದ್ರೆ ಕೊಡ್ತೀನಿ. ಇಲ್ಲದ್ರೆ this 420 will go on. Yes. List next Wednesday. ಸಾಕಾ? 18th.
Please.
Yes. List on 18th at the request of the counsel appearing for the petitioner.
85.
Request for 10 days accommodation.
ನಿಮಗೂ 10 days. You taking cue from that submission?
Statement objects.
10 days time. Learned counsel.
His passport is expiring, my lord. It's okay.
Passport?
No, his accused person's passport is getting expired. Before that, his matter is getting over.
When, sir? August. ಅಷ್ಟರ ಕಾಯಿಸಲ್ಲ ಬಿಡಿ ನೀವು. Yes. Learned counsel Madhukar Deshpande seeks 10 days time to file statement of objection.
Next Monday, my lord.
10 list Wednesday same.
10 days.
12 days ಆಗುತ್ತೆ ಸರ್. Yes. 10 ಆಯ್ತಲ್ಲ 10, 9th, yes. Next Friday, 27th.
Please.
20th.
Much obliged.
86.
CRP move ಮಾಡ್ರದು ಯಾಕೆ? Why madam?
Order 6 Rule 17 application, Your Honor, rejected by the trial court.
Oh, rejected.
Yes, Your Honor. The trial has not been yet to commence, Your Honor.
Where is the order?
Order at page number 53, Your Honor. Sorry, sir.
When is the next date?
12/6, Your Honor.
Huh?
12/6. Next Thursday, Your Honor.
List on 11th in preliminary hearing. Next.
Stay application.
ಇದೆಯಾ? ಇರ್ಲಿ ಬಿಡಿ.
Evidence commence ಆದ್ರೆ
12th ಅಲ್ವಾ ಕಮೆಂಟ್ಸ್ ಆಗೋದು?
this month.
ಕರೆಕ್ಟ್. ನಾನು ಈ ನಾಡಿದ್ದು ಹಾಕಿರೋದು 11th.
That's all.
Admission, CRPL admission, yes.
87.
It's a matter which
ಅದೇ 2 years ಮುಂಚೆ.
yes, my lord. Yeah.
Now what do you want?
There's some directing the trial court to issue delivery warrant for position.
This position of law I could not go through, man. But we'll take it tomorrow. Could not go through the papers tomorrow. There is some doubt about this statement, that is why, yes.
Yeah, we have, I've got one more.
Rahul Shah kodi innond kodi.
2025.
Yavadar kodi.
Same. The same ratio the court has adopted, which was I had submitted last.
Let's paragraph.
Yeah, it is. Yeah. Paragraph 20. Yeah, 26, 27, 26 and 27, page 69, madam.
All right, tomorrow.
Yeah, paragraph,
Tomorrow,
page
tomorrow.
17, paragraph 22A. Also.
We'll take it tomorrow, yes.
Orders 88.
Maintainability.
Maintainability of the petition under section 9 before the civil court in a commercial dispute is rejected, my lords. If my memo were to be allowed, my lords, then this.
Why maintainability?
Plus, it's the agreement under which the arbitration is there, my lords, is a commercial, covers a commercial dispute. That was the objection raised by us. The trial court says, no, this relates to education, therefore it's not commercial.
Recovery of money na?
Recovery of money, Allah.
Then ಎಷ್ಟಿದೆ?
That's not
What
recovery
is the relief sought?
Relief sought is that I must deposit the fees collected in the school in a designated bank account. That's the order granted by the trial. That's the prayer sought for, my lords. This is an agreement entered into, my lords, where in respect
Yes,
of
sir.
three.
I undertake to appear for the respondents. My lords may have it any day. I don't have a copy of the petition and the papers. I will.
furnish. Plus the difficulty is, my lords, I have filed a application before the commercial court under section 9. That's on 11th, my lords. Now this order will be produced.
List the matter on 11th in preliminary hearing. Learned counsel so and so undertakes to enter appearance for
All the four
All
respondents.
all the respondents.
All the four respondents.
Registry to print the name of so and so as appearing for the respondents. Yes.
The office objections.
Office objections overruled. List the matter on 11th. Yes.
Great.
Appear for the petitioner.
Next.
90.
My lord, interim order to be extended in 89, my lord.
ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಯಾವ್ದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಡಿ. Yes.
Deeply obliged.
A week, 2 weeks time to do the needful.
91.
Same order.
92.
Serial number 90. Serial number 90, my lord.
1 minute. Huh?
My lord, 91, there's an interim order operating against me, my lord.
Vacating stay ಹಾಕಿದಿರಲ್ಲ.
Vacating stay
Rectification of office objections ಯಾವ್ದ್ರಲ್ಲಿ?
The IA number 2, the office objections is that they have not been served with the IA. my lord.
Have you
We've
served
already
it now?
We've already served them.
Learned counsel for the respondent submits office objections quae, the statement of objections stands complied, registry to verify. List the matter on next Wednesday in the, under the caption hearing on interlocutory applications.
Serial number
May kindly be
Interim order subsisting will continue till the next date of hearing. Next.
Serial number 90, my lord. Previous occasion also interim order not extended, my lord.
This time also we will not extend. Interim order stands extended to the next date. 90 il ಮಾಡಿ madam. Maribadi. Yes.
Please, my lord. The lena responding number la.
ಮಾಡಿದ್ದೀನಲ್ಲ.
Please.
92.
Prepare for the petition, my lord. And I have moved that application for early hearing.
Early hearing rejected. Yes. Post the matter IA 1 of 2025 for early hearing stands rejected. List the matter on 2nd June preliminary hearing. Next.
2nd July.
July, sorry.
93.
I am for the
Consideration of interim prayer.
Yes, Lord. What has happened is, in the trial court, there was an interim order in my favor. That order was assailed before the first appellate court. So after hearing the matter, keeping it for more than 1 year, orders have been passed and appeal has been allowed, and set aside the well-considered order passed by the trial court. The facts are this, my lord. The plaintiff had executed a registered agreement of
Day after tomorrow in preliminary hearing. Next.
94.
On filing.
Your Honor,
Where is the acknowledgement?
Your Honor, in the previous, this one, previous date, you have given the hand summons, Your Honor, issued the hand summons.
Where is the acknowledgement of service?
Not able to service, serve the, this one, Your Honor, no, summons to the respondents as unavailable.
Unavailable?
Two, respondent 1 and 2 are out of the station, Your Honor, and respondent 3 has given NOC to his client, and respondent 4 is ex-party.
Emergent notice to the respondents. Yes. Next.
Fixed date on 23rd, Your Honor.
Let it come, sir. Put up after service of notice. Yes.
Much obliged, Your Honor.
ಮುಂಚೆ ಸರ್ವ್ ಅಂತ ಹೇಳಿದ್ದೆ ಅಷ್ಟೇ. ಎಸ್ ನೋಟಿಸ್ ಆಗಿಲ್ಲ. ಸರ್ವ್ ಆನ್ ಅದೇ ಇಲ್ವಂತಲ್ಲ ಅದಕ್ಕೆ ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್.
95.
For the petition is also.
Appearing for respondent 4 and 17.
not been filing wakalat on behalf of 4 to 17.
On filing of wakalat in respect of ಯಾಕೆ ಅದಕ್ಕೂ ಡೈರೆಕ್ಷನ್ ಕೊಡ್ಬೇಕು ವಕಾಲತ್ ಹಾಕಿ ಅಂತ.
They are not necessary parties because this is only an amendment application. No, because they were parties in the suit. I have to
Relay memo that need not be served ಅಂತ.
No, they are already served. They are already served. The advocate has undertaken to file wakalat.
What's the order?
The order is an amendment application.
617.
6 rule 17. There's a
Filed by the plaintiff.
When?
Lord,
Stage.
Stage is, my lord, after they got impleaded. They got impleaded as an additional defendant. My lord, after
that is allowed?
Allowed.
Impleadment is allowed.
I filed my written statement. I've also let my evidence also. It is for cross-examination of DW2.
ಏನ್ ತಪ್ಪು?
No.
ನಾನ್ ಕರೆಕ್ಟ್ ಆಗಿದೆ ಅಂತ ನಾನು ಹೇಳ್ತಾ ಇರೋದು. My lord, what
I am
happened
for
is
the defendant. And they are the
ನಿಮ್ದು
it is a suit for specific performance, my lord. At the stage of defendant evidence, my lord, they came and impleaded, saying that they have purchased a portion of the property. That came to be allowed. After they got impleaded, my lord, I asked for an additional prayer and certain facts saying that.
No, it's come in orders. Let it come in preliminary here.
Very well.
Listen, big group ಅಲ್ಲಿ ಬರ್ಲಿ. Listen, 25 da. Listen, preliminary hearing on next Wednesday, 18th. Yes. Next.
Maybe taken up after 25th. There's a chance that the settlement can make on.
List on 25th, 27th.
27th.
Yes, grateful.
Much obliged.
Madam, ಎರಡು ಇದೆ ಯಾವುದು?
96.
Petition. My lord, I'll take out fresh steps, my lord.
ಏನ್ ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
Interim orders.
ಅದಕ್ಕೆ ಸ್ಟೆಪ್ಸ್ ತಗೊಂಡಿಲ್ಲ.
ಇಲ್ಲ, my lord, I've already taken steps to 1 to 7 has been served, 12 and 13.
2 weeks to do the needful.
Please.
Interim order subsisting will continue to
Great.
the next date of hearing.
97.
Your Lordship, counsel for the petitioner, it's for issuing a direction with regard to disposal of the IAs 1 to 3 in a time-bound manner. The IAs are filed under Order 13. That's all. Order 39, Rule 1 and 2. Because the suit has been filed in September 2023, And there's been no ex parte order as there was caveat filed by some of the defendants. And even they have filed their written statement and memo for adopting it as objection to IA 1 and 3 in October 2023 itself. However, the matter
Since then order is not passed on the application?
No, Your Lordship.
The petitioner is before this court seeking the following prayer. The petitioner is the plaintiff. Along with OS 5696 of 2023, files application and order 39 rule 1 and 2 seeking injunction, temporary injunction. The said application is said to be pending even as on date and no orders are passed by the concerned court. In that light, the aforesaid direction is sought in the light of the prayer being innocuous and the act of the court in keeping the application pending for the last 24 months is what shocks the court. Therefore, the court shall pass appropriate orders on order 39 rule 1 and 2 within an outer limit of 15 days from the date of receipt of the copy of this order. If
Your
not,
Lordship, applications number 1, 2, 3, all of them are under order 39.
on IA 1, 2 and 3. Order 39 rule 1 and 2 on IA 1, 2 and 3. Yes. Ordered accordingly. Yes, next.
98.
Appearing for petitioners, Your Lordship. I'll take on
Unserved, 2 weeks to do the needful. Next.
interim order to
Interim
be
order
extended.
subsisting will continue to the next date of hearing.
Great.
In the event needful is not done, FPF steps tagondilva?
We have taken first time, Your Lordship. It has been returned for the
Yes, so
second
it's
time.
2 weeks finally granted to do the needful. Next. Interim order subsisting. Madam, held over interim order idre continue.
Respond one this case. My lord, senior is not well. Kindly list it for next week, my lord.
Unserved, returned with postal. 2 weeks time to do the needful. Next. 100.
100.
Post immediately after service of notice upon respondents 1 to 4. Interim order continue. Madam.
101.
My lord, in this, I appear for petitioner. My lord, in this, I am filing a
Who is
memo
R3?
to.
R3, there is no relief sought for against
R3 is one of the.
Memo. Learned counsel for the petitioner files a memo seeking dispensation of service of notice upon the third respondent on the score. No relief is sought against the third respondent.
And your lordships may kindly see, I am filing a memo to refer the matter to the mediation center. Because, my lord, the order passed on RFA is challenged by the respondent before the Supreme Court. The Supreme Court has directed, my lord, to get the matter settled amicably.
Parties, who is the petitioner?
On the last two occasions, the matter has been referred to the mediation, please, your lordship, but unfortunately, none of her appeared and there was no compromise or between the
ಈಗ
parties.
ಯಾವತ್ತು appear ಆಗದೆ ಹೋದ್ರೆ I will pass orders on
This,
merits.
they have mediated it. Unfortunately, they were unable to arrive at any kind of settlement. If you- this
Settlement is not arrived at.
No, please, your lordship.
Yes, madam.
ಒಂದು ವರ್ಷದ ಹಿಂದೆನೆ ಆಗಿತ್ತು. All the parties have
ಮತ್ತೇನು ಅದನ್ನೇ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ ಮತ್ತೆ
ಇದು ಮತ್ತೆ
ಒಂದು ವರ್ಷದಿಂದ ಆಗಿದೆ. Supreme Court has again
again they have made a submission before the honorable
Correct.
Supreme
Supreme
Court.
Court has directed. What do I do?
Leave it to your lordship,
Yes,
because
that is
if
why
even ಅಲ್ಲಿ ಹೋದ್ರುನು ಅಲ್ಲಿ
the apex court has observed as follows in the list between the parties. The apex court directs the parties to explore the possibility of an amicable settlement. Counsel appearing for the respondent submits that 1 year before the same submission was made and the same is carried over to before the apex court and they are not coming forward to the settlement, or there is no settlement between the parties.
there is no settlement. Not that they
Coming
didn't come
forward,
forward.
there is no settlement between the parties. In that light, in the light of the fact that the apex court has directed to explore the possibility of settlement, I deem it appropriate to give the parties one chance to explore the possibility of a settlement. If there is no settlement, if there is no settlement arrived at on the next date, the matter would be heard on its merit. The parties to appear before the mediation center on date kodi.
In any date, please. your lordship.
Next Monday ತಗೊಳ್ಳಿ madam. List on 16th at 3 p.m.
Please,
List the matter on 18th.
Grateful, your lordship.
ಏನು ಆಗಿಲ್ಲ ಅಂದ್ರೆ will take.
ಆಯ್ತು sir.
ಮತ್ತೆ ಅದೇ submission ಮಾಡಿದ್ರೆ ಆಗಲ್ಲ.
Grateful.
Next.
102.
Post immediately after service of notice upon respondents 1 to 4. Interim order continue.
103.
Same order.
104.
Your lordship, date may be given in this matter. Your
Immediately after service. Madam. Yes, next. Non-filing of representative before trial court. A week's time to do the needful. Yes.
105.
I am appearing for the
Memo
petition.
for dispensation.
Yes. Notice to R2 to 15 may be dispensed with.
The council, where is the memo, Kodi? Counsel for the petitioner files a memo seeking dispensation of service of notice upon respondents 2 to 5. The
2 to
memo is
15.
taken on record. Service of notice to respondents 2 to 5 stands dispensed with at the risk of the.
2 to 15 plus.
Has filed a memo on the matter. 2 to 15 are dispensed with at the risk of the petitioner.
Plus I sought for plus interim order plus.
List on
Written statement is.
next Monday in preliminary hearing.
Plus
Next.
case is posted today, tomorrow. Plus.
Today?
Tomorrow.
Tomorrow, next Monday ತಗೊಳ್ಳಿ. Yes, next.
Please.
Day after tomorrow or Thursday.
ಯಾವುದು sir?
107.
106 ಅಲ್ಲಿ ಇದೀನಿ
I'm
sir.
so sorry. We are so sorry. We are so sorry.
Lordship, 103 stay is not extended to
That
be
will
extended.
wherever interim order is there, it will get extended.
Much or less.
Madam, ಅದನ್ನು ಹೇಳಿಲ್ಲ ಅಂದ್ರೂ interim order ಇರೋ ಕಡೆ extend ಮಾಡು.
106.
For the petitioner, my lord. Hand summons,
ಬೇಡವಾ?
I'll take
ಬೇಕಲ್ಲ?
it.
ಇದರ
Have it on Wednesday, my lord, my request.
council seeks a day's accommodation to do the needful. In the event hand summons are taken, list on next Monday.
Lord, 102, my lord.
102 ne 102 na
102 ಅಲ್ಲಿ, my lord.
106
102 ಅಲ್ಲಿ, I could not,
102 ಅಲ್ಲೇನಾ ನೀವು ಇದ್ರ
I was just here.
just here wait yes next
Matter is posted for
wait
16th in
sir
trial court.
yes post immediately after service of notice ಅಂತ ಹೇಳಿದೀನಿ yes next you should be here sir
I was right here.
107 yes Sunil
Can it be on Thursday or Wednesday?
Lordship, I can say, here, your Lordship, with 39 rule 1 and 2 application, against that writ petition is filed and obtain order of stay. Taking advantage of the stay, your Lordship can see he is
There is a section 8
interfering with the
application
position of
pending.
this petitioner.
The suit was filed
There is
with
a
the
school
section
is
8
running.
application pending.
Now your Lordship
And
can
not
say,
when the section 8
whom do
application.
I hear if both of you are at once saying
I filed an application for vacating stay.
Can be on Wednesday or Thursday, if it is on.
vacating stay ಹಾಕಿದ್ದೀರಾ
Wednesday or Thursday.
post the matter
School reopen ಆಗ್ಬೇಕಾಗಿತ್ತು because of these persons, your Lordship.
ಹೌದು ಯಾವ್ದು ಏನ್ ಸ್ಕೂಲ್
No, no, my lord, I'll just.
ಶಾರದಾ ವಿದ್ಯಾನಿಕೇತನ್
Sharda
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ
Sharda Vidyaniketh.
That what happened, your Lordship, you see, Sharda, the land was blocked.
blocking ಶಾರದಾ ವಿದ್ಯಾನಿಕೇತನ್
Nobody is blocking.
The
Sharda.
land was granted to them. Then subsequently, your Lordship, we executed the fee sharing agreement in the 2017 and handed over the position to the Overall Education Trust. Then your Lordship can see they filed a CMP application, arbitrator was appointed, no steps was taken. And then subsequently, your Lordship, on the strength of that, my lord, then again he came before the court. Then your Lordship will see 1-4
ಕೇಳ್ಬೇಕು ತುಂಬಾ ಇದೆ
arbitration application ಇದೆ.
ಇದೆ ವೆಡ್ನೆಸ್ಡೇ
Wednesday, orders are better because the process has, I filed in a wakala.
ವೆಡ್ನೆಸ್ಡೇ ಅಂಡರ್ ದಿ ಕ್ಯಾಪ್ಷನ್ ಹಿಯರಿಂಗ್ ಆನ್ ಇಂಟರ್ಲೋಕೇಟರಿ ಅಪ್ಲಿಕೇಶನ್
Please,
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ತಾನೇ ಇದೆ
ಹೌದು.
Date given as 23/6/25. Who moved it?
Moved the matter. They have
We
moved
filed
the matter.
this statement of objections and vacating the interim.
So ಅದಕ್ಕೆ ಡೇಟ್ ವೇರಿ ಆಗ್ಬೇಕಾ?
Date ಎಲ್ಲ ಬೇರೆ ಆಗ್ಬೇಕು ಅಂತಲ್ಲ, your Lordship can see, because
Wednesday.
they are doing unnecessary things, because they ransacked, even
Ransacked.
CCTV footages were demolished, even benches, even teachers were kept in the room and locked. The police complaint is lodged. Even-
Teachers kept in the room and locked.
Yes, your Lordship, the teachers were locked in the room. Then thereafter, your Lordship, they lodged a complaint. That case is registered. 3 cases registered against them.
Criminal case.
Criminal cases.
ಎಲ್ಲ ಆಗಿರೋದು ಯಾಕಂದ್ರೆ ಫೀ ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್.
ಹೌದು, ಫೀ ಶೇರಿಂಗ್ ಅಗ್ರಿಮೆಂಟ್. ಅಲ್ಲ,
money-
ಅವ್ರಿಗೆ ಏನಾದ್ರು
money-
ದುಡ್ಡು
money.
ಬೇಕಾದ್ರೆ ಕೇಳಿ, ನಾನು ಕೊಡ್ಸಕ್ ರೆಡಿ ಇದ್ದೀನಿ. ದುಡ್ಡು ಅದು ಇಲ್ಲ.
ಓ ಕೇಳ್ಬೇಕಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ, your Lordship, we paid 1 crore 87 lakhs.
ಆಯ್ತಲ್ಲ.
1 crore 87 lakhs we have paid. Extra amount has been paid.
Not sir.
Even
There have been a
arbitration
series
was,
of around
arbitrator was
8
appointed.
offshoot litigations, not in this.
The arbitrator was appointed. They have not pursued. They themselves have filed an application.
It is obvious that fee sharing agreements will result in criminal and civil cases. They will
30
gallow.
police personnel
Now
got
the
stationed
sufferers
in
are parents.
Not because security guards are assaulted. 30 not police personnel are stationed in the school. For what reason? Not on whose say we don't know that. And not that was
Security,
question-
sir.
And that was
Security,
questioned in the
because
writ.
parents.
The writ appeal came, the writ appellate court not came down heavily, questioning the conduct of the police and the state not involving in such disputes.
ಅಲ್ಲ
And-
ಸ್ಟೇಟ್ ಗವರ್ಮೆಂಟ್ ವೇರ್ ಇಟ್ ಇಸ್ ನೀಡೆಡ್ ಕೊಡಲ್ಲ. They will be stationed
Yes, sir.
like this in a school and somewhere something will happen where policemen are not there.
And one first FIR, not then 107 notices CRPC, not then after that, not we have a second FIR. All these things are set. They have been stayed by the court.
Even
Then
your
not they
lordship
file a
is
suit.
aware.
Not previously
From
they
the
had
orders
filed a
on
section 9
39
application.
rule 1 and 2, the writ, how can the writ is maintainable? It is appealable order.
Not the law is very clear. Not in the presence of a section 8 application, not in the pendency of a arbitration of the agreement. Not the court cannot go ahead with the merits of the suit, starting from 2003 and Cox and Kings recently. Not there is a procedural violation by the court, and that has resulted.
Look,
in the
who
writ.
restricted them
That is why
to
not- there is a lot to argue in the
when
matter.
the arbitrator
Your
was
lordship may see the-
appointed?
your
No
lordship may see
proceedings
the
were
order, but
initiated.
not it has been passed
Even
first.
they have not filed the counter application, counter claim.
Which are you referring to? Sukanya Builders?
Sukanya is overruled in Cox and Kings. It has been
Overruled in Cox.
it has been impliedly relied and overruled not by in Cox and Kings the constitutional bench. That was exactly your lordships where the court said we cannot split, and that is Sukanya holdings.
That's also section, when section 8 petition.
Section 8, and prior to that, that Hindustan Petroleum, that is where it held the right law, and that has been upheld not in Cox and Kings recently also, where even a non-signatory to an arbitral agreement not can go ahead in a to an arbitration. Ultimately, not here the case was once there's an application under section 8, the question not was section 8 had to be decided first or the remainder. The law is very clear that the merits of the case cannot be gone into in the presence of a section 8 application. There's a division bench ruling also. But can it be had on Wednesday? I don't want to, because
It is on Wednesdays.
Top of the
That
list, because your lordship
Top
will
of
say,
the list.
your lordship is going to see what will happen after the orders are
Under
here.
the caption interlocutory applications, list day after tomorrow. Yes.
The interim order
Idea interim order. Idra continue.
Taking advantage of that order only, they have.
Interim order subsisting shall continue till the next date of hearing. Yes, next.
Hang on, 108.
Respondent, my lord, this matter, my lord.
Vacating stay.
Vacating stay, my lord. Along with which, my lord, the petitioner has filed.
Vacating stay will take everything on 18th. Because tomorrow, this Wednesday, I have listed so many. Yes, list on 18th under the caption, same, under the same stage. IA 1 of 24 for posting. Next, next.
Please.
Yes.
109.
Interim order subsisting will continue, Madam. Not.
My lord, may I request for Monday, my lord, serial number.
ಈ ಮೆಮೊ ಹಾಕಿರೋದು ಅದು IA ಹಾಕಿರೋದು for posting, again adjournment.
Allah,
IA
my lord,
2024 stands rejected. List the matter next Friday, 20th. Yes, next.
110.
Same, 18th.
2 weeks ಇಲ್ಲ sir. Senior not well, 2 weeks.
2 weeks.
I filed vacating.
ನೀವು petitioner ಹಾಗಾದ್ರೆ next Wednesday.
Next week.
Senior well ಇಲ್ಲ ಅಂದ್ರೆ ನೀವು ರೆಡಿ ಆಗಿ. ಈಗ ವೆಲ್ ಆಗ್ತಾರೆ ಅಂದ್ರೆ ಎಸ್ 18th.
111.
Same 18th. All interim orders will be extended. Don't.
Filed a vacating IMNOs, can there be a date?
18th, sir. Yes.
12.
My lords, I filed an NOC wakalat in the morning. Kindly have it
18th.
day after tomorrow.
18th. Yes. Interim order election. Yes.
130.
Well, I appear for the petitioner in this case. I've sought for direction.
Respondent
to deposit the amount. Not the
What amount?
amount which was not
check
settled
bounce
before the
in
local alert.
execution
Yeah, 138 proceeding.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್
Thereafter-
ಹಾಕಿದೀವಿ. ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಹಾಕಿದೀವಿ. ಚಾಲೆಂಜಿಂಗ್ ದಿ ಅದಾಲತ್ ಮುಂದೆ.
ಪರ್ಸು ಮಾಡಿ ಇಲ್ಲೇನು?
ಅಲ್ಲ,
ಅಲ್ಲಿ
ಇದ್ರಲ್ಲಿ
ಪರ್ಸು ಮಾಡಿ.
ಅದೇ
Criminal petition stay ಆಗಿದೆಯಾ?
ಮೀನ್ ಟೈಮ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಹಾಕಿದಾರಲ್ಲ.
Criminal petition stay ಆಗಿದೆಯಾ?
ಇನ್ನ ಇಲ್ಲ. It has not come up. Last time before vacation it has come up.
I'll give you a
Now it
week's
will-
time. You get it posted, or if no order is passed there, we will pass orders here. Yes, list on 20th.
2021 is the order passed before the magistrate.
List on 20th. Yes.
And after 20th, my lord.
No, sir, list on
ಅಲ್ಲಿ-
20th.
ಅಲ್ಲಿ
Otherwise, I will
post
grant, I will direct the
ಅಲ್ಲಿ
court.
ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು ಅದಕ್ಕೋಸ್ಕರ.
Move ಮಾಡಿ sir.
ಮಾಡ್ತೀನಿ. Let it be on 24th
482
or
court ಅಲ್ಲಿ
25th.
move ಮಾಡೋದು ಬರಲ್ಲ ಅಂತ move ಮಾಡಿ first.
482 does not arise because
ಅದು ಆಮೇಲೆ ನೋಡೋಣ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
ಅದು ಎಲ್ಲಿ ಮೂವ್ ಮಾಡಿದಾರೆ ಮಾಡ್ಲಿ ಬಿಡಿ ಸರ್, ನಿಮ್ಗೆ ಯಾಕೆ? Yes. Rectification of order dated 29/4.
I appear on behalf of the respondent number 1 and
Which
respondent
has to
number
go
11 in this
before the
case.
same honorable judge, sir, if it is
Your lordships had
correction
passed
of
this
an
order,
order.
my lords. Your lordships had passed this order.
I
That's
have
why we
passed the
moved.
order.
Yeah, please, my lords.
Seriously. What is this?
Lordship, I appear for the petitioner, your lordship.
Respondent number 11's name is not reflecting in the final order that has been passed.
Name is not reflected.
And also, my lords, the other rectification is
Ah.
the impugned order dated 22/2/2024.
Whose name has to be reflected?
Respondent number 11, my lord. That's in the main petition. Amended plaint was also filed on 24/4.
Amendment is allowed?
Very well, my lord. Yes.
The R11 is not even there in the list.
It's not there in the final order that's been passed.
All right. Oh, settlement.
And please, my lords, and as per the settlement, the order of the clear error was not
Party and
quashed.
council name, Amele.
The caution, your lordships in the final order had quashed the order of the RERA. But in fact, that is relevant for us because that is what conferred rights and ownership over R11. So we don't want
agree
it.
wherefore the parties may please receive.
As per in the operative portion, my
Order
lords.
so and so. The learned counsel for the petitioner submits that in terms of the settlement, the order need not have been quashed. Need not have been quashed as quashing of the order is resulting in grave prejudice to them. In the light of the settlement, therefore the order would read as follows. In the light of the aforesaid settlement, the petition stands disposed in terms of the settlement.
Very well.
Lordship, just one submission, your lordship.
The
Your lordship
correction
had
be
recorded-
effected too, and a certified copy be issued to the petitioner.
Lordship, just one submission. Your lordship has recorded in terms of submissions of the petitioner. My learned friend is appearing for the respondent. Your lordship.
Respondent number 1.
Application has been filed by them.
Respondent number 1 and 11.
ಏನೇನ್ ಬರ್ಕೊಂಡ್ರಿ ಹೇಳಿ. ಅಲ್ಲ madam, the petition ಹಿಂಗ್ ಬರ್ಕೊಳ್ಳಿ. The subject petition was disposed recording the settlement in terms of the order dated 29th April 2025. The counsel for the respondent has now moved the matter for correction of the order on 2 scores. One being the inadvertent omission of R11 being printed in the order, and the other, the order resulting in quashment of the proceedings pending before RERA dated passed by RERA 22/2/2024. The learned counsel for the respondent submits that is the order that inured to the benefit of the respondents, and therefore that ought not to have been quashed. In the submission of the counsel for the respondent merits acceptance. Therefore, the said paragraph will now read as follows. I'll mark madidini madam paragraph. In the light of the aforesaid settlement, the petition stands disposed in terms of the settlement. The terms of the settlement ashte ad ಮಾಡಿ certified corrections be effected to and certified copy be issued to the petition, to the parties. Yes.
Obliged, madam. Much obliged.
Gratefully.
115.
For the petitioner in the.
Bringing LRs of petitioner, will allow it.
In
Yes,
both
for-
cases.
Yes.
In one of the cases, respondent.
Yes, my lord. In
Any
connected
objection?
matter, no. In connected matter, even we have filed the application, madam.
For the reasons, ಎಲ್ಲ applications, IA 1 of 25, 1 of 24, 2 of restraining, ಏನಿದು?
My lord, we filed application, my lord.
ಬರೀ LRs madam. IA 1 of 25 in 115 and IA 1 of 25 in 115.1. Both for the reasons indicated in the affidavit accompanying the application and being satisfied with the same, application stand allowed. The legal representatives of the respondent,
Yes, my lord. In my case.
legal representatives of the deceased respondent, for deceased first respondent are permitted to come on record the petitioner to amend the cost title and or file an amended cost title as the case would be in the next 10 days. Yes, next.
My lord, date may be fixed. Date may be fixed in this matter, my lord.
Why, sir?
My lord, we have a
2023. All right. Yes, list on 18th.
Obliged.
Next. 18th, but 25th, list on 25th. Vacating interim order.
My lords, I have filed, I'm a life trustee. I've been
It
removed.
may be passed over,
I've
my lords, and
charged.
for the petitioner.
Pass over.
My lords, we have engaged senior counsel in this matter, my lords. He held up in court all 6, my lords.
ನಾಡಿದ್ದು ತಗೋಬೋದಾ?
Yes, please. my
Day after tomorrow in preliminary hearing.
Very good.
Please, my lords.
I'm grateful.
Sorry, my lords.
My lords, I have filed the IA for vacating.
No,
Time-
shall I take it day after tomorrow itself?
Very well, Lords.
No problem. Yes, let's day after tomorrow. Preliminary hearing alle barli. Close it. Yes.
My
Next.
lord's interim order may be extended.
That's.
117.
In this case, my lord, compromise petition filed by the party has been deferred by the trial court. In page number 189, may kindly be seen. Compromise petition came to be filed in the appeal, RA 63 of 2021. The said appeal has been
No, why
deferred.
is this in orders? Yeneno ide illi? Appeal admitted.
Although that is connected matter only to see, my lord, whether that appeal affects the compromise has to be seen. Therefore, my lord,
Non-compliance office objection raised in bringing LRs. RFL yeneno objection ಇದೆ
RFA
ಇನ್ನು?
ನಮಗೆ ಸಂಬಂಧ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅದು only to see compromise.
ಯಾರ್ದು RFA? ನೀವೇ ಹೇಳಿ ನಂಬರ್ ಕೊಟ್ಟಿದ್ ನೀವೇ.
Number ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ವಿ, but court has, my lord, directed to list along with that. That is not a subject matter. Kindly see in page number 189 annexure L.
For the appellant in the RFA, my lord.
One minute, sir.
Please.
Annexure L. Page 201 is the operating
order. I have directed. Who directed?
Predecessor of
Previous
this
bench.
Previous bench. To list along with this writ petition, only that. I have already produced a RFA copy. There, kindly see, my lord, order.
Then why will delink it?
Yes.
Delink RFA 997 of 2021. List the writ petition on Friday in preliminary hearing.
Please.
Yes. Extension of time.
118.
Yes, parole, your lordship. 302, your lordship.
Extension of time.
Parole.
Parole is.
Extension of parole, your lordship. 11 years, 8 months.
Term is already completed, my lord.
What term is completed?
Your lordship has granted the parole on.
Yes,
60
where is
days.
the order?
60 days. Annexure
60
A,
days.
Please.
Madam,
60 days. Page 6, your lordship.
on extension on the same term 60 days.
30 days.
Again offense in.
Obliged. 302, your lordship.
Yes.
30 days they are.
60 days. Finally,
Obliged.
no more
Obliged.
extensions. Yes.
119 adjourn. 120.
For the respondent,
They have filed an application for vacating interim order.
Order passed by this.
What is the interim order?
Order passed is under Order 21 Rule
Then the
54 for
execution
attachment, my lord. I have sought for stay of the attachment. And subject to depositing 15 lakh stay was granted, I have
There
deposited.
is an interim order?
Yes, my lord, there is an interim order. Subject to deposit of 15 lakhs, I, the interim order-
Deposited.
Deposited.
Lord, the only ground urged in the entire petition is that, my lord, the property value is higher and the decretal amount is lesser, my lord. That is the only ground they have alleged.
We'll see, consider. Yes. List on 25th.
Please.
Interim order subsisting will continue till the next date of hearing. Next.
Group matters. 121.
I'm appearing for petition. For the respondent, my lords. Divergent order.
In 39-1.
39
For the hearing. 3:30 ಆಗೋಯ್ತು. We'll take this on 18th, all B group matters. Interim order ಇದ್ರೆ continue ಆಗುತ್ತೆ.
Interim order.
List on 18th.
Interim order, maybe.
All. 121 to 127, list on 18th. Interim order subsisting will continue to the next date of hearing.
Further hearing. 128.
It's very short issues involved in each one of these matters.
Very short issue.
Yes, my lords, criminal petition 12267 of 23.
Regular court ಮುಂದೆ ಬರಲ್ಲ ಬೇಡವಾ?
My lords, your lordships have substantially heard the matter, my lords. I'll not take more than 10 minutes because there's nothing much, my lords, for me to. My lords, criminal petition 12267 of 23.
Day after tomorrow.
ಅಲ್ಲ ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬರಲ್ಲ.
Day after tomorrow.
Day after tomorrow ರೆಗ್ಯುಲರ್ ಕೋರ್ಟ್ ಕಳಿಸ್ಲಾ?
Please let it be before lordships, no? Because we have already concluded our arguments. They had to commence. It is at that stage.
ಕೃಷ್ಣಕುಮಾರ್ ಸಾಹೇಬ್ರ ಮುಂದೆ ಜಲ್ದಿ ಆಗುತ್ತೆ.
ಇಲ್ಲಿ ಪರವಾಗಿಲ್ಲ, ನಮ್ಮ ಮುಂದೆನೆ ಮಾಡಿ.
Day after tomorrow.
24th ಅಲ್ವಾ ಇದು?
23.
23 ಇದ? ಹಾಗಾದ್ರೆ ಹೇಳಿ. Yes, sir.
Lords, criminal petition 12267 is arising out of crime number 222 of 23. Lords, the complainant is the vendor of a property which the present petitioner as the accused is purchased.
ನೀವು ನಾಡಿದ್ದು ಕೇಳಿದ್ ಯಾಕೆ ಜಗದೀಶ್ ಸರ್?
Stampede.
ಹಾ?
Stampede case.
ಅಲ್ಲಿ ಇದೆಯಾ ಈಗ? ಆಯ್ತು, ನೀವು ನಾಡಿದ್ದು ತಗೊಂತೀವಿ.
Very well.
It's only one submission.
That is important. Do.
Only one submission.
Yes, Rajat.
In 128.1, 2 and 3, they may not have any relevance so far as the other cases are concerned. The accused is common in this case. Facts of the other cases are different. So that may kind of
Yes. Day after tomorrow.
Please, Lords.
Yes.
129.
ಜಗದೀಶ್ ನೀವು ಹೋಗಿರಿ ಹಂಗಾರೆ ಯಾವ್ದಾರು?
This one, issue of limitation.
ಯಾವ್ದು ಇದು? 129.
29.
Is covered by this judgment because the time calculation, either filing of complaint or initiation of prosecution.
No, that's order was passed in the year 2022. PCR was filed in the year 2024. But the act prescribes only 1 year, my lords.
One ನಿಮಿಷ sir. What is the offense, sir?
Lords, offense, petitioner in a capacity of revenue court has passed an order and directed the revenue department to insert as a sarkari gomala, my lords. Challenging that order, they have appealed before the DC also. Again, they have filed a PCR against me, alleging that I am passed an order favoring some individuals.
All right.
My lords, it's an appealable order. I am protected under 3 things, my lords.
Interim ಇಲ್ವಾ?
ಇದೆ.
Yes. Yes, sir.
Literally, the limitation, my lord, your lordship may see because sanction is required to prosecute these people. Sanction under the Forest Conservation Act. So same month we have processed for sanction to central government. So sanction has come, thereafter we have filed. So that all these things.
Sanction ಕೊಟ್ಟ ತಕ್ಷಣ everything is valid.
That is what the your lordship may see Sarah Matthew and section 470 also.
No, I am not on that at all. I am not on limitation. You forget limitation. Let us not get into the jugglery of limitation. Now come to the fact that it is an appealable order. Right?
They have appealed, my lords.
They have filed an appeal also.
Correct.
Where will the criminal case lie when the appeal is pending?
No, that appeal also been allowed and.
No, it was not allowed. It was remanded back.
Direct.
Remanded back for what, sir?
No,
Fresh consideration, my lords.
All right.
It was directed to execute a mutation in the name of Forest Department.
No.
In the appeal.
Yes.
Show me that order. Yes. If that is the order and he has passed contrary to that,
and in spite of
and
that,
then we will permit prosecution.
And in spite of that, even today, the RTC stands in the name of Gomala.
No.
Where is the order in appeal? ಅದನ್ನು ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ ಸಾಕು. Where is the order in appeal?
53, my lords, page 53. Last para, my lords.
One moment. Let me get into that. 53.
Last para, my lords. ವಿಭಾಗಾಧಿಕಾರಿ ಹಾಸನ ಉಪವಿಭಾಗ ಹಾಸನರವರು ಪುನಃ ಉಭಯ ಚಿತ್ರರೊಂದಿಗೂ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ಮೇಲ್ಮನವಿದಾರರ ದಾಖಲೆಯನ್ನು ವಿವರವಾಗಿ ಪರಿಶೀಲಿಸಿ 6 ತಿಂಗಳೊಳಗೆ ಆದೇಶ ಹೊರಡಿಸಲು ಆದೇಶಿಸಿದೆ.
Yes, Jagdish.
No, there is.
Where is the direction that he should enter the name of the forest department?
I'll place that.
What ಇದರಲ್ಲಿ ಇಲ್ವಾ ಅದು?
They have not produced it. I'll place that.
Produce it. Yes.
My lords, after passing of this order, I was transferred. I am not there.
No, in fact, whether
that hardly matters if you are there or not.
Still,
you are the author of the order where the deputy commissioner directs entry of the forest department is what he says.
No, that is wrong, my lords.
If it's right, then you are gone. Yes.
Supreme Court, my lord, recently also retreated.
No. If what you say is right, the petition should be dismissed.
Even then, I am protected under 77, my lords.
That we'll see.
No, all those things.
That we'll see. Yes. ನಿಮಗೆ ಯಾವತ್ತು ಮಂಡೇ ಹಾಕ್ಲಾ? ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ಲಾ? List on Tuesday.
Please.
Yes.
Submission serial number 127. Sorry, man. I was held up in.
ಇಲ್ಲ ಅದು ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ ಬಿ ಗ್ರೂಪ್ ನಾನು ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡಿ ಸೆಕ್ಷನ್ ಮಾಡಿದ್ದೀನಿ. I posted them to 18th. Don't feel sorry. ಅದು ನಾವು
ಎಂಟ್ರಿ ಮಾಡಿ ಇರ್ಲಿಲ್ಲ, ಅರ್ಜೆನ್ಸಿ ಇತ್ತು.
ಇಲ್ಲ ಅಂದ್ರೆ 18th ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಡೈರೆಕ್ಟೆಡ್ ಮೈ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಈ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಇದ್ರೆ ರೀಚ್
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ?
ಇಲ್ಲ
127 post in preliminary hearing on 18th. Yes.
130.
ಏನ್ ಬರೋದಿಲ್ಲ Mohammed Azharuddin.
For the respondent, are two, my lord.
What is this, madam?
Multiple marriages.
Huh?
Multiple gender.
Seventh
marriages.
husband. Oh, yes.
He has not come to. Even
Eighth
last
husband.
time, he has not.
Seventh, ನೀವು ಹೇಳಿ madam.
Himself. No, I don't.
7 marriages ಆಗಿದೆಯಾ?
No. One after the other.
One after the other ಎಷ್ಟಾಗಿದೆ?
4 marriages. ಒಂದೇ ಗಂಡ ಆಗಿರೋದು. ಇವನ್ ಲಾಸ್ಟ್ ಗಂಡ 6,000 rupees ಮೇಂಟೆನೆನ್ಸ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಅದು ಕೊಡ್ಲಿಕ್ಕೆ ಆಗದೆ. ಇವತ್ತಿನ 2022-11 ಅಲ್ಲೇ ಆಗಿದೆ.
ಇದು
ಅದನ್ನ ತಪ್ಪಿಸ್ಲಿಕ್ಕೆ
ಇದು fifth husband fourth husband?
This is the fourth one.
Fourth one?
Yes.
All right. First 3 ಏನಾಯ್ತು?
ಒಬ್ಬ ಬಿಟ್ಟು after death ಒಂದು ತಲಾಕ್ ಒಂದು ಡೆತ್ ಎಸ್ಕೇಪ್ ಆಗಿದೆ. ಎಲ್ಲ ತಲಾಕ್.
ಎಸ್ಕೇಪ್? ಹೌದು,
ತಲಾಕ್ ಆಗಿದೆ.
ಯಾರು ಎಸ್ಕೇಪ್ ಆಗಿದ್ದು?
ಗಂಡ ಎಸ್ಕೇಪ್ ಆಗಿದೆ.
ಗಂಡ ಎಸ್ಕೇಪ್ ಆಗಿದ್ದು.
Has nothing to do with.
From whose clutches escape ಆಗಿದ್ದು?
Overnight on.
Overnight escape ಆಗಿದ್ದು.
This comes in YouTube like this, and then her life is miserable there because of all this. It is her fate. What to do?
No. The interim order passed is habit of marrying and registering complaints against the husband. And
before notice it was husband ಬಂದಿರೋದು 498 ಅಲ್ಲಿ ಸ್ಟೇ ಕೇಳಿಕೊಂಡು.
ಹೌದು, correct.
Avoid 6,000 rupees maintenance, interim maintenance on
Allah, he has produced the photograph of all 6 husbands and
he can produce many, my lord, and Waqf board also gives marriage certificate.
ಓ, ಅದು ಬೇರೆ ಇದೆಯಾ?
ಅದನ್ನ ತಗೊಂಡು ಬಂದಿದ್ದಾರೆ ಬೇರೆ ಮಸ್ಜಿದ್ ಎಲ್ಲ. ನಾನು ಗಂಡ ಅಂತ.
ನಾನು ಗಂಡ.
This is not question of joke, my lord.
No, I am not joke here. This is the problem is that you are the fourth husband even according to you. All right. Yes. ಈಗ 498 ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಸ್ಟೇ ಆಗಿದೆ. DV Act
objections ಹಾಕಿದೀರಾ?
ಹಾಕಿದ್ದೇನೆ.
ಎಲ್ಲಿದೆ?
Filed.
Statement of objections ಇದೆಯಾ?
Filed on 27/9/24.
Correct. ಇದೆ. Yes.
Maybe
No representation behalf of the petitioner. List tomorrow. In the event the petitioner would not, there was no representation behalf of the petitioner on the last occasion.
Stay may not be extended.
Even today, there is no representation on behalf of the petitioner. In the event he would not be present on the next date, the interim order subsisting would get automatically vacated. List on Thursday. Yes. Next. Yes, Raju sir.
This is the third complaint the second respondent would lodge against.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ?
Stay ಕೊಟ್ಟಿದ್ದೀವಿ.
Yes.
ಸೊ ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಿದೆ.
ಕನೆಕ್ಟ್ ಆಗ್ಬೇಕಾ? ಏನ್ ಕನೆಕ್ಷನ್?
ಸೇಮ್ ಅಲಿಗೇಷನ್ಸ್ ಮೇಲೆನೆ ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು, ಸೇಮ್ ಪಿಟಿಷನ್.
ವೆಂಕಟೇಶ್ ಅರ್ಬಟ್ಟಿ ಹಾಕಿದಾರೆ ಅಂತ I don't know anything about. It can come along with this.
Tag this petition along with
writ petition number 6047 of 24, madam.
Yes. List them both on 16th. 16th ಅಲ್ಲ, 17th.
After 23rd, my lord, senior will not have.
ಮತ್ತೆಲ್ಲ ಹೋಗ್ತಾ ಇದ್ದಾರೆ? Yes. List on 25th.
Yes, please.
Yes. Interim order subsisting will continue to the next date of hearing. Yes, next.
132.
ಅವರೇನೋ ಟೈಮ್ ಕೇಳಿದ್ರು.
I had just only one request. I just want to bring to your lordship. It is only one document.
ಹೇಳಿ.
On page number 40.
ಅದೇ ಗೊತ್ತಲ್ಲ.
ಅದಲ್ಲ ಇನ್ನೊಂದು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಇನ್ನೊಂದು ಫೋರ್ಜರಿ ಇದೆಯಾ?
ಅಲ್ಲ, basic document itself, not my request, your lordship to kindly have a look at the compilation of all the documents which your lordship directed and he has produced. Just only one page, but I will not show.
ಯಾರು ಇಲ್ಲ, ಟೈಮ್ ಕೇಳಿದ್ರು.
ಅಲ್ಲ, ಏನಿಲ್ಲ, my only request is to direct direct the state to secure these papers. There is not every likelihood that they get further fabricated. Just not one page.
Yes, no, we'll direct that.
That's all. That's all.
What papers?
Not all the revenue papers, not which are on
the state shall secure the papers from the revenue department that are the subject matter of any of these cases. Please. And place it before the court on the next date.
Please.
ಯಾವತ್ತೋ ಬೇಕು ಅಂದ್ರೆ ಅವ್ರ ಟೈಮ್ ಇಲ್ಲ, ಅವ್ರ ಟೈಮ್ ಕೇಳಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ.
Please.
We'll take it on Tuesday.
17. Please.
ಮಂಗಳವಾರ ಆಗ್ಬೋದಾ?
Please.
That is 17.
Please.
18th.
17th ಯಾವ್ದು ಕೊಟ್ಟಿದೀವಿ ಮೇಡಮ್? ಮತ್ತೆ ಯಾವ್ದು ಎರಡು ಕೊಟ್ಟವಲ್ಲ? ಶೇಷಾದ್ರಿ ನಾಯ್ಡು.
Week commencing 23rd. Week commencing 23rd.
All right, that is better. Wait, yes. 24th.
Please.
Finally.
There is one more request. Not my client apprehends, not with reliably learned that before this order of your lordship would get executed or they go, or there is every likelihood that they tamper with those documents. let them act on the
ಈಗ immediate
immediate.
shall forthwith secure ಅಂತ ಮಾಡಿ.
Please.
Not by the next date, but shall forthwith
forthwith.
secure the entire records pertaining to the cases at hand and place it before the court. Yes. This government. ಯಾರು government ಯಾರಿದ್ದಾರೆ? Interim order will continue. Government. Madam, ಎಲ್ಲ secure everything forthwith immediately.
Please.
Yes. ಬೇರೆ ಏನು ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ ಅವ್ರು ಇದ್ರೆ
ಅದೇ ಗೊತ್ತಾಯ್ತು. ನಮಗೂ ಅಷ್ಟೇ ರಿಕ್ವೆಸ್ಟ್.
ಅಷ್ಟೇ.
Only request.
134.
130?
Yeah, 134.
133. 133 ಮೇಡಮ್.
133 ಯಾವುದು?
Sorry.
ಕರೆಕ್ಟ್ 133. ಏನಿದು?
I am representing
ಎಲ್ಲಿ
the respondent my lord in both the cases. Unfortunately my lord, it's an accident.
ನೀವು ಹಾಕಿದ್ದೀರಾ? ಸರಿ. ಕೌನ್ಸಿಲ್ ಸೋ ಅಂಡ್ ಸೋ.
ಅಲ್ಲ ಅದು KR ರಮೇಶ್ ತಾವು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಿ ಅದು.
KR ಮಧುಸೂದನ್ ಯಾರು? ಇವರು ರಮೇಶ್ ಜೂನಿಯರ್.
My lord, KR Ramesh.
One minute, sir. MN Madhusudan is said to have entered appearance in.
My lord, may make one submission. My lord, may make one submission, my lord.
ಹೇಳಿ sir.
This is the case where the
I know the
memo
case.
for
Sir.
retirement
Yes.
has been.
1 minute, sir.
Please.
Counsel MN Madhusudan is said to have entered appearance in place of Ramesh KR. Registry to delete the name of Ramesh KR and retain the name of MN Madhusudan. List day after tomorrow. I'll vacate the interim order day after tomorrow. Yes. All suppression.
My lord.
Yes. Next.
134.
The petitioner.
Yes, sir.
But there are a few instances that I
CPS.
would no man.
They are sought not for interesting the investigation.
So CBI. Yes.
But I'm just filing.
But who is the contesting? Contesting ಏನಿಲ್ಲ ಇದರಲ್ಲಿ ಕೊಡಿ.
State not.
Nobody need be heard. State ಎಲ್ಲಪ್ಪ ಇಲ್ಲರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ತಾರೆ.
But I'm just placing.
State ಇಲ್ಲದೆ ನಾನು CBI ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಲ್ಲ.
Grateful, my lords. The reason why I'm just
Invalid.
placing.
You may say anything, sir, unless Jagdish is heard, we will not do it.
This is the fourth adjournment, my lords. I understand, my lords. I went through the Chandrakala order as well. Lords, I'm only placing reliance on whatever is stated in this synopsis, my lords, and I've added a few grounds there. Yes, my lords. My lord, what I would like to point out, your lordship. My lords, idalli enagutte andre first time in my life, my lords, the accused in a 302 case is not taken in police custody.
No, the most shocking thing about this is
Please.
offense is 302. The police conduct investigation for 302. File charge sheet for 323.
Lords, on the basis.
302 in the 323. And you see the murder is like this.
My lord, on the
And
basis.
the police file charge sheet for 323.
Surprising.
Uncognizable offense. 302 is reduced to 323. What can you expect from the state police?
Surprisingly, my lords, they rely on doctor's certificates. My lord, they come and file a requisition on 19-1 before the court. My lord, on the basis of a medical certificate that is dated 31-23. Lord, they have collected this certificate when? On 1-1-23. My lord, it is dated 31. How did you collect it on 1-1?
ಪಾಯ್ಸನ್ ತಾನೇ ಇದು.
My lord, poison. ಇವಾಗ ಏನಂತ ಮಾಡಿದ್ದಾರೆ ಸ್ಟೋರಿನ ಅಂದ್ರೆ ಪಾಯ್ಸನ್ ಕುಡಿದ್ಬಿಟ್ಟು ತಟ್ಟಾಡ್ಕೊಂಡು ಹೋದ್ರಂತೆ, ಮೆಟ್ಲಿಂದ ಬಿದ್ದು ತಲೆ ಹೊಡ್ಕೊಂಡ್ರಂತೆ.
ಅಲ್ಲ, the forensic, sorry, this postmortem is poison is consumed later.
Yes, my lord. My lord, that point is clear.
Poison is induced later, rather
Induced
consumed.
later, and it has not gone to the systemic circulation of the body.
ಸತ್ ಮೇಲೆ ಪಾಯ್ಸನ್ ಇಂಡ್ಯೂಸ್ ಅಲಿಗೇಷನ್ ಇರೋದು. ಸತ್ ಮೇಲೆ ಪಾಯ್ಸನ್ ಇಂಡ್ಯೂಸ್ ಮಾಡಿ they have turned the body into this shape, this style. And investigation is conducted. Offense, FIR registered for 302. But investigation ಆದ್ಮೇಲೆ ಇದೆಲ್ಲ ಇದ್ರೂನು 323. Plain simple assault. ಸುಮ್ಮನೆ ಸ್ಕ್ರಾಚ್ ಮಾಡಿದ್ದಾರೆ.
Shocking aspect of this investigation is that the initial charge sheet, my lord, other than the 5 eyewitnesses who have gone before the sessions court and claimed that I have never given this statement, other than their statements, my lord, all
and based on those statements they have rendered this.
My lord, they have done that, but they have gone before the sessions court, even in the bail order, as well as in the other instances, very clearly stated, these are not my statements. Subsequent to that, my lords, they record other statements of the relatives of the accused person. My lord, for what?
No, his
To create an
allegation,
alibi.
Prasanna Kumar, his allegation is he's killed. It's a case of murder. After killing, they've induced poison into his body because the postmortem says that poison is induced later. Investigation is done and reduced to 323, as I said. Is this not a fit case to send it? CID also says the same thing.
And absolutely no investigation, my lords, with respect to the place where the entire incident is occurred, as according to them, to the place where the body is found, that is 300 meters away.
And his body is not like this. It is after inducing poison.
Not just, not because of the previous orders.
That is why I don't take.
They're only placing, our statement, but not.
And
I've already
you
conveyed.
also should have filed your objections ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೀವೇನು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಲ್ಲ. ಕೊಟ್ರೆ ಮಾಡ್ತೀವಿ ಇಲ್ಲದ್ರೆ ಇಲ್ಲ ಅನ್ಬಿಡ್ತೀರಾ. ನಾವು ಕೊಟ್ಟಿದೀವಿ ಅಂದ್ರೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ.
But in these cases, not where our conscience itself not displayed.
This is what
we don't
really
generally
shocks the
object.
conscience of the court, the way the investigation is done. Murder case na reduced to scratching, back scratching
But in
allegation
fact-
of assault.
In fact, not I have discussed about this issue, not with the branch head. He also says, how can this be?
No, this is shocking.
My lord, the most startling of facts in this, my lord. My lord, a 302 investigation creating an alibi for accused persons, my lord. And the
See,
same
today
statement.
then a stampede case ಇದೆ ಅಂತ Jagdish is gone.
Understand.
I'll take it tomorrow.
My lord, this is not Jagdish sir who's appearing in this.
Who appears then?
Not another SPP, because this is GM police, it's Mr. Hegde who's appearing.
Spurti Hegde had appeared on the last.
ಯಾರು appear ಆಗಿದ್ರು?
Spurti Hegde.
Where is he then? Where is Spurti ಇವತ್ತು ಬಂದಿಲ್ವಾ?
He appeared on the last date of hearing, took
I
time.
know. Morning itself he has come or gone?
But anyway,
ಬೆಳಗ್ಗೆ ಬಂದಿದ್ರಾ ಇಲ್ಲ ಅದೇ ಹೇಳ್ಬಿಡಿ ಸರ್. ಬಂದಿದ್ರಾ? ಅಷ್ಟು ಈಗ ಎಲ್ಲಿದ್ದಾರೆ? ನಾಳೆ ಬರಕ್ಕೆ ಹೇಳಿ. ನಾಳೆ take it at 4 o'clock ಬರಕ್ಕೆ.
Grateful.
Yes. Let's tomorrow at 4 p.m. for further hearing. Further hearing later, sorry. Yes. ಅವರು ತಗೊಳ್ಳಿ party in person.
Fast or not?
Lords,
Ah,
for
yes,
the
sir.
petitioner, my lords. We are challenging Annexure A, my lords, which is in page number 12. It is just a merry letter which is sent from the authority, my lords.
You are challenging annexure A na?
A, my lords.
ಏನದು?
It is
Prepare
just,
pension papers. All right. Why are you challenging this?
my lords, writ petition has been dismissed, my lords.
Writ petition is dismissed.
Outside.
Which is the writ petition?
Writ
Page,
petition,
order.
we are not filed the writ.
ಕೊಡಿ ಅದು order ಕೊಡಿ.
There is the EAT order as well as the learner single judge order.
1 minute.
No, we have challenged the writ petition.
Just 1 moment. This is EAT order. What does it direct? Dismissal is set aside. Superintendent, appellant notion, the original post and back pages contribute to service counsel. A writ petition is filed against that. What happened to the writ petition?
It has upheld. Now we have filed writ appeal, my lords. In the meantime, execution has been proceeded against.
Writ appeal ಏನಾಗಿದೆ ಸರ್?
My lords, ಅದರಲ್ಲಿ ಆಲ್ಮೋಸ್ಟ್ ನ್ಯೂಮರಸ್ annexures ಕನ್ನಡದಲ್ಲಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲ ಅದನ್ನ ಟೈಪಿಂಗ್ ಕೊಟ್ಟಿದ್ದೀವಿ, ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು.
ಯಾವಾಗ ಹಾಕಿದ್ದೀರಾ ಸರ್?
ಫೆಬ್ರವರಿ, my lords.
ಫೆಬ್ರವರಿ. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಈಗ ಇದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
It is just a merry letter ಅಂತ ಸ್ವಾಮಿ. It is not any adjudicative order ಅಂತ we have challenged ಅಷ್ಟೇ.
No problem. Yes. ಅಷ್ಟೇನಾ? The petitioner is before this court. The petitioner, the judgment debtor, is before this court calling in question a communication dated 16/4/2025 by which the concerned court directs the directs the petitioner institution to prepare the pension papers and keep it ready. The learned counsel, heard so and so. The petitioner is an educational institution in which the respondent was, what were you working as? Assistant professor.
Associate professor.
Associate professor. The petitioner, owing to certain omissions and commissions, had been dismissed from service. The dismissal of which was called in question by the respondent in MA 3 of 2017. The Educational Appellate Tribunal, by its order dated 30th September 2023, sets aside the order of dismissal and passes the following order. The said order is tossed, TOSSCD, tossed before this court in writ petition 5076 of 2024. The coordinate bench, by its order dated 19th December 2024, rejects the challenge by the petitioner herein and affirms the order passed by the Educational Appellate Tribunal. Therefore, the petitioner becomes entitled to the relief that is granted by the Educational Appellate Tribunal, which was continuity of service and all other consequential benefits, as the respondent had retired from service by then on attaining the age of superannuation. In the light of the order not being complied, the respondent has instituted execution proceedings. Execution proceedings in one nimsham. Where is the order? Where is the order? Impugned order yavadu? Annexure A na impugned order?
Annexure D.
Annexure D.
1 minute. Page
26. There is no direction.
Sorry. Respondent institution. Sorry. The execution petition is preferred by the respondent in execution 573 of 2023, seeking to execute the decree passed by the Educational Appellate Tribunal quoted supra. During the concerned court, by the order impugned, directs the pension papers to be prepared and sent to the judgment debtor number 2. Pension papers to be prepared. It is this order that is called in question by the petitioner. The learned counsel for the petitioner would, however, contend that a writ appeal is pending against the order passed by the coordinate bench in writ petition 5076 of 2024. Therefore, the proceedings in execution must be arrested till the division bench would hear the writ appeal. The submission is noted only to be rejected. The order passed is the order of the concerned court, i.e. the Educational Appellate Tribunal, is 30th September 2023. The learned single judge affirms the said order by his order dated 19th December 2024. If the petitioner has taken 6 months to get the writ appeal posted before the court, the petitioner has done it to his peril. To his peril, since there is no interim order granted, there is no stay granted of the order of the learned single judge before the division bench as on today. There is no warrant to stay the proceedings in execution quoted supra. In that light, finding no merit in the petition stands rejected. Yes. Next.
13th executing court ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ 13th ಡೇಟ್ ಇದೆ.
ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದೀನಿ. ಅಲ್ಲಿ ಏನು ಮಾಡಬೇಕು ಮಾಡಿ ಅಷ್ಟೇ.
ಬೇಗ ಸಿಗುತ್ತಾ ಆರ್ಡರ್ಸ್ ಅಂತ?
ಆರ್ಡರ್ ಸಿಗುತ್ತೆ 13th ಗಲ್ವ ಇರೋದು.
ಥ್ಯಾಂಕ್ ಯು. ಲೆಟ್ಸ್ ಹೋಗು.
First over, yes, Bani sir. Order 6, order 26 rule 9 nimde.
6 is not
56 ಅಲ್ಲ ಅದು, sorry.
71.
56 ಆಯ್ತು ಮೇಡಮ್. 56 is not passed over at all. ಆಗಿದೆಯಾ? ಯಾವ್ದು 56 ಯಾರು? ಓ ಅದು day after tomorrow. To pass an order, day after tomorrow.
Please, my lord. My lords, may kindly take my application. I'll just take my lords very, very briefly as far as the facts are concerned, my lord. So, suit for declaration and my lord, mandatory injunction to demolish the encroachment insofar as my property is concerned, my lord. My lord, my predecessor in title purchases the property in 1980. Now, this property was purchased based on a Hissa Tippani of the year 1980. Now, I purchased the property. My predecessor in title was my brother itself. I purchased the property in 1994. Not impugned orders at annexure A, 14, page 29, my lord. The order sheet is there, my lord. My lords may kindly come to the operative portions at page 39. Only reasoning given is that, my lord, application is rejected because it amounts to collecting of evidence. My lord, that is covered by the quadrant bench of this honorable court, saying that merely because you say that it's for collecting of evidence, I finished my evidence. There's no point of, there's no concept of me trying to collect anything now.
First, where is the impugned order?
Please, either.
Page.
39, my lord. 39, last paragraph, my lords may kindly see.
That's at page 37.
The operative portions are 39.
Even reason ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
Reason, my lord, is
Not to collect evidence, and what kind of evidence?
That's correct.
What is that he wants to collect? What is that the court wants to say?
Better, but I can only explain to one, your lordship, para 10, if your lordships read again.
Yes,
The same thing. What has happened here is, there is an earlier suit, my lord, filed by the same plaintiff against the same defendant. There, my lord, similar application was filed. There is a report, my lord, which is marked in that suit, my lord. There, my lord, suit is dismissed. Appeal is dismissed. This is the second round of litigation.
No, that
Now
was
that
a suit for
appeal is-
injunction. Ugly, but I just want to clarify it's a suit for injunction. Please,
I have not even said order to rule,
Yes,
so I
wait,
am not
sir,
objecting
wait,
on that.
yes.
Now that, my lord, that report, my lord, by the earlier court commissioner, and my lord, his evidence, which is evidence adduced before the court in the earlier suit, my lord, has been marked in evidence before this honorable, this suit, my lord. I have confronted it.
No, that report is in your favor.
No, yes, it is in our favor. Now, he had asked a specific question. If your lordship will just see that one report for a minute. My lord. In his earlier application, the earlier application is on record. I'll just take your lordship to that within a second. The memo of instruction at page 139. Oh, sorry, this is the answer. This is memo of instruction. Yes, please see page 134.
134, sir.
134.
134. When is the next date?
16th, my lord.
But actually,
Today, my lord.
it was
today.
Adjourned to 16th, is it?
Adjourned to 16th, but for them, my lord, because my stage is already closed. Because, my lord, if I were to go ahead, it becomes infructuous.
What has happened is he was supposed to argue.
Yes.
He did not argue. So his argument is taken as nil. No, he'll have to recall that order.
For him also, it is last chance.
No,
So
no,
both of us are in the same boat right now. In fact,
Evidence
today,
ಎಲ್ಲ
my lord,
ಮುಗ್ದೋಗಿದೆ.
today, in fact, it was not to be posted for
ಏನಾರು
judgment.
ಹೇಳ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ,
ಏನು ಹೇಳ್ದೆ ಅವ್ರು?
Lord, that para 10, after your lordship understand the fact.
It is not for this court or the councils to, develop inference on this laconic order. There should be something.
No, let me just read 10 again, my lord.
And not 6 months, my lord, for this order. With all due respect. 6 months.
No, I'm sorry.
Order
20
ಬರೆಯಕ್ಕ.
Months, my lord, please. 6 months. 39/2024 it's posted for orders, my lord. 14/3/2025 takes.
On 26/9.
On 26/9. And my lord, it was taken up in a tearing hurry on a day-to-day basis.
I have litigating since 2004. It's not my.
No, I'm not. Sir,
This is on the court.
this is on the order, not on.
No, 2022 he files it. Please see, this
tearing-
application is filed in 2022.
ಅಲ್ಲಲ್ಲ ಅವರು ಟೇರಿಂಗ್ ಹರಿ ಅಂತ ಹೇಳಿದ್ದು ನಿಮಗೆ ಟೇರಿಂಗ್ ವರಿ ಆಗ್ಬೇಕಾಗಿತ್ತು.
ನಮಗೆ ವರಿ ಆಗಿದೆ, that's the problem. Now please see, my lord, para 10, what he says. The plaintiff filed the suit against defendant seeking relief of declaration, mandatory injunction, vacant possession of eastern side. On perusal of P19, which shows suit number so-and-so is filed before the so-and-so court by present plaintiff against defendant number 1 and 2, which is dismissed. This is the earlier suit, my lord. This is the earlier suit.
What was the suit for?
That was a suit for bare injunction.
Injunction is granted, they denied.
No, denied. But I want to show, my lord, what was his specific instruction.
What is this
Even-
suit for?
This is for declaration. After dismissal of that suit, this suit is not maintainable according
No,
to me, but
Injunction is refused.
injunction is refused.
That is, refusal has become final.
Final. This suit, after dismissal of that suit is not maintainable. Order to rule 2 will apply. But
Then
I'm not on
do
that
that.
point. I'm not on
Yes.
that point. I'm only showing, my lord. Now, let's see what is his requirement in this application and what was his requirement in the earlier application. If your lordship will just give me 1 minute and go back to page 134 for a moment.
We'll continue tomorrow.
Please, my lord, no. If my lord's going to, in fact, it's on
16th ಅಲ್ಲ ಬೇರೆ ಅದು. Day after
16th.
tomorrow will continue.
If,
Day after tomorrow in preliminary hearing. Yes.
please.
ಅದೊಂದೇನಾ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ? 233 ತಗೊಂಡ್ಬಿಟ್ಟು. I might.
Objection.
Yes, day after tomorrow. Very good.
33 matters. Preliminary hearing, MD Raghunath.
ಎಷ್ಟಿದೆ? Raghunath.
Please, my lord. Lord, I file a suit for bare injunction. I am a tenant in respect of ground floor of the property. My original owner was one Mr. Syed Mansoor Ahmad. He transfers the property by a sale in favor of Chaudhry Abdul Rahim. There was some dispute between those two owners. I had to file a suit because they tried to dispossess me.
You are in
by
possession.
demolition. I'm in possession of ground
39,
floor.
1 and 2 is rejected or what?
Not rejected, my lord.
But
Emergent
notice
notice is issued.
All right, is the respondent represented today?
Not yet, please. Fresh matter.
ಅಲ್ಲಪ್ಪ ಅಲ್ಲಿ
ಇಲ್ಲ ಇಲ್ಲ ಅದು fresh matter.
ಅದು ಫ್ರೆಶ್ ಅಂದ್ರೆ ಯಾವಾಗ ಆಗಿದ್ದು?
Just file, please.
5 minutes?
No, just
5 days. Yes.
Lord, it was filed on 35.
Emergent notice to the respondent petition. Respondent shall be served by way of hand summons as well. List the matter on 20th. There shall be an interim order. Or ಏನ್ ಕೇಳಿದಿರ ನೀವು?
Not to dispossess me, not to interfere with my peace.
ಎಲ್ಲಿದೆ interim order?
Please, there is no interim order.
ಮತ್ತೆ?
That is where I am, Lord, I am the plaintiff. I did not get an
Where is
order.
the application?
Lord, application before the
PI
court.
is not very emergent notice ಆಗಿದೆ.
ಅದನ್ನೇ challenge ಮಾಡಿ.
ಅದಕ್ಕೆ ಇಲ್ಲಿ ಕೇಳಬೇಕಾಗಿಲ್ವಾ?
ಕೇಳಿದ್ದೀನಿ, interim order.
ಎಲ್ಲಿ ಅದನ್ನೇ ಕೇಳಿದ್ದು ಎಲ್ಲಿದೆ?
Interim order in the, I'm sorry, in the petition, my lord, kindly come to page 5, my lord. Restraining respondent from interfering with.
That's all I asked. Interim order is spread for till the next date of hearing.
Public.
Next.
Bill number 2, Shri Pradeep Naik ke.
Is the defendant's petition. The respondent filed a suit for ejectment. I filed an application for seeking amendment of return statement, which came to be allowed. Allowed on 28/4/25.
ಸರಿ ಈಗ ಏನಾಗಿದೆ?
ಅದು 4 ದಿನ ಟೈಮ್ ಕೊಟ್ರು. ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಿಲ್ಲ ಅಂತ ರೀಕಾಲ್ ಮಾಡಿಬಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್.
The emergent notice to the respondent petitioner to serve on the Andhra Pradesh.
ಅವ್ರದ್ದು ಇರೋದಲ್ಲ ಕೌನ್ಸಿಲ್.
Petitioner is
residing in
directed to serve on the counsel who represented the respondent in the trial proceedings. The counsel for the petitioner submits that his application seeking amendment of the written statement under Order 6 Rule 17 is allowed by the concerned court in terms of its order dated 22/4/2025. The matter was adjourned to 29/4/2025 on the score that the amendment is not carried out despite passage of 4 days. The order is recalled. The order on the face of it is erroneous. Therefore, there shall be an interim order of ಇದೇನು ನಾನು ಸೆಟ್ ಅಸೈಡ್ ಮಾಡಿ ಕಳಿಸಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
ನೆಕ್ಸ್ಟ್
ಅಮೆಂಡೆಡ್ ಪೆಟಿಷನ್ ಅಮೆಂಡೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವಾಗ ಹಾಕ್ತೀರಾ ಸರ್?
11th ಇದೆ ಸುಮ್ಮನೆ 11th ಗೆ.
ಅವತ್ತು ಹಾಕ್ತೀರಾ?
ಮೈ ಪಾರ್ಟಿ ಇಸ್ ನಾಟ್ ಇನ್ ಸ್ಟೇಷನ್.
ಇದು ಹಂಗಾರೆ ಸ್ಟೇ ಕೊಡಲ್ಲ.
ಅವತ್ತು ಹಾಕ್ತಾರೆ.
11th ಹಾಕ್ತೀರಾ? The learned counsel for the petitioner submits that petitioner submits the written statement, amended written statement is ready and would be filed on the 11th.
11/6.
On the 11/6, on the 11th before the concerned court. List this matter on 12th. Please. Yes. Our file ಮಾಡಿ.
Sorry, adjourn matter can I ask for hand delivery?
Let's see. Put in order. Yes, next.
May I seek, court should not proceed. 11th ಫೈಲ್ ಮಾಡಿದ್ರೆ ದಿ ಆಪರ್ಚುನಿಟಿ ಟು ಬಿ
11th ಫೈಲ್
ಈಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ ಹೋಗ್ತಿದೆ.
ಫೈಲ್ ಮಾಡಿ ಅನ್ಬಿಟ್ಟು ನಾಟ್ ಟು ಪ್ರೊಸೀಡ್ ಅಂತ ತಪ್ಪಾಗಲ್ವಾ? ಲೆಟ್ಸ್ ಸಿ. ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ. ನೆಕ್ಸ್ಟ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
3.
For the petitioner's matter, my lord. The plaintiff filed an application under Article 26 Rule 10A of CPC sought for a scientific investigation.
ಸೈಂಟಿಫಿಕ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಯಾವ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಸಿಗ್ನೇಚರ್ ಇದೆ ಸರ್?
DD ಹಿಂದ್ಗಡೆ ಡಿಸ್ಪ್ಯೂಟರ್ ಸಿಗ್ನೇಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ. DD
ಡಿಡಿಲಿ ಸಿಗ್ನೇಚರ್ ಡಿಸ್ಪ್ಯೂಟ್.
DD ಹಿಂದ್ಗಡೆ lordships kindly see page number 95. His application a moment.
Who filed the application, sir?
The plaintiff has filed an application. He has executed a
You are
sale.
the defendants.
I am the defendant, one among the owner of the property. I am also executed a sale deed.
The learned counsel, the petitioner defendants are before this court calling in question an order passed under Order 26 Rule 10A directing by which the concerned court directs a reference of a demand draft to consider verify the signature on the back side of the demand draft. Since it is a demand draft, there could be no question of sending it for further scientific examination prima facie. Therefore, there shall be an interim order of stay as prayed for till the next date of hearing. The petitioner shall serve on the counsel representing the plaintiff respondent number 1 before the concerned court and file an acknowledgement. List the matter on 27th. Yes, next.
Number 4. Jagdisha Keech.
For the petitioner, my lord. Yeah, the respondent number 2, I'm the guarantor, my lord. Respondent number 2 has bought the cheat amount of 35 lakhs from the respondent number 1, my lord.
ಅದೇ ಅವ್ರದೇ ಬಾರೋರ್ದೇ ಪ್ರಾಪರ್ಟೀಸ್ ಬೇಕಾದಷ್ಟಿದೆ.
ಬಾರೋರ್ ಪ್ರಾಪರ್ಟೀಸ್ ಇದೆ, my lord. ತುಂಬಾ ಇದೆ.
ತುಂಬಾ ಇದೆಯಾ?
It's worth more than the claimed amount, my lord. It's worth claimed more than
What's the order that you challenge, madam?
I'm challenging the order of the trial court, which states that the issue sale proclamation against JDR number 3. I am the JDR number 3, my lord. Pertaining to the property bearing survey number 77 of
Petitioner shall serve on the counsel who represents.
25 gunta spot.
Shall serve on the counsel who represent the respondent. You suffered a decree already.
Yes, my lord.
You were also a defendant
That
there.
one property is
You are
already-
also a defendant there.
Yes, my lord. But,
Then
my lord, one property is already been sold, my lord, which is for the 26 lakh, 26.5
anyway, you serve on
lakh.
this counsel.
And my
You
lord,
serve on
tomorrow is
the
sale.
decree holders counsel. Yes.
My lord, tomorrow is a sale, spot sale is
1 minute. The petitioner shall serve on the counsel for the first respondent, the decree holder, before the concerned court. The spot sale that is slated to be held tomorrow shall be deferred till the next date of hearing. List on next Monday in preliminary hearing. In the event the petitioner does not make efforts to serve on the respondent, the interim order would stand vacated automatically. Yes, next. Question, madam.
Subjection, my lord. Serial number 44, my lord. Copy subjection is only not stitched properly ಅಂತ ಇದೆ. List number
44
2.
ಅಲ್ಲ.
List number 2.
Second list.
ಹೌದು.
ಎಲ್ಲ ಆರ್ಡರ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ ಅದು ಅರ್ಜೆಂಟ್ 15 ಗೆ
ಮಾಡಿ.
ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಅಲ್ಲ ಸ್ಟಿಚ್ ಮಾಡೈತೆ.
Number 125, my lord.
ಇವೆಲ್ಲ ಸ್ಮಾಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನಕ್ಕೆ ಬಿಡ್ತೀರಾ?
ಅಲ್ಲ
Irresponsibility.
ಕರೆಕ್ಟ್ ಆಗಿ ಸ್ಟಿಚ್ ಮಾಡಿದೀವಿ.
Serial number 125, my lord.
Day after tomorrow, my lord.
In the commercial court,
appointment of commissioner.
commercial court
ಇರ್ಲಿ
suit
ಪರವಾಗಿಲ್ಲ. Yes.
suit is
ಕೆಳಗೆ
posted
move
on,
ಮಾಡಿ sir.
commercial court suit is posted on 12th. May be
ಯಾವ್ದು
heard
madam?
on
Serial
Wednesday.
number
125, my lord.
125.
125.
B group.
B group.
My lords, it's only posted for production of a document. It's an order
So
was.
it will come on 18th. madam.
My lord,
Trial court
Take
matter is
adjournment
posted
there,
on
yes.
12th.
Court will not pass any order, don't worry. Yes.
My lords, I moved a matter for 230, my lords. It's numbered, but the file has not reached. My lords, may I,
Give your
WP
file.
16473, my lords.
Give your file, sir.
Yes, my lords.
previous order hand delivery. May I seek for hand delivery?
Madam, ಒಂದು 3-4 ಕ್ಯಾಂಡಲ್ ಆಗುತ್ತೆ.
Hand delivery.
What's the matter? Urgency.
My lords, delivery warrant is issued on 4/6/2025 and I have filed an SLP. I have filed order 21 rule 26, which is not considered, my lords. Today the matter is listed on an application for grant of police protection to break open the lock, my lords. Whereas my SLP is not listed on account of a circular by Supreme Court where it says
Urgent matters matra.
matra anta. And specifically execution related matters are specified as not urgent matters.
All right.
My lords, caveat is also there, my lords. I have served the caveat and presently the trial court has passed over the matter and is waiting for appropriate orders from this court, my lords.
You tell the trial court to defer its proceedings. I will pass an order.
Grateful, my lords.
The ಕೇವಿಟ್ ಇದೆ ಅಲ್ವಾ?
KVT, the my lords, I have served the KVAtor also, and they are informed, and they was.
2:30 ಮೂವ್ ಮಾಡಿದ್ರೆ ಕೇವಿಯೇಟರ್ ನೀಡ್ ನಾಟ್ ಬಿ ಪ್ರೆಸೆಂಟ್. List the matter day after tomorrow in preliminary hearing. The concerned court shall defer its proceedings subject to further orders at the hands of this court. ನಂಬರ್ ಆಗಿದೆ ಮೇಡಮ್ ನೋಡ್ಕೊಳ್ಳಿ.
16473.
ನಂಬರ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನೋ ಆರ್ಡರ್.
My lords, I have the number. Just
ಅದಲ್ಲಪ್ಪ ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ. Just check madam.
I'll provide the
Because
number.
it's passed over there, I took it. Anyway, day after tomorrow in preliminary hearing.
Great.
My lord, serial number 107, my lords, it has been posted for Wednesday. We have slight inconvenience on Wednesday, my lords. It can-
18th.
It can be on Thursday, my lord, this Thursday.
No, Wednesday or Friday. Friday is a half day, so Wednesday. You make a mention on Wednesday.
Sir, second.
ಬೆಳಿಗ್ಗೆ ಹೇಳಿದ್ನಲ್ಲ, warrant ಇದು.
Hello.
Last moment, you should.
Madam, video is